Allahu Akbar. Ya Allah, कल कैसे आसानी से जोड़ दूँ. List one.
Two matters end of list.
Why?
Not the matter pertaining to Pondicherry vehicle, not other transport authority.
Tomorrow.
Please.
One matter, your last.
Matter for tomorrow.
Tomorrow kodi alla.
2:30, my lord.
2:30 wait. Tomorrow della ಕೊಟ್ಬಿಡಿ. Tomorrow.
2:30. My lord.
Why? Why? Huh? Cancelled. No problem. Tomorrow. Why? Huh? Day after yesterday? What is day after yesterday? Day before yesterday. Yes, sir. What is this? Huh? Banka. Surface I want.
My lord. My lord.
For shifting of the bank. 2:30 ಯಾಕೆ ನಾಳೆ ಬರಲಿ.
My lord. 2:30.
Pending matter, you tomorrow it will come. Yes, give it.
My lord. 2:30, my lord.
Why?
The respondent, by violating the interim order by this honorable court,
Violating interim order.
has passed some adverse order against the interest of the petitioner committee, Your Honor.
Tomorrow.
2:30, my lord. The respondent is going to issue a appointment order, my lord. I am the eligible candidate. I obtained a highest marks, my lord. Anganwadi workers. Alle politics is.
2:30.
Please.
GMC.
My lord, one submission.
ಕೊಡಿ.
Let's mandamus is there Monday.
13% na.
13%. Monday.
Tender matter, my lord. Lordship has passed the order for subject to disposal of petition, my lord. 5% and 95% vehicle.
Sorry?
5% of the owner.
ಅದು 2:30 ಯಾಕೆ ಸರ್?
Today is the last day, my lord.
For what, sir?
For applying the tender, my lord. My lord, in Bangalore bench, my lord, the passed the order, my lord, and so far in that petition, my lord, for permission is given, my lord.
Give it. We'll give permission. Give
My
it.
lord, for 2:30, my lord, for end of the list, externment order, my lord, the petitioner is 50.
Externment ನಾಳೆ. Let the AGA seek instructions ನಾಳೆ. Pending
My
matter.
lord, ಒಂದು small submission ಇದೆ.
2:30 ಹೆಂಗ್ ಮೂವ್ ಮಾಡ್ತೀರಾ ನೀವು? It's all right. Pending ಮಾಡಿ 2:30 ಹೆಂಗ್ ಮೂವ್ ಮಾಡ್ತೀರಾ? ನಾಳೆ ಕೊಡಿ. Tomorrow.
One tender matter, lordship. I am for the respondent.
Pending
lordship.
matter.
Pending matter.
Tomorrow.
Lords, one matter for 2:30, fresh matter.
ಆಗಿದೆ ಸ್ವಾಮಿ ಅಂದ್ರೆ non-compliance.
ಏನಾರು ಆಗಿರ್ಲಿ ನಾಳೆನೆ. Pending matter ನಾಳೆ.
ಪೋಸ್ಟ್ ಆಗ್ತಿದೆ ಸ್ವಾಮಿ ಅದಕ್ಕೆ.
ನಾಳೆ.
Please.
Lords, one matter for 2:30, fresh matter. This is pertaining to the Bagalkot Bar Association disqualification of the
ನಿನ್ನೆ ಸ್ಟೇ
president.
ಮಾಡಿದ್ದೀನಲ್ಲ.
ಅದು ಇನ್ನೊಂದು petition ಉಳಿದಿದೆ, ಅದು ಬಂದಿಲ್ಲ.
2:30.
2:30.
My lord, ಒಂದು submission ಇದೆ, my lord. List 1, serial number 42, we will withdraw the case, my lord.
Thank you, sir. Yes.
My lord, may I make a mention, my lord?
So much disposed as withdrawn.
My lord, may I make a mention, my lord?
Yes, sir.
My lord, this
Yes,
is a
Nitin,
pending matter for, my lord, I'm in a pending matter, I'm moving a memo. The urgency is that it's a service matter. A batch of officers, assistant engineers working in ESCOMs have been kept out of the 371J advantage, my lords, the Hyderabad Karnataka reservation.
Right.
There is an interim order. Despite that, they are going ahead and promotions are likely to happen. If it can be had on 4th November, my lords.
Oh, it will definitely be had. Give it, sir.
Yeah, great.
On submission, my lord, serial number 100. Parties have entered compromise and all of them are present. I may permitted to, my lord, make a request around 11:30 or 12 minutes once.
Brunch ಹೋಗ್ಬೇಕಾ ಎಲ್ಲರೂ?
So that, my lord, we can relieve them.
We'll relieve them at lunch, not
Please.
brunch. Yes.
Great.
1:30.
Yes.
My lord, list 1, serial 42, withdraw ಮಾಡಬೇಕಿತ್ತು.
ಆಯ್ತು, withdrawn, sir.
Okay, sir, noted, my lord, noted.
Okay, yes. All the case.
Rule number 1, Abhishek L. Khalid,
Last time order comply ಆಗಿದೆಯಾ ಕೊಟ್ಟಿದ್ದಾರಾ?
No, my lords. My lords
Yes,
are
sir.
directed to
Today
deposit.
interest, cost, everything will come.
Lords, in this
I had already passed an order.
Allah, I would like to, my lords,
Yes, sir.
rules. My lords, rule 7. My lords,
Rule 7 of what,
ಇಲ್ಲ,
sir?
376.
ಇದು ತಗೊಳ್ಳಿ.
KCCR, my lords, KCCR.
KCCR ಅಲ್ಲ, KCSR. KCSR.
Sorry, KCSR.
Mike.
376-7, my lords.
Ah.
Your lordship may kindly peruse. A retired government servant against whom departmental inquiry or judicial proceeding is pending shall not be allowed the benefit of commutation of pension till such time he is sanctioned final pension after the conclusion of the inquiry or proceeding as the case may be. In such case, the declaration or deemed declaration shall be considered after the conclusion of the inquiry or proceeding and commuted value as admissible from the date of commencement of the pension shall be authorized by the accountant general. That is, my interpretation is this, my lords, in this. But the commencement of pension starts from the date of, my lords, his retirement.
Correct.
And, my lords, he retired, my lords, in the year 2017. And apart from that, my lords, sub-rule 14 may kindly be seen, my lords. Where a retired government servant has commuted a portion of the pension, the portion of his commuted pension shall be restored to him from the first day of month following the expiry of a period of 15 years from the date of commutation. That is, my lords, if he attains, my lords, superannuation and if he retires, my lords, at the age of 60, that before 75 years, the entire, my lords, commutation amount has to be restored to him. That is what.
What an interpretation. It will defeat. ಅಷ್ಟ್ರಲ್ಲಿ ಹೋಗ್ಬಿಟ್ರೆ ಅವರು 65 ಹೋಗ್ಬಿಡ್ತಾರೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಅವರು
ಹೋಗ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ? 75 years ವರ್ಗು ನೀವು ಕಾಡ್ಬೇಕು ಅಂತ
75
65 ಗೆ somebody passes
65 years ಹೋದ್ರೆ ಅದನ್ನ ನಾವು ರಿಕವರಿ ಮಾಡಕ್ ಬರಲ್ಲ. We can't recover it from the LRs.
ಆಮೇಲೆ
ಅಲ್ಲ, that is the
correct, sir. Anything else, sir?
ಅಲ್ಲ, only that submission, madam.
Anything else, madam?
Therefore, madam, this order has
The
been passed.
petitioner is before this court calling in question an order dated 14/8/2024 by which the claim of the petitioner for commutation of pension is rejected and seeks a consequential mandamus for disbursement of full commuted value of pension with effect from the date of his retirement. Heard the learned counsel appearing for the petition Abhishek Kallid, Shri Sharanabasava, representing Nivyarga Sharanabasavare,
That's
Hubli
right.
Dharwad Municipal
2
Corporation.
and 3. Yes.
Respondents 2 and 3 and the learned HCGP, Srimati Girija Hiremat. The issue in the list pertains to grant of commuted value of pension. Therefore, the dates and events, therefore it would suffice if the dates and events are noted at the periphery. The petitioner joins the service of the respondent department. Second respondent, Hubli Dharwad Municipal Corporation, hereinafter referred to as the corporation for short, on 29/11/1982. And on attaining the age of superannuation, retires on 31/7/2017. During the service of the petitioner, it transpires that a departmental inquiry was pending even at the date of his retirement. Therefore, the petitioner was sanctioned provisional pension and all other terminal benefits were deferred on account of the pendency of the disciplinary proceedings. The petitioner gets exonerated or dropped?
Dropped.
The inquiry against the petitioner comes to be dropped on 26/6/2014, thereby rendering his service in the corporation blemish-free. Petitioner then was sanctioned commuted value of pension on 14/8/2024. The second respondent, ಏನ್ ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ರು?
5,26,428.
Why?
In fact, 7
Why?
lakh. Why, my lords, miscalculation, my lords.
Which
towards
miscalculation?
84 installments we have deducted.
Unpaid
From the date of
commutation value has been
2007.
The
deducted.
respondent corporation, while sanctioning commuted value of pension in terms of the representation or closure of the departmental inquiry deducts 84 in
Installment
84 installments of commuted value of pension,
amounting to rupees 5 lakhs,
which was quantified to 5 lakh,
26,428.
5 lakh 26,000
From August 2017,
428.
August 2017 to July 2024.
From August 2017 to July 2024, ostensibly on the score of pendency of a departmental inquiry on the petitioner. It is this action of the respondent corporation that has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner Abhishek Khalid, taking this court through the documents appended to the petition, would demonstrate that the deduction of 84 months of commuted value of pension from the commuted sanction of commuted value of pension is blatantly contrary to law. As according to the learned counsel, the departmental inquiry, the petitioner was not imposed any penalty, but the departmental inquiry itself stood dropped against him. Once it stood dropped, the petitioner would become entitled to all benefits that would flow to a regular employee, is the submission of the learned counsel appearing for the petitioner. Per contra, the learned counsel Sri Sharanabasava, representing the corporation, would take this court through Rule 376 and 377 of the Karnataka Civil Services rules to demonstrate that
376(7), 376 sub-rule 7,
376, 7 and 8.
ಇಲ್ಲ 7 and 14.
376, 7, ಕೊಡಿ madam. 376, 7 and 14 to defend the action of withholding of 5 lakh, ಎಷ್ಟದು 5 lakh?
5,28,000.
5 lakh 28,000.
5,26,428.
ಅದು ಒಂದ್ ಕಡೆ ಬರ್ಕೊಂಬಿಡಿ 420. Yes, 5,26,420 as being the 84 months of commuted value of pension. The learned counsel submits that since the inquiry was pending against him, no pension can be sanctioned. No commuted value of pension could be granted. And in terms of sub-rule 14 of Rule 376, he would interpret to contend that the commuted value of pension has to be sanctioned 15 years after his within 15 years after his retirement. Therefore, the respondent has time up to 75 years of a retired employee to grant commuted value of pension, and therefore no fault can be found with the action of the corporation. The learned HCGP, you're towing the lines. Learned HCGP would submit that they are only a formal party, and the pension has to be accorded or sanctioned, commuted value is to be granted by the corporation. Yes. I have given my anxious consideration to submissions made by the respective learned counsel and I peruse the material on record. The petitioner retires, joins the service of the corporation on 29/11/1982 and retires on attaining the age of superannuation on 31/7/2017 and is relieved from the services on the said date. Lady Naido.
Lords, superannuation.
ಅಲ್ಲಪ್ಪ ಒಂದು ನಿಮಿಷ. Daughter of, sorry, she retires.
Retires.
ಅಷ್ಟೇ.
Superannuation.
Yes. So and so. During the pendency of the petition against the petitioner, during the service of the petitioner prior to her retirement, the certain disciplinary proceedings were initiated against the petitioner, against her, which ultimately culminated in its closure.
Annexure C, page 27, Lords.
In terms of an order dated
26/6/2024.
26/6/2024, the order reads as follows.
Order is forthcoming at page 26, my lords. Typed copy, page 26.
ಯಾಕೆ ಇದು ಆರ್ಡರ್ ಅಲ್ವಾ? ಸೇಮ್ ಅಲ್ವಾ?
Same.
The order reads as follows. ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Page 27.
ಬಿಡಲಾಗಿದೆ ಅಂತ ಎಲ್ಲಿದೆ?
5, my lords. Para 3. ಈ ಕೆಳಕಂಡ ಅಧಿಕಾರಿ ನೌಕರಗಳನ್ನು ಪ್ರಕರಣದಿಂದ ಕೈಬಿಟ್ಟು ಆದೇಶಿಸಿದೆ. My name finds at 5, my lords. Serial number 5, Srimati.
The inquiry was not only pending against the petitioner, but against 5 others. The inquiry is dropped against all the five. The name of the petitioner finds place at serial number 5, Supra. After at the time of retirement of the petitioner in the year 2000,
Inquiry was initiated against 7 members, not 5 members. Only in respect of 5 members.
Inquiry was initiated against several members, but it is dropped against 5. The name of the petitioner figures at 5. At the time when the petitioner retired from service, the petitioner was entitled to all terminal benefits as a regular employee would get, including commuted value of pension. Commutation of pension is a choice of a retired employee to choose, as it is not a bounty that would be given by the respondent. If the employee seeks commuted value of pension, it would accordingly reduce the pension itself. Therefore, it is not from the coffers or the pocket of the corporation that the employee would be entitled to commuted value of pension. Nonetheless, only on the score that the departmental inquiry was pending against the petitioner, the commuted value of pension was not sanctioned. The inquiry ends up in the name of the petitioner being dropped. On the name of the petitioner being dropped, the petitioner thus becomes entitled to all the benefits that a regular employee would become entitled to on attaining the age of superannuation, including commuted value of pension. Commuted value of pension is sanctioned, no doubt, but with deduction from 31/7/2017 till the date of the closure of the departmental inquiry on account of dropping of the name of the petitioner. The learned counsel for the respondent, Sri Sharanabasava, would place reliance upon Rule 376
Sub Rule 7 and 14.
and Rule 376, Sub Rule 14.
Yes.
The said rules read as follows. Sub-Rule 7 indicates that a retired government servant against whom a departmental inquiry or a judicial proceeding is pending shall not be allowed the benefit of computation of pension till such time he is sanctioned final pension after conclusion of the inquiry, as the case may be. A perusal at the rule in the first blush would indicate that the employee would not be entitled to commuted value of pension at the time of retirement if a departmental inquiry is pending. What happens if the employee is exonerated or name is dropped need not detain this court for long or delve deep into the matter. It is settled principle of law that if a departmental inquiry ends in favor of an employee, it is as if there was no blemish against the said employee. In the case at hand, the name of the petitioner is dropped nonetheless after 7 years after retirement. Therefore, it cannot be said by the respondent that the petitioner would not be entitled to commuted value of pension, as there is nothing against the petitioner to declare the petitioner to have regularly retired on attaining the age of superannuation. The other provision that is pressed into service by Sri Sharanabasava is Sub-Rule 14, where a retired government servant has commuted a portion of pension. The portion of pension shall be restored to him on the first day of the month of expiry of a period of 15 years from the date of commutation. The commutation would begin on the date of retirement. The council's submission is that they have time to sanction up to 75 years of a retired employee the commuted value of pension.
No, my lords, that is not my
sir.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಇದು ಮಾಡಕ್ಕೆ ರಿಕವರಿ ಮಾಡೋದಕ್ಕೆ ಅಪ್ ಟು 75 years
and sorry,
sanction
would
ಮಾಡೋದಕ್ಕೆ
submit
sanction
that,
from the date of
the employer has a power to recover commuted value of pension till 75 years of age of a retired employee on account of several circumstances. the said submission, to say the least, is preposterous. The council has misinterpreted and misread the regulation to defend the action of the corporation, which in the opinion of the court is indefensible, undefendable. Therefore, on the sole score that the petitioner having been exonerated or dropped from the departmental inquiry would become entitled to all the benefits of a regular employee. Commuted value of pension is also a benefit that the regular employee would get. Therefore, it was wholly unfair, unjust, and uncouth on the part of the corporation to have withheld 5 lakh so and so 420 from the amount from the commuted value of pension that is paid on after the closure of the proceedings against the petitioner. Therefore, the petitioner closure of the in the light of in the light of the dropping of the inquiry against the petitioner, though it has happened 7 years after the retirement, it would date back to the date of retirement. Therefore, the petitioner becomes entitled to all the benefits of a regular employee on the date of retirement. The submissions of the learned counsel for the respondent, counsel respondents are all untenable and contrary to law. Therefore, the petition deserves to succeed, not a success simpliciter, but with imposition of exemplary costs upon the corporation. For the aforesaid reasons, the following order: the rate petition is allowed, so and so stands quashed. The amount that is withheld from the pension commuted value of pension of the petitioner shall be refunded to the petitioner within 4 weeks from the date of receipt of the copy of the order. Writ petition is allowed with costs of rupees 1 lakh to be paid to the petitioner by the corporation. Within 4 weeks from the date of receipt of the copy of the order. In the event the amount is not refunded within the amount is not made over to the petitioner within 4 weeks from the date of receipt of the copy of the order, she would become entitled to interest at 12% from the date it fell due, i.e. 31/7/2017, till the date it reaches the doors of the petitioner, ordered accordingly.
My lords, insofar as cost is concerned.
Oh, sir. ಜಾಸ್ತಿ ಮಾಡ್ಲಾ?
ಇಲ್ಲ ಯಾಕೆಂತಂದ್ರೆ
ಡಿವಿಷನ್ ಬೆಂಚ್
one submission ಇಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲ, but one submission ಇದರಲ್ಲಿ because of audit objections, ಅದಕ್ಕೋಸ್ಕರ ನಾವು we could not release the amount. Therefore, my lords, once we have passed an order, therefore, my lords, may I request to this honorable court to reduce the, my lords,
cost.
ಯಾಕಂದ್ರೆ ಇಲ್ಲ ನಾನು
ರೆಡ್ಯೂಸ್ ಮಾಡ್ಲಾ? 99,990
lords 25,000 ಯಾಕಂದ್ರೆ
ಏನ್ ಬಾರ್ಗೇನ್
ಇಲ್ಲ ಬಾರ್ಗೇನ್
HDMC ಗೆ ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಕಾಸ್ಟ್ ಆಗಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀನಿ. ಯು ಬಿಹೇವ್ ಲೈಕ್ ಇಟ್ಸ್ ಯುವರ್ ಪರ್ಸನಲ್ fiefdom and treat the employees as and how you want. I've been seeing cases after cases. ನಿಮ್ಮ ಕಾನೂನೇ ಇಲ್ಲ HDMC ಗೆ.
ಇಲ್ಲ ಇದ್ರ
ನೋ ಲಾ ಎಟ್ ಆಲ್.
84 months
ಯಾರಿಗೂ ಪೆನ್ಷನ್ ಕೊಡಲ್ಲ. ಎನ್ಕ್ವೈರಿ 10 ವರ್ಷ ಇಡ್ತೀರಾ, ನಥಿಂಗ್ ಹ್ಯಾಪನ್ಸ್ ಅಂಡ್ ಫ್ರೀ ಫಾಲ್ ಫಾರ್ ಯು.
84 installments we have deducted. We have sanctioned the, my lords, commutation.
ವಾಪಸ್ ಕೊಡಿ.
84 installments we have deducted.
ಕೊಡಿ.
Cost
no, I will increase the cost.
ಯಾಕಂದ್ರೆ ಇಲ್ಲ otherwise ಇಲ್ಲ ತೊಂದರೆ ಅಂತಲ್ಲ, but audit objection otherwise
ತೊಂದರೆ ಇಲ್ಲ.
In fact, my lords, I have
suggested objections ಅಷ್ಟೇ, ಮನಸ್ಸಿಗೆ ಬಂದಂಗ objection. He sits in his AC chambers and writes something that takes away the pension of an employee.
For that reason, my lords.
No, sir.
ಅಲ್ಲ. Yes. ಅದಕ್ಕೋಸ್ಕರ ಇದು ಮಾಡಿ.
ಜಾಸ್ತಿ ಮಾಡ್ತೀನಿ ಬೇರೆ. 1 more lakh.
Request, my lords,
Inquiry, sir, it is basic principle
definitely,
of
my
law.
lords,
Basic principle of law.
Yes, yes, I
that
do.
once an employee gets exonerated or dropped, it dates back to the date of retirement.
Yes, my
it is
lord,
as
I
if
do
there was
admit
nothing. Then how did you deduct?
ಇಲ್ಲ ಅಂದ್ರೆ
Who is that audit who has done this?
ಅಲ್ಲ ಇದಕ್ಕೆ 84 months
Change the
installment deduct ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
Change
They
the
have recovered
statutory
it.
audit group, sir.
They have recovered it. That's all.
ಅದೇ
They have
recovered it.
recovered it.
ಕೊಡಿ
84
ವಾಪಸ್.
ಇಲ್ಲ ಕೊಡ್ತೀವಿ ಅದಕ್ಕೆ. Cost also.
No, sir.
ಅಲ್ಲ
Appeal
next time, my lords, ಅಲ್ಲ
Appeal
next
at
time
2 courts away.
ಅಲ್ಲ appeal but next time, my lords, I will my
Oh,
lords,
no, sir.
direct the authorities.
Yesterday I have told in the court that HDMC ಗೆ ಇನ್ಮೇಲೆ
ಇಲ್ಲ HIMC ಅಲ್ಲ ಇದು ಹೂಡಾದ್
ಯಾವ್ದು ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್
ಅಲ್ಲ ಅದಾಗಲ್ಲ ಅದಕ್ಕೆ ಫಸ್ಟ್ ಸ್ವಲ್ಪ ರೆಡ್ಯೂಸ್ ಆಮೇಲೆ 25,000 ಮಾಡಿದ್ರೆ ನಾನು ಐ ವಿಲ್ ಇನ್ಸ್ಟ್ರಕ್ಟ್
ಚಾರಿಟಿ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ ಚಾರಿಟಿ
ಎಂಟೈಟಲ್ಮೆಂಟ್
ಐ ವಿಲ್ ಇನ್ಸ್ಟ್ರಕ್ಟ್
ದಟ್ಸ್ ದ ಲೇಡೀಸ್
ಅಲ್ಲ
ಎಂಟೈಟಲ್ಮೆಂಟ್
ಇದು
ಕಮಿಟೆಡ್ ವ್ಯಾಲ್ಯೂ ಆಫ್ ಪೆನ್ಷನ್ ಯು ಬಿಹೇವಿಂಗ್ ಆಸ್ ದಟ್ ಇಸ್ ಚಾರಿಟಿ.
ಅಲ್ಲ 11th month ಅಲ್ಲಿ ಇದಾಗಿರೋದು ಅಷ್ಟೇ.
11th month
2024
ಸೊ
1 year ಆಗಿದೆ.
One year
25,000 rupees my lord should be
ಅಲ್ಲ 50,000 ಗಳಿಸಿ
much grateful.
ಓನ್ಲಿ ಬಿಕಾಸ್ ಆಫ್ ಶರಣ ಬಸವ. Yes.
Petrol, your lordship.
Petrol.
Petrol, your lordship.
Applied within 6 months, it is not permissible under law.
ಅಲ್ಲ ಯಾವಾಗ ಲಾಸ್ಟ್ ಪೆರೋಲ್?
Last ಆಗಿದ್ದು ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ
ಕೂಲಿಂಗ್ ಆಫ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ,
Your
6 months
lordship,
ಆಗಿದೆ.
June 2024, your lordship.
ಯಾವಾಗ? 2024 ಜನವರಿ ಟು ಡಿಸೆಂಬರ್ ಯಾವಾಗ?
Your lordship, he returned to the jail on 8/8/2024, your lordship.
ಅಲ್ಲ 6 ತಿಂಗಳು ಆಗ್ಲಿಲ್ಲ ಅದ್ರೊಳಗೆ
ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
Your
8/8/24 ಆಗಿದೆ.
8/8/24 ಇವಾಗ ಎಲ್ಲಿದ್ದೀವಿ ನಾವು?
ಪೆಟಿಷನ್ 9/1/25 ಹಾಕಿದ್ದಾರೆ.
ಪೆಟಿಷನ್ ಹಾಕಿದ್ದಾರೆ, ಕೊಡ್ತಾ ಇರೋದು ಯಾವಾಗ ಸರ್?
Moreover, another my lords, my main objection is that on medical ground they have sought for. Kindly see the my lords, the medical.
ಏನ್ 302 ನಾ?
ಹೌದು. ಅಲ್ಲ 302.
ಎಷ್ಟು ವರ್ಷ?
376, 366,
Your
392.
lordship, 376, he has completed, your lordship. 7 years ಇತ್ತು 376 ಅಲ್ಲಿ. He has completed 7 years, your lordship. 302 life, your lordship.
376, 302 ನಾ?
ಹೌದು ಹೌದು.
Your lordship, 376 7 years ಆಗಿತ್ತು, ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ, your lordship.
ಆಮೇಲೆ
Conviction.
robbery is also section 392 is also he has convicted. And my lords, kindly see
ಇರ್ಲಿ ಬಿಡಿ.
medical ground.
ಅದೇ
Your lordship, January ಅಲ್ಲಿ.
I will give but not 1-4 weeks.
Your lordship, 8 months ಮುಂಚೆ ಈ ತರ.
ಅವ್ರಿಗೆಲ್ಲ ಸ್ವಲ್ಪ
Your lordship, 376, he has completed, your lordship. 7 years conviction ಆಗಿತ್ತು, ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. Last March also, February also, lordship said, sir.
List the matter on 1st December.
ಆಮೇಲೆ ಅವ್ರದ್ದು ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಸ್ವಾಮಿ ಪರವಾಗಿಲ್ಲ.
ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಆನ್ಲೈನ್ ತಗೊಳ್ಳಿ ಈಗ. What is all this application?
online
ಇಲ್ಲ ಅದಿಲ್ಲ. You have to put in a system where application comes online. You should have interaction with those jurisdictional police to go and get a report. ಎಲ್ಲ ಇದೇ ಆಗೋಗಿದೆ. Primitive ಕಾಲದಲ್ಲಿ you can't go the primitive way now. With the burgeoning cases here, you can't go the primitive way. Yes.
Your lordship, November, some date in November, your lordship.
November ಇಲ್ಲ, December 1st. Yes.
Your lordship, he has completed 8 years, your lordship. as of
ಪರವಾಗಿಲ್ಲ,
now.
let 4 more weeks get completed. Next.
Blessed.
Lords, the petitioner is working in respond number 8 college, my lords. Respond number 8 college was sanctioned granting aid in the year 2015, my lords.
ಅದೆಲ್ಲ ಬಿಡಿ. 2007,
Yes,
2014,
Yes,
today,
Yes,
do you have qualification?
Yes, my lords. I have.
What? Yes, sir.
My lords, for that.
ಲೈಬ್ರೇರಿಯನ್ಗೆ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಏನು ಅದಿದೆಯಾ ಹೇಳ್ಬಿಡಿ.
Yes, my lords.
NET SLET ಪಾಸ್ ಆಗಿದೆಯಾ ಹೇಳಿ.
Page number 40 may kindly be seen, my lords. Wherein,
You are claiming that others have been given, I should also be given.
no, my lords. The thing, for the state scale, SLET and NET and PhD is not required. They have only mentioned.
ಅದೊಂದು ತೋರಿಸ್ಬಿಡಿ. ಅದು ಮೊನ್ನೆಯಿಂದ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
Yes, my lords. It is in on page number 40, my lords.
Page?
Page number 40.
40.
40, my lords. In
Yes.
this column, my lords.
Yes, sir.
ಬೋಧಕ ಸಿಬ್ಬಂದಿ.
Column, which column, sir?
My lords, ವೇತನ ಶ್ರೇಣಿ column, my lords.
ವೇತನ ಶ್ರೇಣಿ column.
ಬಿ ಜಯಸಿಂಹ.
ಶ್ರೇಣಿ column. ಬೆಲ್ಲದ್ ಕಾನೂನು ಕಾಲೇಜ್ so and so.
My lords, in this table.
ಇವರುಗಳು ಅದಾ?
Yes, sir, my lords. ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ law 35 KLM.
24/12/2009.
Yes, my lords. ಇಲ್ಲಿ ಬೋಧಕ ಸಿಬ್ಬಂದಿ ಅಂತ ಇದೆ, my lords. ಇಲ್ಲಿ ಕಾಲಮ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಒನ್ ಬಿ ಜಯಸಿಂಹ, ಪ್ರಾಂಶುಪಾಲರು GM ಕ್ಯಾಟಗರಿ, my lords.
ಸರ್ ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ಸರ್?
Lords, page number 40, my lords.
I am at 40 or 41.
40, my lords.
ಬೋಧಕ ಸಿಬ್ಬಂದಿ.
ಬೋಧಕ ಸಿಬ್ಬಂದಿ, my lords. ಇಲ್ಲಿ ಬಿ ಜಯಸಿಂಹ ಅಂತ ಇದೆ, my lords. ವೇತನ ಶ್ರೇಣಿ. Yes, my lords. ವೇತನ ಶ್ರೇಣಿ ಕಾಲಮ್, my lords, ಲಾಸ್ಟ್ ಕಾಲಮ್. ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿ. ನೆಟ್ SLET PhD ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿರುವುದಿಲ್ಲ, my lords. Without they have
This is teaching staff.
teaching staff, my lords. So
ನಿಮ್ದು ಯಾವ್ದು?
my lords,
ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿ.
no, my lords. he is also come in teaching only.
Librarian.
Librarian.
All right. Amale.
My lords, in next page, my lords, at page number 41, my lords. At serial number 5, Rajkumar MB, my lords. Wherein they have mentioned that ಇವರುಗಳು ದಿನಾಂಕ 11/7/2009 ನಂತರ ನೇಮಕಾತಿ ಆಗಿದ್ದು ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ 24/12/2003 ವಿದ್ಯಾರ್ಥಿ ನೆಟ್ ಸೆಟ್ PhD ಹೊಂದದೇ ಇರುವುದರಿಂದ ಕಾನೂನು ಕಾಲೇಜಿನ ಪ್ರಾಧ್ಯಾಪಕರು ಮತ್ತು ದೈಹಿಕ ಗ್ರಂಥಪಾಲಕರು ಪರಿಗಣಿಸಲು ಸಾಧ್ಯವಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ನೀವು ಯಾರು? ರಾಜ್ಕುಮಾರ್ ನೀವೇನಾ?
Yes, my lords.
Yes, madam.
Your Lordship, as on the date of requisite appointment, Your Lordship, he was not having the qualification.
Even today he doesn't have.
Please, Your Lordship.
Even today he doesn't have the qualification.
Please, Your Lordship, that is the reason. Subsequently he has got, Your Lordship, but masters he has not, Your Lordship. Masters illa.
Pay scale ge masters bedo ಬೇಕು.
Beku.
That
is necessary.
There are in this column only, my lords, in Bodhaka Sibbandi at serial number 3, my lords, Vijay Murdunde, he is having a UGC, my lords. Net cert and PhD. He is having a net cert PhD. He has been given, my lords, this order itself shows that there are two pay scales, my lords. One is
you are seeking state pay scale.
State pay scale, my lords.
Yes, Gayatri madam. ನಿಮ್ದೇನಿಲ್ವಾ?
Here for the college minutes.
Your
Lordship, the third person, Your Lordship, he is Sahayaka Pradhyapakaru. The person who is now seeking is a librarian, Your Lordship. Please, Your Lordship. The reason he is not having a requisite qualification as on the date of appointment, Your Lordship. During 2006.
But ಇವ್ರಿಗೆ ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ? Without requisite qualification ಏನು?
Your Lordship, post graduation, Your Lordship, and a net set also, PhD also, Your Lordship.
Post graduation?
And passing the net and set also, Your Lordship, PhD or PhD.
ಹೊಂದಿರುವುದಿಲ್ಲ ಅಂತಿದೆಯಲ್ಲ ಇಲ್ಲಿ. ಈಗ come to page 40 madam. ಜಯಸಿಂಹ ಬಿ ಅಂತ ಇದೆ.
ಹೌದು.
ಅಥವಾ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರು ರಾಜ್ಯ ವೇತನ ಶ್ರೇಣಿ NET SLET PhD ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿರುವುದಿಲ್ಲ. ನಿಮಗೇನ್ ಪೇ ಸ್ಕೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
I have not been considered, my lords.
ಏನ್ ಪೇ ಸ್ಕೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ, my lords.
ಪೇ ಕೊಡ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ, my lords, the payment was made by the management, my lords.
Your Lordship, and on 26/8/2005, Your Lordship, 2015, the order has been passed for grant in aid, Your Lordship.
Correct.
Please, Your Lordship. On that day, Your Lordship, only 5 teachers and 9 non-teaching staffs were been appointed, Your Lordship.
Right.
And in that, Your Lordship, 4 staff members were left out, wherein he was also there, because as he was not having
What was the
qualification
qualification on that day?
Your Lordship, only graduation he was having, Your Lordship.
What is the necessary qualification?
Necessary qualification, post graduation, MLib and masters.
Where do you get that?
My lords, the
Qualification ಏನಿತ್ತು?
My lords, I will explain, my lords.
You don't explain. 2015 ಅಲ್ಲಿ what was the necessary qualification for the post of librarian even to the state pay
My
scale?
lords,
ಹೇಳಿ.
the issue is that, my
Issue
lords,
ಅಲ್ಲ. Qualification ಏನಿತ್ತು ಹೇಳಿ ಅವತ್ತು?
my lords, I have been appointed in the year 2007, my lords. At that point of time, for the state pay scale, the candidate has to be having a master degree of 55%, my lords.
Correct.
At that point of time, I am having a, may kindly be seen, my lords, at page number.
Which is master's degree ಯಾವ್ದು ನಿಮ್ದು?
Library science, my lords.
Masters in library science.
Yes, sir, my lords.
55% ಇತ್ತಾ?
55% is, my lords.
Lordships, kind
See the
permission.
objections. Go to the objections.
Yes, my lords, I have gone through.
Rejoinder
My lords,
ಹಾಕಿದ್ದೀರಾ ಅದಕ್ಕೆ?
my lords, the issue is that, my lords,
Rejoinder ಹಾಕಿದ್ದೀರಾ ಅದಕ್ಕೆ? 55% ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ ಅದು.
rejoinder is ready, my lords. I will file it.
ಎಲ್ಲಿದೆ?
File,
ಮತ್ತೆ ಹಾಕ್ತೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
my lords, I will file it.
You are not qualified on the date of.
My lords, not only total 19 colleges have been extended a grant in aid, my lords, wherein the kindly we seen, my lords, at page.
ಬೇರೆದ್ರಲ್ಲಿ we can show some leeway and direct consideration, direct appointment, but in so far it touches upon the qualification.
My lords, it is not.
File a rejoinder. It's a 2025 matter. Learned counsel appearing for the petitioner seeks 2 weeks time to file rejoinder statement to the objections so filed by the petitioner, but you have no case.
That's one.
Less the,
I appear for respond number 9. I was told to bring what is the qualification of librarian in Karnataka.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅವಾಗಿಂದ.
The statute governing librarian, my lords, it prescribes terms and conditions of service and emoluments of librarian shall be such as applicable to the professor under UGC.
That is if he is seeking UGC scale. He is seeking state scale.
This is the only
My lords, in this
regulation
case,
available with the university.
19 colleges have been extended granted aid, my lords. Wherein,
No, this has wide ramifications, sir.
my lords,
Just like
56
that one
candidates.
case, we can't do it. You file a rejoinder,
Yes,
but you have no case prima facie unless you convince. ನೀವು ಅದು ನೋಡಿ ನಿಮ್ಮ objections ಅಲ್ಲಿ detail ಆಗಿದೆ objection. Yes. Less the matter on 19th in preliminary hearing.
Yes.
Rejoinder if any by then next.
Number 4, Amit Deshpande.
Yes, ma'am. The petitioner is a successful bidder to supply manpower to town municipal council.
ಈಗೇನು ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ವಾ?
ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. ಅವ್ರ ಒಂದು ಲಿಸ್ಟ್ ಕೊಡ್ತಾರೆ. ಆ ಲಿಸ್ಟ್ ಪ್ರಕಾರ ಅವರು they are insisting their own list.
ಇಲ್ಲ 2024 ನಾಗ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದೀವಿ.
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದೀವಿ.
ಮಾಡಿದ ಮೇಲೆ ಇಲ್ಲಿ annexure C make
why are you here?
kindly see annexure.
What is the challenge, sir?
I am challenging annexure G, my lordship.
What is that?
Annexure G is the list of employees. And before that, kindly see annexure C, my lordship. Annexure C is the list of employees given by me. And after that, annexure D has been issued. As per annexure D, kindly see page number, para number 3 of annexure D, my lordship, page number 19. ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ಸನ್ಮಾನ್ಯ ಶಾಸಕರು ಕಂಪ್ಲಿ ವಿಧಾನಸಭಾ ಕ್ಷೇತ್ರ ಕಂಪ್ಲಿ ಇವರು ವೀರಾಂಜನೇಯ ಸದಸ್ಯರು ಪುರಸಭೆ ಕಂಪ್ಲಿ ಇವರು ಶಾಸಕರು ನೀಡಿರುವ ಪತ್ರದ ಪಟ್ಟಿಯಲ್ಲಿ ಇರುವಂತೆ ಹೆಸರುಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳಲು ಸೂಚನೆ ನೀಡಿ ಪತ್ರದ ಮೇಲೆ ಮೇಲ್ರುಜು ಮಾಡಿ ಕಳಿಸಿರುತ್ತಾರೆ. ಸೊ ಅವರು ಕಳಿಸಿರೋ ಪಟ್ಟಿ ಪ್ರಕಾರ ನಾನು ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಳ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Tender is for supply of manpower.
Yes,
so you are the successful bidder.
Yes, my lordship.
You have your own manpower.
ಹೌದು.
So you have to supply.
ಹೌದು.
ಈಗ why are you imposing, sir? ಇವ್ರನ್ನೇ ಕರ್ಕೋಬೇಕು ಅಂತ ಯಾಕೆ ಇಂಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಇವ್ರನ್ನ ಅಂತಲ್ಲ, ಅವ್ರನ್ನ ಬಿಟ್ಟರು ಕೂಡ ಅವ್ರು
ಇದೇನ್ ವಾಟ್ ಇಸ್ ದಿಸ್ annexure D? ಈಗ ಏನಾಗಿದೆ ಕೆಲಸ
ಟೆಂಡರ್ ರದ್ದು ಮಾಡ್ತೀವಿ.
ಅದಲ್ದೇನೆ ಇಲ್ಲ ಟೆಂಡರ್ ರದ್ದು ಮಾಡ್ತೀವಿ.
ಫಸ್ಟ್ ಒನ್ ಬೈ ಒನ್ ಸರ್
ಪ್ಲೀಸ್.
ಟೆಂಡರ್ ಮ್ಯಾನ್ ಪವರ್ ಗೆ he is a successful bidder. He has his own manpower. What is this you are imposing now? ಯಾರು MLA ಹೇಳಿದ್ರಾ ಇವ್ರಿಗೆಲ್ಲ ಕೊಡಿ ಕೆಲಸ ಅಂತ?
ಅಲ್ಲ ಎಲ್ಲ ಇವ್ರಿಗೆಲ್ಲ ಅಲ್ಲ, ಇಬ್ಬರಿಗೆ ರೆಕಮೆಂಡ್.
ಯಾರು
ಉಳಿದವ್ರಿಗೆ ಯಾರಿಗೂ ಅಲ್ಲ.
ಯಾರಿಬ್ಬರಿಗೆ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲಿ ಟೋಟಲ್ ಲಾಟ್ಸ್ 18 persons he was asked to supply.
ಆಯ್ತು, ಇದರಲ್ಲಿ ಸಪ್ಲೈ
ಎಲ್ಲ ಇವ್ರನ್ನ ನಾವೇ ರೆಕಮೆಂಡ್ ಮಾಡಿದ್ದಲ್ಲ ಅಥವಾ
ಅಲ್ಲ ಅವ್ರ ಮ್ಯಾನ್ ಪವರ್ ಅವ್ರು ಮಾಡ್ಕೊಂತಾರೆ. he is successful.
ಮಾಡ್ಲಿ, let him do it.
ಅಷ್ಟೇ.
Let him do it.
Other interfering then?
Let him do it, my lords.
All right.
And let him give his own manpower supply.
Correct.
But the difficulty is now, my lords, he is asking for giving us, my lords, appointment orders. That we are not supposed to, because as per the condition in the tender, he has to, my lords, after issuance of work order, he has to, my lords, register the name of the employees, my lords, in the ESI and PF, and then he has to submit.
ESI and PF ಮಾಡಬೇಕು ಅಂತಂದ್ರೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿ ತಗೊಂತಾರೆ ಅವರು? ESI
ಅಲ್ಲ, ನಾವು we have issued, my lords, that by approving the list supplied by him, given by
ESI PF ಪೇ ಮಾಡಬೇಕು ಅವರೇ ಅಂತಂದ್ರೆ you should give appointment order. ಇಲ್ಲದ್ರೆ ESI PF ರಿಜಿಸ್ಟರ್ ಆಗಲ್ಲ.
ಅಲ್ಲ, ಅದು ನೇಮ್ಸ್ ಗೆ ಅಪ್ರೂವಲ್ ಕೊಟ್ಟಿದೀವಿ ನಾವು. The names we have given work order also. The names we have approved. Whatever the manpower he has not furnished, we have approved.
Generally what do you do?
Well, so we will approve the.
No, ಮುಂಚೆ ಎಲ್ಲ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು ಗೊತ್ತಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ.
ಮತ್ತೆ
ಅಲ್ಲ, ಇಲ್ಲಿ as per annexure C, if they direct us to appoint, we will take necessary steps. They are insisting as per annexure D, my lordship. Their own employees, they are insisting. That is the problem.
ಅಲ್ಲ insist ಮಾಡೋದು ಬೇಡ, but let
we
him
will
not
comply
see
other
the
conditions.
EPF.
Petitioner is before this court seeking the following prayer. The issue that brings the petition, the petitioner had so and so. A tender is notified by the second respondent for securing manpower. The petitioner being supplier of an enterprise being supplier of manpower emerges as the successful tenderer. Work order is also issued to the petitioner on 30/11/2024. The petitioner submits list of employees from whom the work would be extracted in terms of the tender. It transpires that the second respondent directs inclusion of many names, excluding the names submitted by the petitioner. The learned counsel, Sri Sharanabasava, submits that the second respondent will not insist upon its employees to be, its names to be in the list of employees to execute the tender. The submission is placed on record.
Well, that's one submission. ಅಂದ್ರೆ ನನ್ನ ಸಬ್ಮಿಷನ್ ಅನ್ನಕ್ಕಿಂತ ತಾವು ಆರ್ಡರ್ ಮಾಡಿ
ಹಾಗಾದ್ರೆ ಒಂದು ನಿಮಿಷ ತಾಳಿ.
ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಇಟ್ ಕ್ಯಾನಾಟ್ ಬಿ, ಐ ಕ್ಯಾನಾಟ್ ಇನ್ಸಿಸ್ಟ್ ಅಂತ ಹೇಳಿ ತಾವು ಆರ್ಡರ್ ಮಾಡಿ
ಅಂದ್ರೆ ಹಾಗಾದ್ರೆ ಸ್ವಲ್ಪ ಡೀಟೇಲ್ ತಗೊಳ್ಳಿ. Work order is issued to the petitioner. The second respondent communicates on 2/1/2025 its own list of employees. Therefore, the petitioner is said to have submitted a revised list on account of the pressure mounted upon it. The second respondent then communicates to the petitioner to submit the ESI and PF details of the employees that they have appointed. The non-compliance with the said direction has resulted in the show cause notice issued to the petitioner as to why the contract should not be terminated. It is at that juncture the petitioner is before this court in the subject petition. The learned counsel Anup Deshpande, appearing for the petitioner, would submit that the petitioner was a successful bidder. He has his own team to supply manpower. The second respondent is insisting on its employees to be a part of the tender, which is contrary to the tender condition. He would submit that if the ESI PF would be done, ESI PF authorities would not register these employees unless there is an approval list in the list granted by the second respondent. The learned counsel appearing for the second respondent, though would seek to defend the action, is not in a position to clarify. The learned counsel for the second respondent would seek to defend the action of listing its employees as it is the tender for manpower. From where manpower would come is immaterial. The learned AGA would also toe the lines of the learned counsel appearing for the petitioner. I have given my source. Therefore, narrated facts are not in dispute. A tender is notified for the purpose of securing manpower. The petitioner emerges as the successful bidder. Since it was a supply of manpower, the petitioner furnished list of employees to the second respondent that these are the employees would be involved in executing the contract. Another list comes in reply on 2/1/2025, including several names in the employees list. This runs counter to the tender condition. The second respondent, after having the petitioner, after awarding the work to the petitioner, work of executing manpower, cannot insist that its own employees should be taken by the petitioner while executing the contract. The petitioner is an independent enterprise who has his own manpower and has been successful in the tender. After issuing work order, the indirect methods of intimidating the successful tenderer cannot be countenanced. In that light, the insistence of the second respondent to take its employees in place of the employees of the petitioner is untenable in law. Since every other action has sprung from the said dictate of the second respondent, all those would become a nullity. Insofar as the registration of ESI and PF is concerned, the learned counsel, Sri Sharanabasava, would submit that they would only give the approval list for the employees list that is given by the petitioner and cannot issue appointment orders. The learned counsel Anup Deshpande submits that it would suffice if an approval list is given by the second respondent. In the light of the said submission, while directing that the second respondent cannot insist something contrary to the tender conditions, I deem it appropriate to dispose the petition by the following order. The petition is allowed in part. The so and so show cause notice stands quashed. The submission of the parties that is borne consideration in the course of the order shall be treated as the operative portion as well. Ordered accordingly.
Lords, the tender period is for a period of 1 year. That's even less than 1 year. That will, my lords, after issuance. That
So and so shall not insist for the period of tender. Yes.
please.
Ordered accordingly.
Ranjita.
I appear for petitioner.
ಓದಿದ್ರ ಮೇಡಮ್?
Please. Lordship,
ಆಗೋಗಿದೆ.
one more judgment, my lord.
One more judgment.
And there is two more judgments. This is latest judgment of 2025, rendered in the Patna High Court Division Bench. Jalar Singh and also Bhargav is referred. Writ is maintained.
What's your name? Ranjita.
Please.
Yes, Ranjita. Anything?
Your Lordship, there's two judgments wherein Your Lordship, this Honorable Court, they have to file a separate suit. Wherein Your Lordship, now dispute is a question of law involved, Your Lordship, to my knowledge. But what about the legal rights of the stranger when they are challenging the compromise decree passed in Lok Adalat? All the Bhargava construction judgment says that, Your Lordship, it specifically says about the rights of the party to the suit. Nowhere, Your Lordship, what about the legal rights of the stranger? This is not particularly stated. In 2-3 judgments I have given, Your Lordship, there is a stranger's rights towards writ petition to say the compromise decree is void. Say that writ petition they cannot file. There's a suit remedy.
We'll answer everything.
Please.
Yes.
With respect to your facts, Your Lordship, actually there is 7 lines of families. Manmat Kere, Hire Kere, Chavadi Kere, and Timmanath Kere, and some other 7 lines, Your Lordship. We belongs to Timnath Kere. They says that, Your Lordship, they still belongs to Timnath Kere, and there is a 4 parts of ancestors. And Your Lordship, adralle namdu heltare, but whether we are son or my ancestor is a son, daughter, how we are related, they are not stated in their genealogy itself. Genealogy itself is wrong, Your Lordship. And Your Lordship, they says that 70 TL or 8 TL partition agide. Till today, records are not in their name. They are only saying they are in the possession. This is all matter of facts, and they have to establish in their separate suit. Because, Your Lordship, if they implead it as without recalling the compromise decree, to my knowledge, they cannot implead in the suit. Without impleading, they cannot recall the compromise decree. And Your Lordship, being if at all they are impleaded, being a defendant, Your Lordship, they cannot invoke 39(1) and 2.
We'll see later.
Still, for their betterment, they have to file
If I
suit
restore
itself.
the suit,
Please.
partition suitally, defendant to plaintiff, the rule is illusory. Because in a partition suit, all of them get a share. So that strict sense of he's the plaintiff, he's the defendant, that definitely is illusory.
Yes, definitely.
Yes. We'll see.
The B and C are the registered partition deed and also registered sale deed. We are claiming.
Reserved.
Grateful.
Number 6.
Because this everything is a little hazy. We'll try to solve something. Yes.
And also section 22E of the
Legal Service Authority.
Please.
But that is also observed in 2 judgments.
You need not worry. Everything will bear consideration. Yes.
Grateful.
Whether it is right or wrong is a different thing, but it will bear consideration.
Grateful.
Item 6. Item 6 ಮೇಲೆ direct assist on behalf of the petitioner ಮೇಲೆ.
1 minute, sir. ಯಾರ್ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಹೇಳಿ ಎಲ್ಲರಿಗೂ ಗೊತ್ತಿಲ್ವಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ You're not from this bar?
Sumana Nagana. Sumna Nagana.
ಯಾರು?
Sumna Naganand my lords for the KERC.
ಯಾರಿಗೆ ಸುಮ್ನ ನಗಾನಂದ್?
KERC my lords.
ಸುಮ್ನೆ ಹೇಳ್ಬೇಡಿ.
ಇಲ್ಲ ಇಲ್ಲ ಹೌದು. ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ my lords in relay challenging the same order and my lords an interim order has been passed.
ಪೆಟಿಷನ್ ನಂಬರ್ ಕೊಡಿ.
100565 my lords.
ಇದೆಯಾ ಅಲ್ಲಿ? ಕೌನ್ಸಿಲ್ ಪ್ಲೀಸ್ ಕಾಪಿ ಇಲ್ವಾ? Same order. Tag same order. Both 6 and 7.
Well, 7 my lords is a different order my lords.
Yes.
My lords, just one submission in item number 6 my lords. Recovery notices have been issued by the ESCOMs. My lords, the dates are different. May I request my lords to kindly stay the operation of the recovery notices.
No coercive steps pursuant to the demand notice shall be undertaken by the respondents till the next date of hearing. Yes, next.
Please, my lords. My lords, in item 7 my lords.
Yes.
My lords, I had my lords a power purchase agreement with the ESCOM. My lords, after the term, my lords, of the expiry of the term of the power purchase agreement, I would continue to my lords inject energy into their grid. My lords, this honorable court
ESCOM
direct.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಎಲ್ಲರಿಗೂ ಇಲ್ಲಿ? ಸೇಮ್ ಅದರಲ್ಲಿ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ ಮೇಡಮ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ಗೆ? ಅದೇ BS ಕಾಮ್ಟೆ ಅಂಡ್ ಅದರ್ಸ್ ಯಾರಿದ್ದಾರೆ ಅದು ಮಾಡಿ. ಸುಮ್ನಾ ನಾಗಾನಂದ್ ಫಾರ್ ದಿ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್. And list these matters on 20th November.
Well, as interim stay, my lords, your lordships may.
15, 10, 24. We'll see.
ಅಲ್ಲ recovery notice issue ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಗ್ಲೇ.
ಯಾವಾಗ?
My lords, this honorable
issue ಮಾಡಿರೋದು ಯಾವಾಗ?
My lords, in 2025, my lords.
When date?
14th of December 2025.
14th of December 25. I have not seen, sir.
Hello, 14th.
I have seen 14th December 25, sir.
Sir, 14th of February 25. ಅದು 2 ನೋಡಿದಲ್ಲ.
Yes.
Well, this honorable court has directed the ESCOM.
Sir, 10 ತಿಂಗಳಾಗಿದೆ. Yes.
ಅಲ್ಲ, this.
Move the matter if there is any coercive steps. Petitioner is deputed to know the court in the event of any coercive steps. Yes, next.
May I just make one submission, my lords? Now crushing season has begun. Now, my lords, I'll have to continue, my lords, to inject energy. The ESCOMs, my lords, will not give me a NOC without, my lords, there being an order of stay. They will ask me, my lords, to comply with the demand.
What was the procedure for the last 8 months, sir?
No, my lords, the crushing season had begun. There was no crushing season at all. There was no generation of electricity. Crushing season is going to begin only, my lords, in the next 2 or 3 days.
All right. You serve on the respondent, then e matter matra, list it on 10th. Yes.
No, may I just make one submission? Just one.
Yes, list on 10th. Next.
Very well. I'm very good.
My lord, a petitioner filed this, my lord, writ petition challenging annexure E and F, my lord. This matter pertains to, my lord,
deputation.
Transfer, my lord.
Deputation.
It is not on the deputation, my lord.
Sir.
No, my lord. Initially, he was transferred, my lord.
First dates, places, everybody.
2/5/2023. 2023.
2023.
23.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
He is transfer from Canara Bank to KVG Bank head office, Dharwad.
Transfer outside the bank adre deputation adu. It's not transfer. Yes, Canara Bank to
KVG Bank, my lord.
Vikas Grameen Bank.
Vikas of Grameen Bank, my lord. Then, my lord, as for annexure A, my lord, on 19/4/2025, my lord.
On
19/4/2025, my lord. My lord, the transfer to the respondent bank, my lord. That is
back to Canara Bank.
Canara Bank, my lord. Then, my lord, as for annexure B, my lord.
19/4/25.
19/4/2025. Then, my lord, the KVG Bank is merged with effect from 1st May 2025 in KG Bank, my lord.
All right.
Then, as for annexure C on 2/6/2025, my lord. He is relieved from the KVG Bank. That is KG Bank, my lord.
ವಾಪಸ್ ಬಂದ್ ಆಗಿತ್ತಲ್ಲ 19/4/25ಗೆ ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ.
Order cancel ಆಯ್ತು. Order was cancelled, my lord.
ಅದೇ ಹೇಳಿಲ್ಲ ಯಾವಾಗ ಕ್ಯಾನ್ಸಲ್ ಆಯ್ತು?
It was cancelled on 15/5 to
Give, with clarity, give the dates at least,
15,
sir.
15/5/2025, my lord.
Hmm. Cancelled and you continued in KVG.
KVG, my lord.
Hmm.
Then, my lord, 2/6/2025,
Hmm.
he is relieved from the KG Bank, my lord, Karnataka Gramina Bank. My lord.
Hmm.
And as for Annexure C, my lord, he joined the Respond Bank, my lord, presently.
Canara Bank.
Canara Bank. My lord.
Hmm.
Then, my lord, as for Annexure E, my lord, that
Hmm.
is 16/6/2025, my lord.
Hmm.
It's very important, my lord. Kindly see the, my lord, the Annexure E, my lord.
Hmm.
It is here mentioned that Sri so and so person transferred under this order shall on repatriation and relief from the Karnataka Vikasa Gramina Bank head office Dharwad.
Hmm.
He is already joined in a Respond Bank, my lord. This bank is not at all existence, my lord.
Solid, ಹೇಳಿ ಈಗ. ಈಗ ಏನಾಗಿದೆ ಪ್ರಾಬ್ಲಮ್?
Now, my lord, he has within a span of 15 days, my lord, again he has a transfer from the Respond Bank to Vijaypur Bank, my lord, within a 15 days, my lord.
ಡೆಪ್ಯುಟೇಷನ್ ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಅಲ್ಲ ಆಮೇಲೆ.
It is not a deputation, my lord. It is here. The copy is here, my lord.
ಆಮೇಲೆ ಎಸ್ ಇರ್ಲಿ ಹೇಳಿ. 60 ಯಾವಾಗ ಈಗ ಎಲ್ಲಿಗೆ ಕಳಿಸಿದ್ದಾರೆ?
Pardon?
ಈಗ ಎಲ್ಲಿಗೆ ಮಾಡಿದ್ದಾರೆ?
Vijaypur, my lord.
ವಿಜಯಪುರ್ ವಾಟ್? ಕೆನರಾ ಬ್ಯಾಂಕ್.
Vijaypur Canara Bank, regional office Canara Bank.
That's in Canara Bank only.
Please, my lord. But within a there is a no consistent, my lord. Within a 15 days, my lord, he has a transfer to the Vijaypur, my lord.
ನಿಮ್ಮ ಗೈಡ್ಲೈನ್ಸ್ ಎಲ್ಲಿ ತಗೊಳ್ಳಿ.
As per the guidelines, Annexure J, my lord. He comes under the physical disability, my lord.
Oh, you disabled candidate.
Page number 26, Annexure J in my rejoinder, my lord.
Rejoinder.
Rejoinder, my lord. In a rejoinder dalli ನಾನು ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. Page 26, my lord. A person with a disability or 7th, my lord, 7 and 8, my lord. A person with a disability or a caregiver of a dependent with a benchmark disability may be exempted.
What is your disability?
Fracture of a hand, my lord.
Fracture.
Please,
sir, certificate ಅಲ್ಲಿ ಕೊಡಿ.
Please.
Fracture is an injury, not disability. ಅದರಿಂದ ಏನಾಗಿದೆ ಕೊಡಿ.
Disability certificate of.
50%.
50% disability.
ಆಯ್ತು.
Clause 7 and 8, my lord, Annexure J.
Wait. Yes, sir.
Now, since he's been, because of this disablement or whatever it is, he's been kept in Karnataka, though he was entitled to be transferred anywhere in India, he's never been transferred out of Karnataka, all these age of service, lordship. Hence, now the exigency because of that theft in Vijapura, divisional manager is suspended there, and some divisional manager was required, and he was the person who was repatriated back to the head office. From there, because of that exigency, because there was no divisional manager there, and he being scale 4, that is the employee was been, except him, there was no other divisional manager who could have been put in that place. Because
it's a countrywide post.
Pardon, lordship?
Anywhere from the country can be.
He could be posted because of.
He could be posted.
Or any person for that matter. But because there was exigency, all the other divisional manager were already been posted, and he was deputed back. Interim order. Vacating ಹಾಕಿದೆ ಅಂತ.
ಆಯ್ತು. ಈಗ ಡಿವಿಷನಲ್ ಮ್ಯಾನೇಜರ್ ಯಾರು ಇದ್ದಾರೆ ಅಲ್ಲಿ?
ಅಲ್ಲಿ
ಯಾರು ಇಲ್ವಾ?
ಯಾರು ಇಲ್ದು ಸಾಹೇಬ್ರು. ಈಗ
ಇದ್ದಾಗ ಏನ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ?
ಈಗ that is the problem. Every day I am pursuing that some person to be deputed.
What someone there? Why only him?
No, because everybody has been regular transfer ನಲ್ಲಿ they have occupied.
Bangalore ಬೇಕಾದ divisional manager.
ಇದಾರೆ ಶಾರ್ಟ್ ಇದೆ.
ಯಾರು ಶಾರ್ಟ್ ಇದೆ?
Divisional manager.
SMGS 4 is divisional manager, senior management grade scale 4. ಮತ್ತೆ ತರಕ್ಕೆ ಏನಂತೆ?
ಅಲ್ಲ, because of that, since this post ಈಗ ಯಾರಿಗಾರ
only a disabled employee.
Disabled employer ಅಂದ್ರು right now because of that merger, he was an excess and he has been transferred there. Otherwise all the divisional manager are already posted.
Excess where?
ಇಲ್ಲಿನ ಧಾರವಾಡಲಿಂದ ಪೇರೆಂಟ್ ಇದಕ್ಕೆ ಕರ್ಸಿದ್ರು.
ಕಳಿಸಿದಾರಾ?
ಇಲ್ಲ, ಬಿಕಾಸ್ ಆಫ್ ಮರ್ಜರ್ he was sent back to parent, and the excess in the sense he was sent back there and he had to be allocated some work, and right now because of that theft case Bijapura was vacant, he's been sent there. That was the reason he's been sent there. Otherwise there was no other exigency for him to be sent there. Because of that, and regarding transfer, our one annexures they have filed G is not applicable anta, as per my
Not applicable.
annexure G. G is only for the directors, executive general managers, not for scale 4.
ಯಾವುದು G?
Annexure G with rejoinder ಹಾಕಿದ್ದಾರೆ.
Rejoinder, page number 10.
Page number 10.
ಓ ಇದಾ?
ಹೌದು. ಇದು
policy of appointment, chairman, executives, directors, board, deputation of
divisional managering ಬರಂಗಿಲ್ಲ. ನಾನು
managers to RRBs.
ನಾನು annexure R1 ಹಾಕಿದ್ದೇನೆ.
How is this applicable to you?
Annexure R1 is for Canara Bank officers service regulation.
ನೀವು ಜನರಲ್ ಮ್ಯಾನೇಜರಾ?
General manager.
You are located
not
general manager?
Please.
SMG is 4.
Divisional manager.
You can't be general manager. Which cadre are you in?
4.
Fourth one.
SMG is 4 is not general manager.
Fourth, my lord. It is comes under fourth, my lord.
That's divisional manager ಅಷ್ಟೇ.
ಹೌದು. Sorry. Division.
Yes, MMGS 3 ಆದ್ಮೇಲೆ SMGS 4 ಬರೋದು. Yes. But this policy of disabled employees transfer, equal opportunity policy, that is applicable. Correct.
If at all that is
No,
within the
this is for all
Karnataka,
the
it's not.
employees. Annexure J, page 25 in the rejoinder is for all the employees.
All the.
Correct. So that says a person with disability with benchmark disability may be exempted from routine exercise of transfer,
but
subject to administrative constraints.
Administrative constraint ಈಗ ಬಂದಿದ್ದ ಎಮರ್ಜೆನ್ಸಿ ಆಗಿದೆ. Otherwise we would not, in regular transfer ಟೈಮಿಗೆ we can reconsider. ಈಗ clause 6 ಒಳಗೆ ಅದೇ annexure J ಒಳಗೆ clause 6 ಒಳಗೆ B, clause B, sub clause B, reference in place of posting at the time of transfer promotion to the person with disablement as far as possible and subjected to the administration constraint.
ಇದನ್ ಕೇರ್ ಗಿವರ್ ಮಾತ್ರನಾ ಅಥವಾ ಎಲ್ಲರಿಗೂ?
ಕೇರ್ ಗಿವರ್ ಓನ್ಲಿ.
ಕೇರ್ ಗಿವರ್ ಮಾತ್ರ.
ಹೌದು.
ನೀವು ಯಾರು ಕೇರ್ ಗಿವರ್?
That is, my lord, the petitioner's son is the petitioner's son, my lord, is studying in Bangalore. Bangalore ಅಲ್ಲಿ ಹೌದು.
ಈಗ 15 ದಿವಸ
after transfer to the my lord.
15 ದಿವಸದಾಗ ಆಗಿಲ್ಲ ಸರ್.
ಇನ್ನು 15 days my lord. ಇನ್ನು ಸ್ಕೂಲಿಗೆ ಅಡ್ಮಿಷನ್ ಕೂಡ ಇದ್ದಾನಾಗಿಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಇನ್ನು ಸ್ಕೂಲ್ ಅಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಕೂಡ ಇದ್ದಾನಾಗಿಲ್ಲ. ಸಡನ್ ಆಗಿ ಬಿಜಾಪುರ್ಗೆ ಅವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ ಅದು.
Yes sir. Disabled employee.
ಇಲ್ಲ ಡಿಸೇಬಲ್ಮೆಂಟ್ ಆದ್ರೂ ಕರ್ನಾಟಕ ಬಿಟ್ಟು ಅವನಿಗೆ ಎಲ್ಲಿಯೂ ಹಾಕಿಲ್ಲ ಸಾಹೇಬ್ರ. ನಾರ್ತ್ ಇಂಡಿಯಾಗೆ ಹಾಕಿದ್ದು, ಬಟ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಡನ್ ದಟ್ ಬಿಕಾಸ್ ಆಫ್ ವಿ ಹ್ಯಾವ್ ಟೇಕನ್ ದಟ್ ಕೇರ್ ದಟ್ ಅಂಡ್ ಬಿಜಾಪುರ ಎಕ್ಸಿಜೆನ್ಸಿ ಇರೋ ಈಗ ಥೆಫ್ಟ್ ಆದ್ಮೇಲೆ ನೋಬಡಿ ಇಸ್ ಸಸ್ಪೆನ್ಷನ್ ಆಗಿದ್ದಾರೆ ಡಿವಿಷನಲ್ ಮ್ಯಾನೇಜರ್. ಈಗ ನಮಗೆ ನೆಸೆಸಿಟಿ ಇದೆ ಸಾಹೇಬ್ರಲ್ಲಿ. ಸೊ
ನಿಜ, ಬಟ್ 15 ದಿವಸದಲ್ಲಿ ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಮಾಡಿರೋದು ಈಗ ನಿಮ್ಗೆ?
ಫ್ರಮ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಟು ವಿಜಯಪುರ್ ರೀಜನಲ್ ಆಫೀಸ್.
ಮತ್ತೆ ಇಲ್ಲೇ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
He resides, my lord, in Dharwad. His family and all are resides here, my lord.
15 days ಅಲ್ಲಿ ಬ್ಯಾಂಗ್ಳೂರ್ಗೆ ಹಾಕಿದ್ರಾ?
ಬ್ಯಾಂಗ್ಳೂರ್ ಹಾಕಿದ್ವಿ.
ಇಲ್ಲಿ ಕ್ಲೋಸ್ ಆಯ್ತು ಬಿಕಾಸ್ ಮರ್ಜರ್ ಲಿಂದ. ಅವನು ಪೇರೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕರೆಸ್ಕೊಂಡ್ರು.
ಅಷ್ಟೇನಾ?
That is the major because of the exigency where we don't have any other.
The petitioner is before this court calling in question an order dated 21/6/2025 by which the petitioner is transferred from Bangalore to Bijapur to head the division as a divisional manager. Heard so and so. Facts in brief, Germain, are as follows.
May until some arrangement is on, at least for the time being, let him go and report there.
ಈಗ ಸ್ಟೇ ಇದೆಯಲ್ಲ
ಅದೇ ಸ್ಟೇ ಇದೆ because
ಸ್ಟೇ ಕೊಟ್ಟು ಎಷ್ಟು ತಿಂಗಳಾಗಿದೆ?
ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
2 months, sir.
2 months ಆಗಿದೆ.
ಅದೇ
2 months ಇಂದ ಏನ್ ಮಾಡಿದ್ರಿ ಅಲ್ಲಿ? ಯಾವ ಅರೇಂಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ 2 months ಇಂದ?
2 months ಈಗ ಎಲ್ಲರಿಗೂ ರೆಗ್ಯುಲರ್ ಟ್ರಾನ್ಸ್ಫರ್ದಾಗ ಆಕ್ಯುಪೈ ಮಾಡಿಬಿಟ್ಟಿದೆ. ಎವ್ರಿಬಡಿ ಇಸ್ ಬಿನ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್.
2 months ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Because of nobody has been transferred, that is true. But ಈಗ ನಮಗೆ ಎಮರ್ಜೆನ್ಸಿ ಇರೋದ್ರಲ್ಲಿಂದ ಈಗ ಅಲ್ಲಿ ಬೇಕೇ ಬೇಕಾಗಿದೆ.
Petitioner is heard so and so. The petitioner is an employee of the respondent Canara Bank, hereinafter referred to as the bank for short. After having joined the service, the petitioner has risen to higher echelons of office, ECHEOLEN, echelons of office, and is presently in the cadre of senior management grade scale 4 and is working as divisional manager. The issue in the list does not pertain, the issue in the list pertains to the deputation or transfer of the petitioner. The petitioner, while working in, after having been promoted as senior management grade scale 4, is deputed from Canara Bank to Karnataka Vikasa Gramina Bank on 2/5/2023. The deputation, in terms of the rules of deputation, was for a period of 3 years. The petitioner, before the expiry of 3 years, is brought back to Canara Bank on 19/4/2025. The bringing back of the petitioner to Canara Bank is cancelled by a subsequent order dated 15/5/2025. In the interregnum, what transpires is Karnataka Vikasa Gramina Bank and other regional rural banks merge and form Karnataka Gramina Bank. Therefore, Karnataka Vikasa Gramina Bank ceased to be in existence. On 2/6/2025, the petitioner is repatriated to Canara Bank after the cancellation on 15/5/2025. Thus, the petitioner comes back and reports to Canara Bank at Bangalore. Barely 14 days thereafter, the petitioner is again now not deputed but transferred on 16/6/2025 from Bangalore Divisional Office to Bijapur Divisional Office. It is this that is called in question in the subject petition. The learned counsel appearing for the petitioner would reiterate the grounds that are set out in the petition, contending that the petitioner is made to move from office to office, post to post, right from 2/5/2023 till the impugned order of transfer dated 16/6/2025. The learned counsel takes this court through the documents appended to the petition to demonstrate that the petitioner suffers from disability, suffers from a benchmark disability to the tune of 50%. And therefore, he is exempted from routine transfers unless administrative exigencies would ensue. Therefore, would submit that the transfer now made barely 15 days of him reporting to Bangalore is contrary to the policy, which policy in particular with regard to the disabled employees. Per contra, the learned counsel appearing for the respondent would again take this court through the statement of objections to contend that the rules or the regulations on guidelines on which the petitioner is seeking to place reliance upon is not applicable to employees. It is only from the general managerial cadre and above. The petitioner, being an employee or an officer in the Canara Bank, is susceptible to transfer, as transfer is an incidence of service. The petitioner, being a disabled employee, is of no avail, as he has not been transferred anywhere outside the state of Karnataka. He has been shown indulgence to be kept only in Karnataka, But since there is administrative exigency in Bijapur, as as theft had happened in a branch in Bijapur, lack of appropriate divisional manager would create serious problem, is the submission of the learned counsel appearing for the respondent. He would in all seek dismissal of the petition, directing that the petitioner should report to contending that the petitioner should report to duties to the transferred place. I have given my anxious consideration, so on so on. The afore narrated facts are not in dispute. The service of the petitioner in the bank need not be reiterated. It is necessary to notice certain dates and events. On 2/5/2023, the petitioner, in terms of the policy of deputation, is deputed from Canara Bank to Karnataka Vikasa Gramina Bank. The policy of deputation, comma, is an admitted fact, comma, that it is the deputation once made would be for a period of 3 years. Correct, Radha?
3 years. But ಇದರಲ್ಲಿ Canara Bank, he was in the circle office Hubli 2 years earlier. ಇಲ್ಲ ಅಲ್ಲಿಂದ 3 years ಇಲ್ಲೇ. So 5 years complete ಆಗಿದೆ.
No problem, don't worry. Yes, sir. Canara Bank or Gramina Bank? Yes, early.
ಇಲ್ಲ ಅದೇ.
We will answer that also.
Please,
Yes,
please.
yes. The ಏನಿದೆ ಮೇಡಮ್? In terms of the policy of deputation, was deputed for a period of 3 years, but an order comes to be passed on 19/4/2025, bringing the petitioner back or repatriating to Canara Bank even before the expiry of 3 years on a specious plea that the petitioner was earlier within the Canara Bank. That also would count for the period of deputation. Be that as it may, that is not the issue in the case at hand. The issue in the case at hand. The said order of 14/4/2025 comes to be cancelled on 15/5/2025. The petitioner comes to be cancelled 15/5/2025 on the score that Karnataka Vikasa Gramina Bank ceased to be in existence as it gets merged with other regional rural banks to one regional rural bank hyphen the Karnataka Gramina Bank. Therefore, the Karnataka Gramina Bank, the petitioner who is an employee of the Canara Bank, a sponsor bank to the Karnataka Vikasa Gramina Bank, is bought back to Canara Bank on 2/6/2025. Therefore, the drill of dates are this way. On 2/5/2023, the first order. On 19/4/2025, the repatriation order. On 15/5/2025, the cancellation of repatriation. On 2/6/2025, the repatriation order. If things would stand thus, there would have been no, the situation would have been altogether different. 15 days thereafter comes the impugned order. The impugned order transfers the petitioner from Bangalore to Bijapur. The petitioner now rushes to this court, calling in question the said order. The contention inter alia of the petitioner is that the policy guidelines with regard to equal opportunity for financial year 2025-26 protects a disabled employee from repeated transfer. The relevant clause is as follows. Clause 7. Clause 7. The policy is enunciated by the Canara Bank, which is directed to be followed by the Commissioner of Disabilities, which in terms of the statute has a power to direct adhering to the policy. The Government of India, in terms of its office memorandum, also directs adhering to the policy. A relevant portion of the government order in office memorandum, insofar it is germane, reads as follows. Page 33 of the rejoinder. On a conjoint reading of the policy and the government office memorandum, which directs adherence to the policy, what would unmistakably emerge is that the petitioner is being shifted repeatedly on a routine exercise, notwithstanding his protection of being a disabled employee. Next. Transfer, comma, is trite, comma, an incidence of service. The incidence is always regulated either by statute or the orders depicting guidelines. The guidelines in the case at hand, though, is applicable to the general managerial level. The policy with regard to the disabled employees would become applicable to the case of the petitioner. The petitioner was brought back to Bangalore on 2/6/2025 and 15 days thereafter is now moved from Bangalore to Bijapur. It would undoubtedly be contrary to the policy with regard to the treatment of disabled employees in an organization. The petitioner is a disabled employee, is not in dispute. The policy being applicable to the bank is not in dispute. And if the policy is applicable, the transfer of the petitioner from Bangalore to Bijapur would undoubtedly be contrary to clause 7 supra. There is an interim order operating in the case at hand. The learned counsel for the respondent submits that there is dire need of a divisional manager at Bijapur. If there was to be a dire need for divisional manager at Bijapur, 2 months of vacuum could have been filled up by the respondents. They have not done so. Therefore, the exigency that the respondents project, the need for a disabled employee to go from Bangalore to Bijapur, is unacceptable. In that light, the petition deserves to succeed. For the aforesaid reasons, the following order.
Humble sir, there are already 3 divisional managers in Bijapura circle, but out of that, 1 is vacant. 2 are looking after, which is becoming heavy on them. The workload is.
No problem.
Other,
Manage it, yes.
ಯಾರು ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ
that's correct ಮಾಡ್ತೀನಿ ಬಿಡಿ. For the aforesaid reasons, the following order. Allowed, quashed all consequential benefits that would flow from the quashment of the order. That the petitioner shall be entitled to all consequential benefits that would flow from the quashment of the order. Yes, next. Right.
This is transfer matter. Teacher working in Karnataka rural
ಎಷ್ಟು ವರ್ಷ 8 ವರ್ಷದಿಂದ ಅಲ್ಲೇ ಇದ್ದೀರಾ?
ಇಲ್ಲ
ಇನ್ನೇನು?
ಇಲ್ಲ lordships may kindly see
Yes,
10/7/2.
Yes, I am for the third respond.
ಏನಾಗ್ಬೇಕು ಸರ್? ಟೈಮ್ ಬೇಕಾ?
10/7/23 I was here. 10/7/23 I was posted to this as a principal. Then
ಎಸ್ ಮೇಡಮ್, ನನ್ನ ಕೇಳಿದ್ದೆ ನಿಮಗೆ ಅಂತ. ಇದಲ್ವಾ?
ಅದೇ ಸರ್.
ಪ್ರಿನ್ಸಿಪಲ್.
Yes.
Plus. Yesterday what?
ಅದು ಬೇರೆ ಮ್ಯಾಟರ್.
What was submitted was annexure R2 page 13 statement of objections.
ಈಗ ಹೇಳಿ ನಿಮ್ಮ ಡೇಟ್ಸ್ ಹೇಳಿ.
Yes, this is a case where principal has been transferred, Karnataka residential education institutions. Your lordships may kindly see 10/7/2023 was the date on which I was posted as a principal in the present school. A synopsis nalli second item number 2.
ಫಸ್ಟ್ ಹೇಳಿ ಸರ್ ಆಮೇಲೆ. ಎಸ್.
And 14/7/2023 I have been transferred.
14/7.
Yes.
ಎಲ್ಲಿಗೆ?
36/2025 I have been transferred. Sorry, 36/2025. From Nargund to Haveri I have been transferred. Now as per the transfer guidelines of Karnataka residential education institutions, minimum retention period is 5 years.
ಅಲ್ಲ, ಅದು ಗವರ್ಮೆಂಟ್ ಗೈಡ್ಲೈನ್ಸ್ ಫಾಲೋ ಮಾಡಬೇಕು ಅಂತ.
ಗವರ್ಮೆಂಟ್ ಗೈಡ್ಲೈನ್ಸ್ ಫಾಲೋ ಮಾಡಿದೀವಿ ಅಂತ there is a circular is what they say, annexure R2 page 13. But annexure R2 page 13 also does not do away with the requirement.
Counseling.
Sorry?
Does not do away with counseling.
Counseling, yes, para 2. ಉಲ್ಲೇಖ 2ರ ಈ ಕಚೇರಿ ಏಕ ಕಡತದಲ್ಲಿ ಕೌನ್ಸಿಲಿಂಗ್ ಮುಖಾಂತರ ವರ್ಗಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಳ್ಳಲು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿತ್ತು. ಕಡತದಲ್ಲಿ ಸರ್ಕಾರ ವರ್ಗಾವಣೆ ಮಾರ್ಗಸೂಚಿ ಸಂಖ್ಯೆ so ಗ್ರೂಪ್ ಎ ಮತ್ತು ಗ್ರೂಪ್ ಬಿ ವೃಂದ, ಐ ಆಮ್ ಗ್ರೂಪ್ ಬಿ ವೃಂದದ ಸಿಬ್ಬಂದಿಗಳ ಕುರಿತು ಹಾಗೂ ಗ್ರೂಪ್ ಸಿ ಮತ್ತು ಗ್ರೂಪ್ ಡಿ ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳ ಕೌನ್ಸಿಲಿಂಗ್ ಮೂಲಕ ಸರ್ಕಾರದ ನಿಯಮಗಳಂತೆ ವರ್ಗಾವಣೆ ಕೈಗೊಳ್ಳಲು ಅರ್ಜಿ ಆಹ್ವಾನಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. ಕೌನ್ಸಿಲಿಂಗ್ ಇಸ್ ನಾಟ್ ಡನ್ ಅವೇ ವಿತ್.
ಈಗ ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ?
ಸ್ಟೇ ಇದೆ.
ಎಲ್ಲಿ ವಿಚ್ ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್? ಅದು ನಿಮ್ ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್ ಅಲ್ವಲ್ಲ. Not the 7/6/2013 guidelines or the subsequent guidelines that are issued. ಯಾರು R3 ಯಾರಿಗೆ?
R3, I am appearing for, you will ask, kindly see, my lord, my application for vacating the interim order.
Yes, sir. ಹೇಳಿ.
Page number 2, my lord, your last kindly, page number 2, para 4, my lord. My lord, no, the petitioner, my lord, she was promoted as a principal on 31/5/2012 and posted to Haveri. My lord, thereafter, my lord, on 5/7/2016, my lord, she has been transferred to Benkanakoppa, district Gadag. That is on 5/7/2016. Thereafter, my lord, on 10/7/2023, she has been transferred to Kaniginahar. She was working. And she was not reported for duty.
Where?
At the place where, my lord, she is claiming to be there.
Then
And
where was she?
She was there in Benkanakoppa. And now yet, without reporting the duty, my lord, again, my lord, on 14/7/2023.
Government change ಮಾಡಿದ್ರಲ್ಲ. ಆಮೇಲೆ?
It has not been changed, my lord. Again, she has reported the duty at Benkanakoppa. Now, from 5/7,
wait,
from 5/7/2016 till the present transfer order, that is on 13/6/2015, 25, she has not transferred. She was working in the same place more than 8 years.
8 ಹೆಂಗಾಯ್ತು? 17 ಇಂದನಾ?
16 ಇಂದ, 16 ಇಂದ.
16 ಇಂದ ಬೆನಕಿನಕೊಪ್ಪಲ್ಲೇ ಇದ್ದಾರಾ?
ಬೆನಕಿನಕೊಪ್ಪದಲ್ಲೇ ಇದ್ದಾರೆ, ಎಲ್ಲಿ ಹೋಗಿಲ್ಲ. From
10/7/2023 ಎಲ್ಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಯ್ತು?
10/7/2023 ಗದಗ್ ಶಿವರತ್ನ ಕ್ಯಾಂಪಸ್.
ಅಲ್ಲಿಗೆ ಹೋಗ್ಲಿಲ್ವಾ?
ಹೋಗಿದ್ದೆ. From there, mutual request ಮೇಲೆ 14/7/23 was transferred to Nargund Benkanakoppa.
14/7/2023
on mutual transfer request.
4 ದಿನಕ್ಕೆ.
mutual transfer.
ಆಯ್ತು, 4 days.
Yes.
So ವಾಪಸ್ ಬೆನಕಿನಕೊಪ್ಪಗೆ you come.
ಹೌದು.
So where you were from 2016?
Please.
2016. 2016, my lords, I was in. Yes, Benkanakoppa.
ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
ಇಲ್ಲ, but transfer, my lords, your lordships kindly.
ಪಕ್ಕ ಮನೆ ಕಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, one submission. For 10/7/23 I was transferred. I went to that job, I joined there.
Correct. 4 days ಗೆ ವಾಪಸ್ ಬಂದ್ರಲ್ಲ?
By way of a mutual transfer.
Correct. 4 days ಗೆ ವಾಪಸ್ ಬಂದ್ರಿ?
Yes.
So 2016 ಇಂದ 20 ಈಗ ಲೇಟೆಸ್ಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ವರೆಗೂ you have been in ಬೆನಕಿನಕೊಪ್ಪ.
Yes.
ಅಲ್ವಾ?
Now I have been posted.
Anything else?
This will still be a fresh transfer itself, my lords.
Anything else?
Only is the minimum retention period is not completed.
Minimum retention period ಎಲ್ಲಿಂದ ಬಂತು ಸರ್?
ಅಲ್ಲ, post 10/7 or 14/7 minimum retention period ಇಲ್ಲ.
ಯಾಕೆ?
14/7 is also a transfer. 14/7 transfer ನಂತರ 10/7 mutual transfer.
10/7 ಆದ್ಮೇಲೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದ ಆರ್ಡರ್ ಕೊಡಿ. Show me you reported to the transferred place.
Mutual transfer ಆಗಿದೆ.
ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ ಕೊಡಿ ಸರ್. If you say transfer ಅಂತಂದ್ರೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ ಕೊಡಿ.
Annexure B, your lordships kindly see.
Where is the charge? CTC ಎಲ್ಲಿದೆ? Charge taking certificate.
ಅಲ್ಲ, ಚಾರ್ಜ್ ತಗೊಂಡ್ರ ನಂತರನೇ I'll be permitted to take mutual transfer.
So without reporting to that place, you took mutual transfer, stayed at Benakinakoppa.
Page 19.
Continued to stay in Benakinakoppa.
Page 19, government order. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ
ಈಗ ಎಲ್ಲಿಗೆ ಹಾಕಿದ್ದಾರೆ?
ಈಗ ಹಾವೇರಿ, out of district.
It's not Haveri. Now she has been transferred to Koppal district.
Koppal, sorry, Koppal district.
ಯಾವಾಗ ಹೋಗ್ತೀರಾ?
ಅಲ್ಲ, annexure page 19 ಒಂದ್ ಸ್ವಲ್ಪ, if your lordship.
Yes sir.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಶ್ರೀ ಡಿ.ಬಿ. ಅಡವಿ ಪ್ರಾಚಾರ್ಯ ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆ ಸೊ ಅಂಡ್ ಸೊ ತಾಲೂಕು ನರಗುಂದಿ ಅವರಿಗೆ ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆ ಕನಗಿನಹಾಳ್ ತಾಲೂಕು ಇಲ್ಲಿಗೆ ಹಾಗೂ ಶ್ರೀಮತಿ ರೂಪಾ ಎಸ್ ನಾಯ್ಡು ಪ್ರಾಂಶುಪಾಲರು ಸೊ ಅಂಡ್ ಸೊ ದಟ್ ಇಸ್ ಪಿಟಿಷನರ್ ಶಾಲೆಗೆ ಗದಗ್ ಜಿಲ್ಲೆ ಇವರ ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆ ಬೆನಕನಕೊಪ್ಪ ಪ್ರಾಂಶುಪಾಲ ಹುದ್ದೆಗೆ ಪರಸ್ಪರ ನಿಯೋಜನೆಗೊಳಿಸಿ ಆದೇಶಿಸಿದೆ. There was a mutual transfer. One employee from there came here, I went from here to there. In effect,
ಕೇಳ್ತಿರೋದ 10th ಆದ್ಮೇಲೆ ನೀವು ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ಆರ್ಡರ್ ತೋರಿಸಿ.
ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರ ಅದರಲ್ಲೇ ಪೇಜ್ 18 ನಲ್ಲೇ ದಟ್ ಇಸ್ ದೇರ್, ಐ ಹ್ಯಾವ್ ರಿಪೋರ್ಟೆಡ್ ಅಂತ.
ಯಾವ 18 ಅಲ್ಲಿ?
ಅದೇ annexure C page 18 ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್. ಫಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಫೋರ್ತ್ ಲೈನ್, ಫಿಫ್ತ್ ಲೈನ್. ಹಾಗೂ ಶ್ರೀಮತಿ ರೂಪಾ ಎಸ್ ನಾಯ್ಡು ಪ್ರಾಂಶುಪಾಲರು ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆ ಬೆನಕನಕೊಪ್ಪ ತಾಲೂಕ್ ನರಗುಂದ್ ಗದಗ ಜಿಲ್ಲಾ ಇವರಿಗೆ ಪ್ರಾಂಶುಪಾಲರು ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ಶಾಲೆ ಕನಗಿನಹಾಳ ಇಲ್ಲಿಗೆ ವರ್ಗಾವಣೆಗೊಳಿಸಿ ಆದೇಶಿಸಿದ ಪ್ರಯುಕ್ತ ವರ್ಗಾವಣೆಗೊಂಡ ಸ್ಥಳಕ್ಕೆ ಈಗಾಗಲೇ ಸದರಿ ಪ್ರಾಂಶುಪಾಲರು ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗಿದ್ದಾರೆ.
ಸದರಿ ಯಾರು?
ನಾನೇ, ರೂಪಾ ಎಸ್ ನಾಯ್ಡು. ಐ ಹ್ಯಾವ್ ರಿಪೋರ್ಟೆಡ್ ದೇರ್.
ಸದರಿ ನೀವಲ್ಲ.
ಅಲ್ಲ, ನಂದೇ ಹೆಸರಿದೆ ನೋಡಿ ಅಲ್ಲಿ.
ಸದರಿ ಮ್ಯೂಚುವಲ್ ಇನ್ನೊಬ್ರು.
ಐ ವಿಲ್ ರೀಡ್ ಒನ್ಸ್ ಅಗೇನ್ ಇಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್. ನಾನೇ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಆಗಿದ್ದೀನಿ. ಆಫ್ಟರ್ ರಿಪೋರ್ಟಿಂಗ್ ಇಟ್ ಸೆಲ್ಫ್ ಮ್ಯೂಚುವಲ್ ಟ್ರಾನ್ಸ್ಫರ್.
ಆಮೇಲೆ 4 ದಿನ. ವೆರಿ
yes, but
very powerful principle.
That is also not
I have
permissible by
reported
virtue of annexure R2, my lord. That is also not permissible, my lord. You'll also kindly see, my lord, annexure R2.
Permissible.
Annexure R2, my lord. There is a circular issued by the second respondent, and that has not been followed also.
So what is not permissible?
What my learned friend is submitting, my lord, reported and again comes back to the Benkanakoppa.
Fact remains that not counseling is not done. Fundamental issue. If there was counseling done and if I had submitted an application for transfer, question is altogether different.
Mutual ಮಾಡ್ಬೇಕಾದ್ರೆ counseling ಮಾಡ್ಬೇಕಾಗಿಲ್ವಾ?
Mutually counseling ಇಲ್ಲ. Under the guidelines itself, there is no requirement of counseling.
Very smart.
Very fundamental aspect, my lords, counseling. Even government order mandates counseling.
Counseling ಯಾಕೆ ಮಾಡಿಲ್ಲ? ನೀವು ಮಿಕ್ಸ್ ಮಾಡಬೇಡಿ ಮೇಡಮ್. ಈ ಟೀಚರ್ಸ್ಗೆ ಸಪರೇಟ್ ಗೈಡ್ಲೈನ್, ಇದಕ್ಕೆ ಸಪರೇಟ್ ಗೈಡ್ಲೈನ್ಸ್ ಇದೆ. ಮಿಕ್ಸ್ ಮಾಡಿ ಮತ್ತೆ ಇನ್ನೊಂದು ರೌಂಡ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಬೇಡಿ. ಸ್ಟೇಟ್ ಜನರೇಟ್ ಸೋ ಮಚ್ ಆಫ್ ಲಿಟಿಗೇಷನ್. ಇದು ಮರ್ಯಾದೆಗೆ ಇತ್ತಾನೆ, ಯಾವುದು ಕೌನ್ಸಿಲಿಂಗ್ ಇತ್ತು. ಇದು ಯಾಕೆ ಮಿಕ್ಸ್ ಮಾಡಬೇಕಾಗಿತ್ತು? ಈಗ ಗೌರ್ಮೆಂಟ್ ಗೈಡ್ಲೈನ್ಸ್ ಫಾಲೋ ಮಾಡಿ ಇದು ಮಾಡಬೇಡಿ. ಯಾರೋ ಒಬ್ರು ಬರ್ತಾರೆ, ಏನೋ ಕೇಳ್ತಾರೆ ಅಂತ ಒಂದು ಸುತ್ತೋಲೆ. ಸಾಕು, 8 ವರ್ಷ. ಅಂದ್ರೆ ಕೊಪ್ಪಳಲ್ಲೂ ದೇರ್ ಆರ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಹೂ ನೀಡ್ ಯು ಇನ್ ಕೊಪ್ಪಳ ಆಲ್ಸೋ.
ಅಲ್ಲ, only contention is this. Beyond this I leave to the
counseling ಮಾಡಿಲ್ಲ ನಿಜ, ಬಟ್ why do you do this? I don't understand. Now you're there for the last 9 years. ಬೇರೆಯವ್ರಿಗೂ ಅವಕಾಶ ಕೊಡಿ.
If transfer order is upheld, my lords, only contention is whether counseling was mandatory or not.
We'll see. That's a little difficult to
annexure R2.
R2 your matter of problem, sir. R2 state matter of problem. Government guidelines follow ಮಾಡಬೇಕು ಅಂತ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, R2 ದಲ್ಲಿ ಏನು ಹೇಳುತ್ತಂದ್ರೆ, the district authorities have to brought to the notice of the R2 before no year, making arrangement of no year deputation.
No, tomorrow I'll dictate. Yes,
please.
Yes, tomorrow.
Interim order may kindly
Number 10. Your Lordship, I seek a short accommodation, my lord, in this matter. I appear for the petitioner.
Senior has come from Bangalore.
Yesterday they have served.
There is an interim order, my lord, sir.
Which I could not go through.
ಅಲ್ಲಿ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
Judgments, citations.
Citations you want to go through?
Yes.
ಅದರಲ್ಲಿ ಒಂದು ಅವರು ಟೈಮ್ ತಗೊಂಡು ತಗೊಳ್ಳಿ. Lords, in 105242, stay is in respect of the entire notification, though the writ petition is filed in respect of only one survey.
Yes, Archana madam.
That may be modified.
It is only insofar as petitioner is concerned, my lord. I am before this.
Clarify that.
Yes.
That can be done. Monday or Tuesday, the matter may be taken up.
I'll take it. Yes. We heard the learned counsel, Srimati Archana Magdum, appearing for the petitioner, and the learned senior counsel, Basaraj Shabrad, representing the respondent board. The learned counsel for the petitioner submits that the list of authorities and other documents are served upon the petitioner only yesterday, date haki, and therefore would seek time to go through the same and make her submissions on, and would seek time to the 4th of Tuesday?
Please, ma'am.
To the 4th of November 2025. The learned senior counsel submits that though the petitioner's claim, ಎಷ್ಟು ಇವ್ರದ್ದು?
2 acres in survey number 81/4 in WP number 105242.
2 acres in
My lord, 81/4.
The learned senior counsel submits that though the petitioner's claim is only with regard to their land, the entire notification, the entire acquisition process is stayed at the hands of this court. The learned counsel appearing for the petitioner submits that the interim order could be modified restricting the interim order to the case of the petitioners only and not to the entire acquisition. Therefore, the interim order so granted shall stand restricted only to the claim of these petitioners and the subject property of these petitioners as is averred in the petition. The aforesaid clarification. Interim order is continued subject to the aforesaid clarification. List the matter on 4th.
10/5242, my lord. In that petition, this clarification is required.
ಯಾವ್ದದು 10
Connected matter.
10.1 ಇದು 10.1 ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು ರವಿ ಇದೇನ್
In 10, my lord,
stay ಇದೆ ಅದು ಪರ್ಟಿಕ್ಯುಲರ್ ಸರ್ವೆ ನಾಟ್ ಟು ಡಿಸ್ಪೋಸಸ್ ಅಂತ ಇದೆ ಅಂತೆ ಅದೇನು ತೊಂದರೆ ಇಲ್ಲ.
All right, then we'll have it on 4th. Yes.
Grateful.
Appearing for the petitioner.
ಈಗ ತಗೊಂಡಿಲ್ಲ ಅವರು.
The annexure B, my lord, in respect
Some
of
instructions are
rowdies.
required. That's the rowdy sheeters case. Instructions makes on war time.
ಈಗ ಎಲ್ಲ ಅಕ್ವಿಟ್ ಆಗಿದ್ದೀರಾ?
ಎಲ್ಲ acquit ಆಗಿದೆ ಸ್ವಾಮಿ. I am based on their notice, my lord, I submitted a representation. In every date has been mentioned on the what date, my lord, I have been acquitted.
Yes. Based on the learned counsel for the petitioner submits that the name of the petitioner is drawn in the list of rowdies or continued to be in the list of rowdies of which police station?
The last, it is Gangavati.
With the third respondent police station, notwithstanding the fact that the petitioner has been acquitted in all the cases against him, the learned AGA to secure instructions and make his submissions list on Monday in fresh matters.
Yes.
Yes, next.
12, I represent in pleading applicant.
I appear
ಇದು ನೆನ್ನೆದು.
Yes.
ಇದರಲ್ಲಿ ಅಫಿಡವಿಟ್ ಹಾಕಿದೀವಿ, ನಾವು ಹಾಕಿದೀವಿ, ಗೌರ್ಮೆಂಟ್ ನವರು ಹಾಕಿದ್ದಾರೆ.
ಕೋರ್ಟ್ಗೂ ಗೊತ್ತಿಲ್ಲ, ಅವ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ. ಅಫಿಡವಿಟ್ ಅವ್ರಿಗೆ ಮಾತ್ರ ಗೊತ್ತಿತ್ತು.
There was some lord.
You appear to have got it vetted from.
Communication gap.
Language is also same. Language, everything is similar. Just take a look at the facts, my lord. Now, my lord, their case is also saying that yes, we have inadvertently sent it. But now it may be quashed, but I'm more interested.
Maybe quashed.
ಅವರೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ, ಇದು ಏನಾಗಿದೆ ಅಂದ್ರೆ
ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ, ನನ್ನ ಪಿಟಿಷನ್ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ. I just explain, my lord, the facts of the case. Petitioners, my lord, are owners of survey numbers 118, 136 and 137. In all measuring, my lord, 13 acres, 67 guntas. Pursuant to which, my lord, conversion has happened. Thereafter, my lord, we have taken certain permissions for development of the industry. 28(1) came to be issued, preliminary notification, insofar as these properties are concerned, on 18/2/2022. These very survey numbers, my lord, were part of the preliminary notification. Thereafter, my lord, notice was issued. 28(3) order came to be passed by the SLAO, wherein recommendation was made for dropping of these lands. 28(3) came to be passed. That is at, my lord, annexure H, page 110. Challenging 28(3), beneficiary filed a writ petition. There is beneficiary gets the right only after final notification is issued.
28(4) ಆದ್ಮೇಲೆ.
But 28(3) he challenges on the ground that those lands are essential, and court should pass appropriate orders saying that KADB should not drop those lands.
Who is the beneficiary?
Beneficiary, my lord, is the impleading applicant.
Problem sir,
Yes, senior. They are the beneficiary. This honorable court, my lord, passed an order saying that since after 28(3) the matter is pending before the state government, let state government pass appropriate orders as per 28(4). Order came to be passed. Pursuant to that order, my lord, 28(4) came to be passed, wherein my lands, the petitioner lands, were not part of the final notification.
They were dropped.
They were dropped. Now again 28(2) is sought to be issued.
Of the same lands.
On the same lands.
28(2).
Notice is issued saying that now what
after dropping 28(2) agutta
now what they say,
it is not the position.
No. Now what they say, 28-2 is sent inadvertently. It was a mistake on our part. Hence, quash it. We have no objection. Then this is what their affidavit says.
ಸರಿ ಮತ್ತೆ ಅವರೇ ಹೇಳಿದ್ಮೇಲೆ
ಅಲ್ಲ, now my grievance is the now kind of I was more interested in the finding, my lord, to be arrived at before quashing of this petition. For this reason, in the affidavit, my lord, is very clear, saying that they have all the intention to issue 28-4, not by the state government. KIDB itself is pursuing. Once 28-3 has already been issued by KIDB and matter is pending before the state government, KIDB at this instance, the very fact of issuance of 28-2 itself is wrong. And in their affidavit, we clearly say, yes, by mistake we have sent it, but we want to request the state government to issue a final notification to that effect. Now, kindly see 28-4. What happens once application of mine 28-4 is issued? If at all they want to reacquire, they have to again issue a preliminary notification.
That's 28-1.
That is 28-1. They can't go back and issue 28-2. Now, assuming 28-2 goes, they can issue 28 another 28-4 only in cases, my lord, where there is no application of mine, or where there is a stay granted, or there is an injunction order granted. In this case, in these matters at least, there was no stay, no injunction. The matter was only sub judice on the ground that beneficiary had challenged it. Beneficiary
affidavit quash ಮಾಡಬೇಕು ಅಂತ ಹಾಕಿದ್ರೆ ನಮಗೆ quash ಮಾಡಲೇಬೇಕು.
The finding, my lord, is required. For this reason, it may be quashed. It should be quashed. That is my prayer. It should be. That is my prayer. It should be
Their
quashed.
prayer is to be granted ಅಂತ ಅವರೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Now my apprehension is this: they'll make every hectic effort to issue 28-4. That itself is not permissible. That is what the grievance, my lord.
In case the issue, you'll have to come back.
Kindly see, my lord, I'll just produce few judgments.
No, I will record the submissions, nim submissions, but I'll record the affidavit and close it.
So that apart, my lord, when there is already an industry being functioning, kindly see, my lord, I'll just take your lordship to two annexures.
If you want me to then write an order, then we will.
Yes, my lord.
On merits.
Yes. Now kindly see, my lord, what has happened. Now, what has happened, my lord, pursuant to the conversion orders, two permissions have been granted by the concerned authorities for me to set up the industry. Those are part of the petition. Parallelly, my lord, the environmental clearance has been granted to me insofar as setting up the very same industry in these survey numbers are concerned. I have annexed the photographs also, wherein, my lord, the plant is already being set up. Insofar as the impeding applicant is concerned, there was an application made wherein, my lord, their environmental clearance came to be cancelled. I just want to bring that on record. Now, my lord, the reason why they're pushing for this is copy is, my lord, I've served on KIDB. Impeding applicant also will get a copy. Now, kindly see, my lord, this is the environmental clearance, my lord, which was cancelled, my lord, insofar as the impeding applicant is concerned. There's a document number 1, page number 2.
It is cancelled.
Yes, insofar as impeding. Now, why they're making this hectic effort to issue 28-4 is this. Now, what had happened insofar as these lands are concerned, insofar as MSPL is concerned, who are the petitioners, it's a self-acquired property. Adjacent to which there's a plant which is already set up. We are seeking extension of it. Insofar as these very same properties are concerned, based on the beneficiary's request.
When should we?
It should be taken. Yes, it should be taken.
Sorry to intervene. If not, KIDB stand lordship may hear whether they want to withdraw it. Subject to what?
If KIDB is wanting to withdraw it,
that's what they have said in para 13.
No, withdraw the notification.
Impugn notification.
Not notification.
Notice.
It is a notice issued under section 28(2). My lords may kindly permit me to make this statement. My lord, 2022 preliminary notification was issued for acquisition of about 268 acres of land for the benefit of the, my lord, impeding applicant. My lord. Then, after inquiry on 26/5/2022, the Special Land Acquisition Officer passed an order under section 28(3), recommending that the petitioner's land should be excluded from the acquisition proceedings. On the very next day, my lord, he issues a corrigendum deleting that recommendation or modifying that recommendation. That recommendation, my lord, that was made on 26/5/2022 was challenged by the beneficiary of acquisition in a writ petition. In the writ petition, my lords, we made a submission that these two proposals submitted by the land acquisition officer, one for acquisition and one for modification of that recommendation, are pending before the state government, which is the ultimate authority to take a decision for issuance of 28(4). This order was passed on 5/7/2024. My lord, before communication of this order, my lords, the state had already, my lord, issued a final notification excluding these survey numbers. So that was brought to the notice of the Honorable Court. The Honorable Court said that let the government take a decision on the recommendations made by the land acquisition officer, and my lord, it was at that stage that the writ petition was closed. Subsequently, my lord, The government has not taken any decision, but in the meanwhile, beneficiary has not pursued the matter with the state government, and they have sought for a report from the land acquisition officer. At that stage, my lord, the land acquisition officer thinks that it's a direction to issue notice under section 28.2 or redo the matter. That is how, my lord, he has issued notices under section 28.2 as per annexure P. And that is how, my lord, they have challenged the, my lord, notices, which is not issued by mistake or inadvertence. The matter is still pending before the government, and let the government take a decision on the
High
matter.
Court, my lord, passed an order on 5/7/24. The state government to take a decision. State government took a decision and issued a final notification on 9/7/24. Thereafter, KDB council was effectively represented. The government, state government was always a party. After hearing all the parties, my lord, the court passed on the order stating that state government should take appropriate decision. Thereafter, my lord, 9/7 order came to be passed. So, in virtue of that, my lands have already been dropped. The fact that it has already been dropped.
No, but they're withdrawing the notice on 3rd.
The finding is necessary. My lord. These lands cannot even be acquired for this reason.
Lord, what? I don't know.
I'll just
What
complete
kind of
my argument.
submission?
I'll just complete my argument.
Yes,
These lands could not have been acquired for these two reasons. One is, my lord, after application of mine, my lord, the state government has already dropped those lands from acquisition based on the SLAO's report. Point number one. The second point, my lord, is that these lands are already converted for industrial purpose. Already industry running. My lords are aware, my lord, there are two circulars issued by KIDB.
All that is fine. Now they want to, the impugned action that has brought you before the court is a notice issued under 28.2. Now the KIDB says by mistake it is issued, we are withdrawing it. In that, what can I?
Well, the grievance is the finding, my lord, to be
I
arrived
can
at.
record your submissions, I can record their submissions.
My apprehension
But
also, my lord,
ultimately our affidavit court and close them on.
My apprehension is this.
All consequential actions they are entitled to do, then you are entitled to come again. In case there is some action, I can record.
In fact, that liberty was reserved in the previous writ petition itself, my lord.
Previous writ petition.
Liberty, if any order is passed, parties can come before the court.
Where is that?
Lords may kindly take page number 6 of the order passed earlier, which is annexure R1 to the affidavit today. Page number 17, my lord.
17 of the affidavit. Page number 17 of the.
In my petition is at page number 151.
Yesterday filed.
Annexure L.
Affidavit filed yesterday.
Oh, order.
Yes.
Last internal page 6 of the order. Order. Petition is disposed of, last down below. Petition is disposed of in view of the documents produced by the KIDB dated 18/6/2024, whereby the SLO has withdrawn the proposal to drop acquisition proceedings. It is for
ಅಲ್ಲೇ ಡ್ರಾಪ್ ಮಾಡಿದ್ರೆ ಇದು ಕ್ಲೋಸ್ ಆಯ್ತು. ಡ್ರಾಪ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ 28 ಇಶ್ಯೂ ಮಾಡುವ.
And kindly see the next important.
State government to take decision, and if the parties are aggrieved, they are at liberty to challenge the same.
This decision is not 28.4 is issued.
This decision is
dropping
not
my lands. Aggrieved party is the beneficiary. Beneficiary ought to have challenged the final notification. They don't do it. They go to KIDB again. My grievance is this, because they are colluding together. They ideally should have challenged 28.4.
This is too much.
Which they don't do. Because
we have
KIDB is
acquired,
selling.
my lord, large extent of land for the petitioner's company also, my lords. Can it be said so, my lords? Can it be
Everybody is
said so?
aware. There, KIDB, what they do, not everybody is aware. I don't want to go into that.
So it
As
holds
and when
good.
it suits
No,
them,
but
they
the whole
pass order.
problem is the hands of this court to reason it out are tied for
Yes, but
the
kindly
reason that they are now filed an affidavit.
this order is important. State government,
This
yes,
we'll
that
see.
order, pursuant to that order 28.4 is issued. After that order is passed, they have
No,
kept it pending.
now by mistake they issued and they withdraw ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Yes, 28.4 is
Withdraw
passed.
ಮಾಡಿ whatever direction is here, that will continue.
No, 20
He will follow that.
Liberty. No, liberty, my lord, ideally, my lord, should go to them for this reason. Because my lands are dropped, they have to challenge it, which they don't do. For this reason, because they are selling with the KIDB.
ಡ್ರಾಪ್ ಆಗಿದ್ದಾಯ್ತಲ್ಲ ಇಲ್ಲಿ. ಈಗ ಡ್ರಾಪ್ ಆಗಿ ಪ್ರದೀಪ್ ಸಿಂಗ್ ಯರೂರ್ ಸಾಹೇಬ್ರು ಗವರ್ಮೆಂಟ್ ಟು ಟೇಕ್ ಡೆಸಿಷನ್ ವಿತ್ ಪಾರ್ಟೀಸ್.
My lands are dropped.
Now that is dropped, no problem. Now that they have issued 28.2 after this.
The fact that they've issued 28.2 shows this. The
Correct.
beneficiary is shooting through on the shoulder of KIDB.
You may be right, but since the affidavit is filed by mistake, they have issued, they will withdraw. This will prevail.
But in the high,
Whatever Justice Pradeep Singh had said, that will always prevail.
but in administrative system, my lord, everybody is working under hierarchy. My lord. They can't say, the principal secretary cannot say the SLO has issued it by mistake. No, it's just a hierarchical setup. Everybody is aware what is happening. Let us not be, my lord,
There is
too
something
naive to
more
say
than
that
what meets the
somebody
eye.
else is doing it.
something more than what meets the
That's
eye.
what I'm saying. Lord. In that background, ideally, instead of challenging 28.4, they want to issue a fresh 28.4, including my lands.
Right.
That is clearly bad, my lord. I'll just take you also to judge that judgment of this honorable court justice.
May I intervene? Lord?
I'll
May I
dictate
make one
tomorrow.
request? Lord, may
I
I
have
make
a
one
submission
request?
to make.
Sir,
My learned friend's impression that, my lord, on issue of 28.4 notification, the earlier notification comes to an end is not correct, and this honorable division bench has
It's
held
not
that,
correct,
my
my
lord,
lord. The facts
successive
are not being
notifications
presented
can
to
be
the
issued, my lord. That is the position, because the lordships will kindly notice, once section 3(1) notification is issued, so long as it is not withdrawn, the land continues to be, my lord, an industrial area. My lord, that has not happened. My lord, I cannot, my lord, make submissions on the merits of the case, because, my lord, the matter is still pending before the government. That's why.
3.1 is only declaration of interest. We are also running
Lords, may
interest.
I,
We are
Lords?
not agreed by the 3.1 order.
Yes,
Kindly-
Prabhu.
Lords
Prabhu,
will
sir,
permit me to make submissions, Lord. Lords
yes,
will
sir.
permit-
You are not
The
that
facts
audible.
No, I'm sorry. May I, Lords, Lords assist? Lord, may I request Lordships to kindly see the order of this honorable court at page 151.
Justice Pradeep Singh error.
Now, David, kindly
Yes.
see. This is not the facts which my learned friend has presented in the correct perspective. Lord. Kindly see page 151. There's no question of final notification being dropped. Lord. Kindly see page 151. Lord. Now, Lordships may kindly peruse at page 155, paragraph 4. Admittedly, the stage of 28.4 of the Act is not yet arrived by the state government, and no orders are passed, and this matter is seized with the state government to pass orders pursuant to the recommendations were made by the SLO as well as the KIDB under 28.3 of the Act, and the further clarification submitted by SLAO at this stage. Learned Senior Counsel so and so appearing for the petitioner contends that nothing much would survive now in view of the statement of objections filed by KIDB, that the ball is in the court of the state government to consider and pass orders based on the orders. Documents are annexed along with the statement of objections filed by KIDB, one of which is dated 18/6/2024, wherein an order is passed by SLAO, wherein it is withdrawn the proposal to drop the acquisition, which was initiated, and therefore he would not press the writ petition, as the matter now vests with the state government to consider under 28.4 of the Act. Nevertheless, learned counsel so and so contends that the order under 28.3 has been revised is an illegality. That may not be required to consider as of now, for the reason that the petitioner does not want to press the present petition. It might be the state government. Well, let me explain before your lordship what are the chronology of events. Not initially preliminary notification.
Withdraw ಮಾಡ್ತೀನಿ ನೋಟಿಸ್ ಅನ್ನಕ್ಕೆ ಇಷ್ಟೊಂದು
No,
ಆರ್ಗ್ಯುಮೆಂಟ್
therefore, my question.
ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್
Therefore,
ಅದಾದ್ಮೇಲೆ
what my
final
learned friend
notification
says that
ಬಂದಿರೋದು.
finding has to be recorded. Finding has to be recorded that government cannot pass a 28.4 notification. That will severely cripple our rights. If KIDB today makes a statement before your lordship that they are
let's
going
see.
to.
I'll dictate it tomorrow. I'll just go through all this and then dictate.
No, if KIDB makes that statement, my lordship may record it and close the petition. This is all that I am submitting.
Well, I can close it straight away. All of you are not allowing me to close it at all.
No, but if
You want
KIDB
your
is the author of
submission,
the-
you want your
KIDB is the-
submissions, you want.
I'm not, my submission is only for this extent, Lord, where my learned friend says finding has to be recorded
All
in a
right,
matter.
tomorrow.
Alala, if 28.
Nale, I will dictate it tomorrow.
But I am sorry, my lord, sorry to trouble your lordship. If Mr. Basavaraj Sabrad, who appears for KIDB, says that they are want to withdraw this, my lordship may record that statement.
No, that's exactly the point. We'll see. Tomorrow we'll do it. Yes.
Very good.
ಅವರೇ ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ ಅಂತ ನಾವೇನು ಬಿಡಿ.
No, my learned friend, but this is most unfair. I'm not saying that. I'm sorry. I will also file an affidavit showing what is the malafide of this petitioner company. It is more it is a rival company which is in the steel manufacturing, setting up all these people to ensure that we do not start our production. This is not the way. When the author of the I'm sorry. When the author says that I want to withdraw,
infructuous petition ಅಲ್ಲಿ ಇಷ್ಟೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ರೆ ನೀನು.
No, Lord, that is the reason I'm saying when the author
The only
says
person
that
who's laughing at this is the KIDB. Because they are the beneficiary, either this way or that way.
What kind of? Not my learned friend. I take very serious exception to this. Continuously, is making allegations. What kind of?
On KIDB is making allegations, sir.
No, I'm sorry, my lord. I'm sorry, without any basis. Let him file an affidavit. What kind of submission is this? We are an industry who has been granted single window clearance. We have invested more than 250 crores in the project. KIDB is acquiring this land for setting up of a plant. What kind of submission is saying that he are in hand in
this
glove,
case-
shooting in shoulders? What kind of submissions are this, my lord?
But this is
You
very clear.
must
Madam,
act with some
the
responsibility. I am
the
sorry.
attitude of KDB
You have
itself
to
is
act
very
with
clear,
some
my lord, what is happening.
responsibility. Just because
Once
you have the
28
license.
is
you
No,
have
it's
to
all
do
right.
this. No, I'm
Ruling,
sorry.
sir. We'll
No, this
pass
is not the
orders
way, my
tomorrow.
lord.
Yes,
Now,
yes.
when lords,
I
the
have
author
become
says that you
punching
want to
bag for
withdraw.
both of them, my lord.
No,
No,
no.
this is not the way.
You are the ringmaster. That is the whole problem.
Lord, my lord, they come to us
You're-
only for acquisition. Everyone comes to us, but my lord, now
You are swinging the pendulum that way to this way. That's the problem. Yes.
my absence may be condoned, my lord,
Absence.
but tomorrow.
Idiralla.
Tomorrow.
Tomorrow.
If I'm not there, my lord, you lost
All
me.
right. Don't.
To appear on VC, my lord.
All of you appear
Yes.
on VC.
Great.
Please.
Tomorrow.
I appear for the petitioner.
Then you said you'll restrict your submission to consideration of representation.
Yes, but facts are needed. I don't mind giving the facts. Lord.
No. Government
Only
consideration representation ಆದ್ರೆ ಏನ್ ತೊಂದ್ರೆ
ಅದಕ್ಕೆ
ಇಲ್ಲ.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
That I will dispose it on that ground.
Yes, annexure A and B, Lord, are the representation.
But A and B will be considered. Yes.
Yeah. But the background of the case is that reconnaissance permit and prospecting license is granted.
ಇಲ್ಲ ಅದು ಗೊತ್ತಿಲ್ಲ.
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ ನಿಮ್ದು ಗೋಲ್ಡ್ ಈ ಜಾಗದಲ್ಲಿ ಇದೆ ಅಂತ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ರು. ಆ ರಿಪೋರ್ಟ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದೀನಿ.
The petitioner is before this court seeking the following prayer. Heard the learned senior counsel Ashok Harnalli appearing for the petitioner and the learned AGA. The learned senior counsel, though the aforequoted prayers are more than one, the learned senior counsel submits that he would restrict his prayer to prayer number 2, which seeks consideration of representations, annexures N and V, at the hands of the respondents. The learned senior counsel would further contend that those representations were directed to be considered, are sought to be considered, are the ones that renders in license other.
Annexure A and B, madam.
A and B, madam, prayer number 1, madam.
A and B are the representation
First prayer.
The
prospecting
representations,
license. Prospecting license.
the representations are submitted for grant of.
No, not for grant.
Cancellation of
They have
allotment.
granted the very land which is subject matter of prospecting license to a school. So that we have.
The representation is for the purpose of clarification, or representation speaks for itself. It is submitted in the wake of the prospecting license being granted, prospecting license that is to be granted to the petitioners being granted to a school, and therefore the representations have sprung. In that light, in the light of the submission that they are going to restrict the prayer for consideration of representations at annexures A and B,
Yes.
I deem it appropriate to dispose the petition. The learned B and B, the learned AGA would submit that if a direction is, if reasonable time is granted, the representations would be considered in accordance with law,
Yes.
and appropriate orders would be passed. In that light, without going into the merit of the claim of the petitioner, in the claim of the petitioner, I deem it appropriate to dispose the subject petition with a direction to the respondent state to consider the representations at annexure A and B, and A and B both dated 27/12/2024,
Yes.
and
And
both dated 27/12/2024, submitted to the
And-
Deputy Commissioner.
And 5825, Lord. And annexure B, 5825.
27/12/2024 and 5/8/2025, both submitted to the Deputy Commissioner, and to pass necessary orders in accordance with law, at any rate within 8 weeks from the date of receipt of the copy of the order, if not earlier, ordered accordingly.
Yes.
My lords, 2 corrections. My lords, the mining license, not prospecting.
Prospective mining license. ಆಮೇಲೆ
By hand, my lords. Order by hand, my lords.
ಆರ್ಡರ್ ಬೈ ಹ್ಯಾಂಡ್.
And delivered for today, my lords.
ಯಾಕೆ, ಏನು ಅರ್ಜೆನ್ಸಿ?
ಅದೇನ್ ಬೇಡ ಬಿಡಿ, ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಬೇಡ.
ಹಾಗಾದ್ರೆ ನಾವು ಒಂದು 2005-6 ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡ್ಬೇಕಾದ್ರೆ ಏನೋ ಇದೆ ಇದರಲ್ಲಿ ಅಂತಂದ್ರೆ ಅದನ್ನ ಹೇಳ್ತೀನಿ ನನಗೆ. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಬರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂದ್ರೆ ಏನೋ ಇದೆ ಇದರಲ್ಲಿ, ಅದಕ್ಕೆ ನಾನು ಎಂಟ್ರಿ ಮಾಡೋ ಕ್ಯಾನ್ಸಲ್.
8 weeks.
ಅಲ್ವಾ ಸರ್?
ಅದೇ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಏನ್ ಬೇಡ, ಇದ್ರಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಸೊ ಇದ್ರಲ್ಲಿ ಏನೋ ಇದೆ ಆರ್ಡರ್ ಇಲ್ಲ.
ಏನಿಲ್ಲ, ಅದು ನೆಲದ ಒಳಗಡೆ ಗೋಲ್ಡ್ ಇದೆ ಅಷ್ಟೇ.
ಎಸ್ ಸರ್.
14, AB 14.
MSME tender.
I'm for respond number 2, my lord.
ಅದೇ ತಾನೇ ಇದು 14.
Yes, your lordship. I 2 weeks time, my lord.
Stay ಇದೆಯಾ?
Objection.
Stay ಇದೆ sir.
Stay is there.
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Urgency ಇದೆ sir.
ಇದೇ ತಾನೇ ಇದು ಯಾವ್ದು?
51
Security.
Security.
Yes sir.
Respond number 4 is the
ಹೇಳಿ,
MSc lordship. Respond number 4 is the MSc lordship. Is not entitled 100% procurement lordship.
25% is the limit for an MSME,
Yes,
correct?
your lordship. Yes, your lordship.
Where is that notification? Where is the tender?
Lordship, Annexure D, your lordship.
Annexure?
Annexure D, your lordship.
Page everybody.
Page number 24, your lordship. The award is awarded to the respond number 4, your lordship. The tender is allotted to the.
Tender is award, ಟೆಂಡರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ MSME ಪಾಲಿಸಿಯಲ್ಲಿ ಎಲ್ಲಿದೆ ಎಲ್ಲ? 25% ಇದೆ ಅಂತ ಎಲ್ಲಿದೆ? ಇಲ್ವಾ?
Your lordship, circular is there, your lordship.
Where is it?
Annexure C, your lordship.
Next C, schedule casting.
ಒಂದು ನಿಮಿಷ. Clarification regarding sub-target procurement of MSc owned by SC/ST entrepreneur. You are an SC/ST entrepreneur?
No, your lordship.
ಅಲ್ಲ ಅಲ್ವಾ? In this connection, to increase the percentage from MSc from the present 20 to 25%. ಆಮೇಲೆ ಇದು ಸರ್ಕ್ಯುಲರ್ ರಿಗಾರ್ಡಿಂಗ್ SC/ST ಎಂಟರ್ಪ್ರಿನರ್ಸ್ಗೆ
Yes, your
ನಿಮಗಲ್ಲ.
lordship. Whatever the MSc is entitled only 25% of the.
Clarification sub-target procurement from MSc owned by.
Procurement, your lordship.
Owned by SC/ST enterprise.
More than that, the MSc is not entitled, your lordship, in any procurement, your lordship.
Where is that? I'm asking, where is that?
I will produce, your lordship. Next
I will
day,
vacate the interim order now. Having taken an interim order on this on a particular premise, how have I not produced all that? When was the interim order granted?
In the vacation bench, your lordship.
ಈಗ I'll give time till tomorrow. List tomorrow and fresh matters list. If you don't produce it, I'm going to vacate the interim order.
Your lordship, kindly have it Monday, your lordship.
No, sir.
Monday.
Tomorrow. How did you get an interim order then
Sorry,
without
Lordship.
showing that policy?
Kindly have it on Monday, your lordship. I will produce, your lordship. Please.
ಇದೇ ಇಲ್ಲ.
Yes, your lordship. I have. Your lordship.
What you have? Circular ಇದಿದ್ರೆ that would have been annexed first.
Yes, your lordship.
That is not there. That is SC/ST entrepreneurship. MSME ಗೆ ಎನಿ ಪ್ರೊಕ್ಯೂರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬಿಯಾಂಡ್ 25% ಇಲ್ಲ ಅಂತ ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಕೊಡಿ.
Yes,
ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ವಿತ್ ಕಾಸ್ಟ್.
I will produce, your lordship.
I'll
Kindly have
take
it
it on
Monday,
Monday in fresh matters list. If it is not there, dismissal with cost.
Till then, interim order may be extended.
Till then,
Please, please, your
yes,
lordship.
till then.
Please, your lordship. Till then,
Monday.
Monday, your lordship.
Please.
List the matter Monday in the fresh matters list. The learned counsel for the petitioner to produce.
Interim order may be extended.
ಅಯ್ಯೋ very sir.
Please.
The learned counsel for the petitioner.
Otherwise, they will.
ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ ಕೊಡ್ತೀರಾ ಇಲ್ಲ ಈಗಲೇ ವಜಾ ಮಾಡ್ಲಾ?
Sorry.
The counsel for the petitioner, the case at hand revolves around a MSME being entitled to a tender only to the tune of 25%. In the case at hand, 100% is awarded to an MSME. That is what is called in question. The learned counsel for the petitioner submits that the government has issued circulars with regard to the entitlement of MSME only to the tune of 25%, while the circular is not appended to the petition nor the petitioner has it. Therefore, seeks time for its production till Monday. It is made clear in the event circular is not produced before the court on the next date, the petition would be dismissed without showing any indulgence. Subject to the aforesaid condition, interim order stands extended. MSE, ME ಅಲ್ಲ, correct, MSE.
Micro and small. Gayatri advocate.
Let's, my name may be deleted. Let's from the.
Gayatri ilva.
Suresh S. Gundi has entered appearance.
Registered to delete the name of Gayatri SR is appearing for respondents 2 and 4, 3 and 4.
Yes.
For respond number 2, my name may be shown. For respond number 2, I will file a wakalat, my lord, my name.
I appear for only one, my lord. They are having a penal advocate.
Two are.
Tejaswini Chandrasekhar from.
So and so for registered to print the name so and so for R2. Next, please.
Cell number 15, Jayvan.
My lord.
Petrol bunk.
The respondent issued the no objections by violating the land conversion
Who are you,
order.
sir?
Land conversion order.
Yaru, sir.
I am for the petitioner, my lord.
has no locus
ನೀವು
standi to
ಪಕ್ಕದ
challenge.
ಮನೆಯವರಾ ರೈವಲ್ ಆಪರೇಟರ್?
I am in the same premises, I have the education institution. I am the member of
ಯು
the
ಆರ್ ದಿ ಪೆಟಿಷನರ್ ಅಂತ ಗೊತ್ತು ನನಗೆ.
petitioner, sir, petitioner.
ಆಮೇಲೆ
The land conversion order is only for the public and semi-public community hall purpose is there. By violating the order of the land conversion order, respondent one permitted to establish the commercial petrol bank, Your Honor.
ಪೆಟ್ರೋಲ್ ಬಂಕ್.
Petrol bunk. And the education institutions desired the said land for the extension of amenities for the education institutions. B.Ed college, ITI college, etc. set up in institution.
Is directed to accept notice for respondent number 1. The respondents 2 and 3 be served by way of hand summons. The petitioner is advocate.
Petitioner.
Educational institution ಅಂದ್ರೆ
Advocate, sir. I am an advocate.
ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು, ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ ಈಗ. Who are you?
I am the member of the institution also.
Which institution?
That is the education institution.
Which educational institution?
Education.
What is your locus to challenge this? PIL ಇದು?
Sir, I am in the same premises, education institution is running. Education institution is running. And that land is required for the extension of the amenities for the education
ಅವ್ರಿಗೂ
institution.
ನಿಮಗೂ ತೊಂದರೆ ಆಗಿದೆ ಅದಕ್ಕೆ
Education institution, Your Honor.
Nothing. What is your locus, sir?
First of all,
What is your locus?
locus
PIL ಅಲ್ಲ
standi.
ಇದು?
Yes.
PIL, sir. I am, the education institution is running in the same premise. I am the
Don't
member.
worry. Who are you?
I am the member of the education institution.
Oh, sir. You say you are an advocate.
I am the member of the education institution. And that institution, that land is donated for the purpose of only for the religious purpose.
File a PIL.
Construction of the
File a
land, Your
PIL,
Honor.
sir. Where is the ಎಲ್ಲಿದೆ ಇದು?
Any order?
ಕಮ್ಯುನಿಟಿ ಹಾಲ್ಗೆ ಅಂತಿರೋದು ಎಲ್ಲಿದೆ?
ಏನ್ ಸರ್?
ಕಮ್ಯುನಿಟಿ ಹಾಲ್ ಡೊನೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿದೆ. Kindly annexure D, Your Honor. Annexure D. Page number 22. First paragraph, Your Honor. ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ 64
ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Sir, next third paragraph, sir.
ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
This is the conversion order, sir. This is the conversion order. 1 ಎಕರೆ 19 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ವ್ಯವಸಾಯದ ಜಮೀನನ್ನು 4ನೇ ಲೈನ್ ದಾಗ ಸರ್ ಜಮೀನನ್ನು ವ್ಯವಸಾಯೇತರ ಪಬ್ಲಿಕ್ ಸೆಮಿ ಪಬ್ಲಿಕ್ ಯೂಸಸ್ ಕಮ್ಯುನಿಟಿ ಹಾಲ್ಸ್ ಉದ್ದೇಶಕ್ಕಾಗಿ ಬಳಸಲು ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗೊಳಪಟ್ಟು ಭೂ ಪರಿವರ್ತನಾ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ.
ಅದೇ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಈಗ ಬರ್ತಾ ಇದೆಯಾ? ಬಟ್ ನಿಮ್ಗೆ ಲೋಕಸ್ ಇಲ್ಲ. ಯು ಮಸ್ಟ್ ಬಿ ನೇಬರ್. ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲಿ ಕೊಟ್ರಿ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಗವರ್ಮೆಂಟ್ಗೆ?
ಇಲ್ಲ, ಅಬ್ಜೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್.
ಎಲ್ಲಿದೆ?
It is public have submitted the representation.
Where?
29, page number 29, Annexure G, Your Honor.
ನೀವು ಇದ್ದೀರಾ ಅದರಲ್ಲಿ?
ಹೌದು, ನಾನು ಇದ್ದೀನಿ ಸರ್. First person, I am the first person.
You are the first person.
ಹೌದು ಸರ್.
The petitioner is before the court calling in question permission granted for for setting up of a petroleum outlet in a land that stood converted for non-agricultural purposes with specific indication that it should be put for public and semi-public use or construction of community halls. Making use of the said conversion, it transpires that the Hindustan Petroleum Corporation is wanting to set up a petroleum unit after securing no objection from the Deputy Commissioner. Till clarification is issued by the clarification to the aforesaid conversion, and now the permission being granted, there shall be an interim order of stay spread for till the next date of hearing. List the matter on 19th in fresh matters.
Granted interim stay order. Stay the interim.
ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ಕೊಟ್ಟಿದ್ದೆ ಅದು ಸರ್. ನಿಮ್ಗೆ ಲೋಕಸ್ ಇಲ್ಲ ಆದ್ರೂ ಕೊಟ್ಟಿದೆ. ಎಸ್.
Abhijitis.
Mandamus, government.
My lord, this is a mandamus.
That is a mandamus. We will grant a mandamus. Yes. The
Take instructions.
ನೋಟಿಸ್ ತಗೊಂತೀರಾ? ಕ್ಲೋಸ್ ಮಾಡ್ಲಾ?
Notice ತಗೊಳ್ತೀನಿ.
ಕ್ಲೋಸ್ ಮಾಡೋದು ಬೇಡವಾ?
Please.
Learned AGA is directed to accept notice for the respondents list on Monday ಹಾಕ್ಲಾ?
next week, 1 week.
I have to list on 17th, in preliminary hearing, next. 17th in fresh matters list. 17th?
Please.
So, why age?
Externment.
Externment.
ಹೌದು. My lord has taken a view in the Deepak case, my lord, Sachin case, relying upon the Deepak case, where my lord has held that, my lord, along with the notice, the report is to be.
Government circular issue ಮಾಡಿದ್ರೆ implementing that. ಅದು ಗೊತ್ತಿಲ್ವಾ?
ಅದು ಇದು ಗೊತ್ತಿದೆ. ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ two propositions of law, my lord.
ಹೇಳಿ.
Way back in the 1973 itself, my lord, Honorable Supreme Court said it should be in the generic nature. Giving a full particulars will defeat the entire provisions of the law.
Deepak says something else.
Deepak case has referred one of the judgment only for limited purpose, my lord. This is this compilation, my lord. I only directly take to the state of Maharashtra case, my lord, for the purpose. Before referring the first case, page 44, my lord.
40?
Page 44, 45, page 45. Paragraph 4, my lord. On behalf of the appellant, reliance has been placed upon so-and-so, where similar plea was being taken by the appellant before this court. It was contended that failure on the part of state government indicate the non-application of mind. The appellant had also urged that allegation contained in the show cause notice was too vague. In the absence of details, afforded reasons, opportunity to defend himself. Rejecting the argument, this court held that full and complete disclosure of particulars as requisite in the open prosecution will frustrate the very purpose of externment proceedings. There is a brand of lawlessness element in the society which is impossible to bring to the book, establish the method of judicial trial, because in such trial there can be no conviction without the legal evidence, and any legal evidence is impossible to obtain because of what fear represent witness are unwilling to deposit the public. While dealing with the contention, the state government was under the duty to give the reasons support the order dismissing of appeal. Point was rejected in following terms. Precisely, the reason which proposed to be extended is only to the extent informed the general in nature. Allegation, neither the extreme authorities nor the state government appeal can be asked to write the reasoned order in the nature of the judgment. So next, now I come to the paragraph 9 of that judgment. This judgment was referred in the Deepak case only to the extent that full opportunity of hearing has to be given. So Deepak case also, my lord, this aspect is not considered by the Honorable Supreme Court in the Deepak case also, because this is the root of the matter in all these proceedings, my lord. Paragraph 9, my lord, page 38. Page 38, my lord, the earlier judgment, now I refer. The provision shows that reasons for which necessity to justify the passing of an externment order arising out of the extraordinary circumstances, an order of externment can be passed under clause so-and-so 56 of the only if the authority is concerned is satisfied that witness unwilling to come forward give the evidence so-and-so. A full and complete disclosure of the particular, such is a requisite in an open prosecution, will frustrate the very purpose of externment proceedings. If the show cause notice were to furnish to the proposed externee concerned data likely to specify the dates, incidents, or name of the persons involved in the incidents, it would be enough to fix the identity those who cut the fear of injury, either person or properties, are unwilling to deposit the public. There is a brand of lawlessness element in the society trial, because in such trials there can be no conviction without legal evidence. Any legal evidence is impossible to obtain because of out of fear of repression. That explain why Section 59 impose a limited obligation on the authority to inform the proposed externment order the general in nature of the materials allegation against him. The obligation fixed the limits of the correlative rights of the proposed externee is entitled before the order of externment is passed under Section 56 to know the materials allegation against him and the general in nature of those allegations. He is not entitled to inform specific particulars relating to the material allegations. It is true that the provisions of Section 56 make a serious inroad to the personal liberty, but such restriction have to be suffered by the larger interest of the society. This court in so-and-so referred subsequently, following the so-and-so, paragraph 11, in which an order of externment was passed under 57 of the Act, it was held that, quote, on examination of general scheme of the Act, the provisions of 55, 56, 59 cannot be held to be invalid on the ground only in general nature of the material allegation required to be disclosed externally, and it would be difficult to him to grade the material evidence justifully examined. So like this, it has been dealt, madam. And the recent, my lord, and the similar circumstances,
ನೋಡಿದೆ
on 144 order, Ninne Honorable Supreme Court has confirmed this order.
prohibitory order.
Prohibited 144. It was issued under the 163, present old 144.
Sachin Magdum.
ಹೌದು, yesterday Supreme Court has confirmed this order, my lord. So judicial interference, all these cases, my lord, what is happening? So if you supply the report, my lord, along with the report, it will defeat the entire purpose, my lord. This the Deepak case also, my lord. Deepak case refer this judgment only to the extent that full protection has to be given, hearing has to be given. For that purpose, Deepak case, not more than that, Deepak case is referred. The first judgment which I have read out, my lord, at paragraph 8, it has referred. My lordship judgment is based upon this judgment, my lord.
Yes, yes.
Paragraph 8, my lord, page 715.
Where is my judgment?
Some judgment.
Padi.
The same.
No, ಅಲ್ಲಿ Justice Magdum or orderly, it was prohibitory order
ಅಲ್ಲ,
144. That is not externment.
Not externment. This is 144 orders.
See, 144 orders is temporary prohibition. Externment, you're taking away
all these
fundamental
cases,
right of a person of
Magdum,
free movement in a place.
Magdum Sahib judgment only relate to the extent of judicial interference.
In prohibitory orders.
That action, not more than that.
Externment definitely will stand on a different footing.
But in externment case, my lord, paragraph, that two judgments, my lord, which says only general in nature. If the entire report is being given, my lord, very purpose of externment will be defeated. That is what Honorable Supreme Court in two judgments. Paragraph 18, they referred strictly with court has held that requisitor must be strictly complied with. That's the only proposition. That is, to the extent that hearing should be given under section 59.
Deepak para 13 nodi. Considering the nature of power under section 56, the competent authority is not expected to write a judgment containing elaborate reasons. True. However,
please,
the competent authority must record its subjective satisfaction of the exercise of one of the grounds
please,
in subsection 1 of section 56 on the basis of objective material placed before it.
Please.
Though the competent authority is not required to record reasons on par with a judicial order, when challenged, the competent authority must be in a position to show application of mind.
Please.
The court, while testing the order of externment, cannot go into the question of sufficiency of material based upon subjective satisfaction. However, court can always consider whether there existed any material on the basis of which subjective satisfaction could have been recorded.
Regarding that come to the reason portion. But my first submission is that, my lord, submitting my lordship has held in this judgment, my lord, along with the notice, report has to be submitted. Report submitted by the police authority.
One ನಿಮಿಷ. ಈಗ ಇವ್ರನ್ನ ಎಕ್ಸ್ಟರ್ನ್ ಮಾಡ್ತೀರಾ, ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಡ್ತೀರಾ.
Please.
Why you should not be externed ಅಂತ.
Please.
ಕರೆಕ್ಟಾ? ಅವ್ ಏನ್ ರಿಪ್ಲೈ ಕೊಡ್ತಾರೆ ಬಂದು? You leave the case, Gangadhar. ಈಗ for a person, you're wanting to curtail his fundamental right of movement, or you're wanting to illinda allige, it's called tadipar, whatever it is. Now you call him, ನಿನ್ನ ಆಚೆ ಕಳಿಸ್ತಾ ಇದೀವಿ ಇಲ್ಲಿಂದ, what do you say? ಯಾಕೆ ಕಳಿಸ್ತಾ ಇದ್ದೀರಾ ಅಂತ ತಿಳ್ಕೊಳ್ಳೋದು ಬೇಡವೇ?
Otherwise, my lord,
you tell me.
Yes, my lord. Otherwise, very principles of natural justice will going to be defeated. If there is a general proposition, I bow down, my lord. But maybe notice should be contained general instruction because of the pendency of three cases.
Now, why do you want to extern a person?
For simple general instruction.
Without there being any basic report under section 56.
Please.
You will not take the step of externment.
Please, man.
So there is some material against him.
Please, man. Please.
Right.
Please, man.
Yes, externment ಗೆ elaborate reasons ಕೊಡ್ಬೇಕಾಗಿಲ್ಲ. At least the notice should indicate there is a report against
yes, that
you.
extent, my lord, that extent I conceal, my lord. There should be notice should be indicated. But the my lordship judgment regarding supply the report is required to be reconsideration. That is my submission. Because that is amount to giving entire material, my lord. So on the basis of the material available.
ಆಯ್ತು, ಈಗ entire material ಕೊಟ್ರೆ, ಈಗ ನೀವು ಒಂದು, if you don't like your face, it's by the deputy commissioner, it is not the police. Assistant commissioner passes the order. Assistant commissioner doesn't like his face at all. ಸೊ ಯು ಪಾಸ್ ಅನ್ ಎಕ್ಸ್ಟರ್ನ್ಮೆಂಟ್ ಆರ್ಡರ್. ಈಗ ಇದು ಯಾವಾಗ ಆಗುತ್ತೆ ಅಂದ್ರೆ ಎಲೆಕ್ಷನ್ ಟೈಮಲ್ಲಿ ಯಾರ್ಯಾರು ಲೀಡರ್ ಸಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ಆಪೋಸಿಟ್ ಪಾರ್ಟಿಗೆ ಅವ್ರನ್ನೆಲ್ಲ ಎಕ್ಸ್ಟರ್ನ್ ಮಾಡ್ಬಿಡ್ತೀರಾ. ಯಾಕೆಂದ್ರೆ ಇಫ್ ದ ಲೀಡರ್ ಗೋಸ್ ದಿ ಫೋರ್ಸ್ ಗೋಸ್. ಅದಕ್ಕೆ ವೆನ್ ಯು ಪಾಸ್ ಅನ್ ಆರ್ಡರ್ ಆಫ್ ಎಕ್ಸ್ಟರ್ನ್ಮೆಂಟ್ ಅಗೇನ್ಸ್ಟ್ ದೀಸ್ ಲೀಡರ್ಸ್, ಇವ್ರನ್ನ ಇಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ ಇಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ ಎಲ್ಲ ಕಡೆ ಹಾಕ್ತೀರಾ. ಎಲೆಕ್ಷನ್ ಟೈಮಲ್ಲೇ ಜಾಸ್ತಿ ಆಗೋದು ಇವೆಲ್ಲ.
highest orders will be passed
only during elections. ನಾವು ಎಲೆಕ್ಷನ್ ಟೈಮಲ್ಲಿ ಇದು ಹಾಕಿದಾಗ ಯಾಕೆ ಆಚೆ ಹಾಕ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಒಂದು ಕಾರಣ ಬೇಡವೆ? ಒಂದು ಸಮ್ ಪೊಲಿಟಿಕಲ್ ಪಾರ್ಟಿ ವಿಲ್ ಸೇ ದಿಸ್ ಮ್ಯಾನ್ ಶುಡ್ ಗೋ ಔಟ್ ರೂಲಿಂಗ್ ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್. ಸೊ ಯು ಸೇ ನಿಮ್ಮ ಮೇಲೆ ಅದಿದೆ, ನಿಮ್ಮ ಮೇಲೆ ಇದಿದೆ, ನಿಮ್ಮ ಮೇಲೆ ಅದಕ್ಕೆ ಆಚೆ ಹಾಕಕ್ಕೆ ಕಾರಣ ಗೊತ್ತಾಗದ್ ಬೇಡ.
That is why, my lord, I bow down, my lord.
Will it not become a misuse or abuse if it is left open?
Yes, this is the matters dealing
Sir,
with.
if everything was well with the society, courts need not be existing at all. That egalitarian society will never come unless bias and prejudice would go everywhere.
To that extent, my lord, notice should be contained. But my lordship has interpreted to the extent that report has to be supplied along with the notice, my lord. That require reconsideration.
ಏನಕ್ಕೆ ರಿಪ್ಲೈ ಕೊಡ್ತಾರೆ ಅವರು ಆಮೇಲೆ?
Otherwise, my lord, that is, my lord, it is amount to giving entire material, my lord. That is what Honorable Supreme Court in these two cases held, my lord. Giving of the entire material will defeat the purpose. My lord, yes, my lord. The notice should contain, there are 3 cases are pending. You are involved in these type of offences. You are threat to the society. Hence, you answer these questions. But entire giving the materials, my lord, suppose if any materials which is obtained by the police through different investigation, that need not be required to be submitted to the petitioner, my lord.
I'm not seeking charge sheet or the complete investigative material ಕೊಡಬೇಕು ಅಂತಲ್ಲ. ಯಾವ ಕೇಸಲ್ಲೂ ನೀವು ಕ್ರೈಮ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಇಲ್ಲಿವರೆಗೂ ಮಾಡಿಲ್ಲ. ನೀವು ಇಫ್ ಯು ಸಿ ದಿ ಕೇಸಸ್, ನೀವು ಅದರಲ್ಲಿ ಕನ್ವಿಕ್ಟ್ ಆಗಿದ್ದೀರಾ, ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಈ ಕೇಸಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಮಾಡಿದೀವಿ ಅದರಲ್ಲಿ. ಬೇರೆ ಬೇರೆ ಕೇಸಸ್ ಆಸ್ ಎ ಪ್ರಪೋಸಿಷನ್.
why you had to write this is
ಅಲ್ಲ, ಇಲ್ಲಿ ಎಸ್ಟಿನೆಸ್
ಟೈಮ್ ನೋಡಿ,
ಇಲ್ಲಿ ಎಸ್ಟಿನೆಸ್
ಬರ್ದಿರೋದು ಯಾವಾಗ?
5th
April ಕೋವಿಡ್ ಅಲ್ಲ, 5th April 2024 ಪಾರ್ಲಿಮೆಂಟರಿ ಎಲೆಕ್ಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ಇದು. ಐ ವಿಲ್ ಟೆಲ್ ಯು ವೆನ್ ಐ ರೋಟ್ ಇಟ್ ಇನ್ 2 days.
ಅಲ್ಲ, ಅದರ ನೋಟಿಸ್ ಅಲ್ಲೂ 2 days ಇರುತ್ತೆ.
ಓಪನ್ ಕೋರ್ಟ್ ಡಿಕ್ಟೇಷನ್.
ಅದರಲ್ಲೂ ನೋಟಿಸ್ ಇದರಲ್ಲಿ ಎಸ್ಟಿನೆಸ್ ಇತ್ತು. ವಿತಿನ್ 2 days ಅಲ್ಲಿ
ಯಾಕಂದ್ರೆ ಐ ಸಾ ಅಟ್ ಲೀಸ್ಟ್ 20 externment orders passed for nothing. For nothing, even para. You are threat to the society, go. You are threat to the society, go.
Regarding that extent, my lord, they are not entitled. Only in respect of only the request by the state is that, my lord, to the extent that, my lord, furnishing of the report is required to be reconsidered, because, my lord, it will. Yes, my lord, they should even the bare reading of the section indicating that the general nature it should be given.
Sir, that is why I have written that is a procedural safeguard. Procedural safeguards are lifeblood of liberty in Bardirada.
Liberty, but that was been
liberty is curtailed, sir. Externmental liberty is curtailed.
Yes,
a man may be good, bad, or ugly to the society, but externment order is passed. Liberty is not curtailed.
That extent, my lord, furnishing of the report, my lord, because 2 judgments which says by referring the when the constitutional
Magdum Sahibradu
144 correct. I am not touching that. Magdum Sahibradu I am not touching that. Only to show that review annexure ಮಾಡಿದೀನಿ ಅಷ್ಟೇ. Only on the first 2 judgments of the Honorable Supreme Court, which is on the basic of the.
Gangadhar sir, I would definitely consider your thing. The whole problem is the authorities misusing it. The misuse led to write this order. 20 ದಿನಕ್ಕೆ 2:30ಗೆ 10 ಮೂವ್ ಮಾಡಿದೆ. ಐ ಆಮ್ extend ಎಲ್ಲ ಎಲೆಕ್ಷನ್ ಟೈಮಲ್ಲಿ extend. Why the authorities become very active during elections? ಅಲ್ಲಿವರೆಗೂ ಯಾರು ಕ್ರೈಮು ಯಾರು ಥ್ರೆಟ್ ಇರಲ್ಲ ಸೊಸೈಟಿಗೆ. ಎಲೆಕ್ಷನ್ ಟೈಮಲ್ಲಿ ಮಾತ್ರ ಥ್ರೆಟ್. ನಿಮಗೂ ಗೊತ್ತು.
Not on that, my lord. Only to the extent of this, my lord, this please consider.
We'll see. ನಾಳೆ ಮಾಡ್ತೀವಿ.
And also appeal is there in all this case.
That ಗೊತ್ತು, appeal ಇದೆ. ಬಟ್ ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದಾ?
ಇಲ್ಲ, ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
19 as also same.
ಒಂದು ನಿಮಿಷ, ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಕೊಡಿ ಇಲ್ಲಿ.
Page number 14.
ಇದು ಡೀಟೇಲ್ ಆರ್ಡರ್ ಬರ್ದಿದ್ದಾರೆ. ಏನ್ what is wrong with this?
My lord, all these cases are still pending, my lord.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ
matters are going on, my lord.
So reason ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ reason ಇದೆ.
But there is no reason to extend the additional, my lord.
Will not, see, that is what is there. Subjective satisfaction, we will not, court will not interfere. Anyway, we'll see. ಅದೇ reconsider ಮಾಡಬೇಕು ಅಂದ್ರೆ ಮಾಡಿ.
19
Report
also
ವಿಷಯ ಆಗಲ್ವಾ?
19 also same.
19 also
19
same.
also same. Both 18, 19 list on Tuesday in fresh matters. Yes, next.
Number 18, Manish Patil.
Lord Mandamus, my lord, for consideration of representation, I've served advance copy on Mr. Girish Hulmani, my lord.
ಎಲ್ಲಿದ್ದಾರೆ? ಗಿರೀಶ್ ಕ್ಲೋಸ್ ಮಾಡೋಣ?
Time
ಬೇಕಾ?
back.
ಮಂಡೇಗೆ ಹಾಕ್ಲಾ ಅಥವಾ?
Well, it's on 10 days.
ಆಯ್ತು. List the matter on 17th in the fresh matters list. The learned counsel Girish Hulmani is directed to accept notice for the respondent bank. The matter is only to consider the representation of the petitioner. In that light, list on 17th in fresh matters.
So, Lord, could it be on 19th, my lord?
Why, sir?
19th. There is a family function on 17th. 19th.
Next.
20,
Much obliged.
Naveen Kumar.
Petrol. AGA.
Direction to register the FIR.
Huh?
This is my lord's the petition filed seeking direction to register the FIR.
Oh, yeah, fire register. Yes. ಯಾಕಾಗಿಲ್ಲ?
ಯಾಕಾಗಿಲ್ಲ ಅಂದ್ರೆ my lord's is, he alleged that is the inspector, he has assaulted. Inspector has assaulted.
ಹಾಕ್ಬಾರ್ದು ಅಂತಿದ್ಯಾ?
ಅಲ್ಲ ಮಾಡ್ಬೋದು, ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ಬೋದು.
ಯಾಕೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಂಪ್ಲೇಂಟ್ ತಗೊಳಲ್ವಾ? ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ರೆ is above the law, is it?
This is allegations.
So what? Allegation is a cognizable offense. Just because he is a policeman, you are not registering the crime?
And ಆಮೇಲೆ annexure A may kindly be seen. ಅದರಲ್ಲಿ ಇದು my lord's the medical report. Which never indicated that the name of the.
ಅದೆಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸರ್. Why are you thinking?
Yes.
Crime register ಮಾಡಕ್ಕೇನಂತೆ?
My submission is under section 156(2), he has to my lords the approach the my lords the concerned station in case no complaint is not taken.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್?
ಯಾರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಅದು ಕಂಪ್ಲೈ ಮಾಡಲಿಲ್ಲ ಪ್ರಾವಿಷನ್.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
To the deputy commissioner, sorry my lords, to the my lords the
deputy commissioner,
sorry, home minister annexure B,
DG, IG,
and thereafter my lords
ಯಾಕೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ?
ಕೊಟ್ಟಿಲ್ಲ, ಸ್ಟೇಷನ್ ಕೊಡಲಿಲ್ಲ.
They are not entertaining. That is why I returned to the highest authorities.
ಗವರ್ನರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪೆಟಿಷನರ್ ಸುಮ್ನೆ ಯಾರು ಅಲ್ಲಿಗೆ ಹೋಗಲ್ಲ ಸರ್. ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಂಪ್ಲೇಂಟ್ ತಗೊಂಡ್ರೆ ಸರಿಯಾಗಿರ್ತಾರೆ. The petitioner is before this court seeking a direction for registration of the crime. The petitioner heard words. The petitioner is said to have been assaulted by the fifth respondent. Fifth respondent is the police inspector of Sandur police station. The petitioner seeks to register a complaint before the jurisdictional police. Since the fifth respondent is the accused in the complaint, it is the allegation of the petitioner that the complaint is not even registered. Therefore, he has complained to all the powers that be, including the home minister and all others, that his complaint is not being taken, and he is the one who has been assaulted by the fifth respondent, the police inspector. It is no law that merely because a complaint is made against a policeman, the jurisdictional police should not register the crime and make the complainant to roam from pillar to post. What is alleged in the case, what is alleged in the complaint is a serious assault of the fifth respondent upon the complainant, the petitioner. The citizen is now knocking at the doors of this court on the ground that a policeman is accused and therefore the complaint is not being registered. The matter, this would become a serious matter as the complaint is not registered on the score that the fifth respondent is a policeman. Therefore, the complaint so made by the petitioner or the petitioner making the complaint to all the persons shall be treated as a complaint before, which is the jurisdictional police?
Sandur
police.
Before the jurisdictional police, shall be treated as a complaint registered before the station house officer of the jurisdictional police.
Yes.
In case the fifth respondent is the station house officer, the investigation shall not be handed over to the station house officer, i.e. the fifth respondent, but the investigation to any other authority, by the DG, IGP, ಅಲ್ಲಿಗೆ ಯಾರಿದ್ದಾರೆ? By the superintendent of police of Ballari. The complaint shall be registered forthwith and investigation be carried on, investigation be conducted thereon, ordered accordingly. Right. Yes.
21. Commissioner for
The petitioner is the land loser, my lord.
C category.
According to BTDA, my lord.
Learned AGA is directed to accept notice for respondent.
2 to 4 Sanjay Chanal is there.
First respondent Sanjay so and so 2 to 4 list on 24th November. Next.
Date may be fixed, my lord.
24th is date, sir. 24th November is a date.
Obliged.
Please, Lordship.
22 parole.
General parole, Lordship. The accused is the punishable offence under section 376, Lordship. For the 25 years, Lordship. The already is undergone 4 years, Lordship. He under in jail, Lordship. That page number 12, Lordship.
Prison certificate ಎಲ್ಲಿ? Imprisonment certificate ಎಲ್ಲಿ?
Page number 12, Lordship. Annex H. Annex H, page number 12, Lordship. The report of the Petrol jurisdiction at page number D, Lordship, page number 16.
ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ದಿನ ಇರಿ.
4 years.
Horrible offenses. You should not be given parole at all.
Lordship, for the conduct of the agriculture in the Lordship.
The matter.
This is the first time, Lordship.
No problem, sir. List the matter on 8th December and fresh matters list. Next.
23.
My lords, I appear for the petitioner, my lords. My lords, in this matter, my lords, there was a discrepancy in the input tax credit.
Delay.
The delay, my lords.
107, wait, sir.
107.
ಯಾರು ನೀವೇನಾ?
Please.
Come on. Learned AGA is directed to accept notice for respondents. List on 17th in fresh matters list. This should be disposed. AGA.
Please.
ನೋಡ್ಕೊಂಬನ್ನಿ. Next.
Grateful, your lord.
Regularization.
Direction.
Learned HCGP is directed to accept notice for respondent 1, 2, 3, 4 and 5 formal parties.
Formal parties.
Notice need not be issued to respondents 4 and 5 for the present. List on 24th, 17th Saka? 19th November.
Please.
In preliminary hearing.
25. Bhagiraj.
It's appearing for the
Karnataka Bank ಯಾರು appear?
Girish Ulmani, sir.
Learned Counsel Girish Hulmani is directed to accept notice for the respondents. Petitioner to serve set of papers upon the aforesaid counsel. List on 17th in fresh matters list. Next. Guest lecturer ಎರಡೂನು.
Kindly pass for your lordship because some papers they have not served properly, all the papers. ಚೂರು ನೋಡಿ
The
ಹೇಳಿ.
petitioner to serve complete set of papers upon the learned HCGP list on Monday.
Please, your lordship.
Yes, next.
Both your
ಎರಡು,
lordship.
both
26
26,
and
27.
37.
Next.
Petitioners are the member of the respondent number 2 and 3 society. They challenge the annexed D, the selection of respondent number 3 as president of education society.
ಇಲ್ಲಂಗ್ ಬರುತ್ತೆ. Writ petition ಹೆಂಗೆ?
Because of the violation of the annex C issued by the registrar of cooperative societies. They accepting the accounts. My lord.
70.
It is registered under Karnataka Society Registration Act, my lord.
Learned
The deputy
AGA
R1
is directed to accept notice for the first respondent. 1, 2 and 3 be served by way of hand summons. List on 6th in fresh matters.
on the basis of the annexed D, they are called the special meeting on Monday, my lord.
ಯಾವತ್ತು?
Monday, 3ನೇ ತಾರೀಕಿಗೆ ಮೀಟಿಂಗ್ ಇದೆ.
Matter tomorrow in fresh matters list. ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ. Next.
They are deciding the Haveri, my lord.
ನಿಮಗೆ ಬೇಕು ಅಂದ್ರೆ ಸರ್ವ್ ಮಾಡಿ.
ಅಲ್ಲ, interim order I am seeking, my lord.
41 maintainable. Yes. ಆಮೇಲೆ.
The urgency is, my lord, third.
ಸರ್ವ್ ಮಾಡಿ ಸರ್, ನಾಳೆ ತಗೊಂತೀನಿ.
But it is difficulty to serve today, my lord, because it is Dursi village, my lord.
No problems. Yes, yes. List tomorrow. ನಾಳೆ 2:30 ತಗೊಂತೀನಿ. ಅಷ್ಟರಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿ.
I am appeal for petitioner, my lord.
Regularization.
Yes, my lord. My lord, covered by decision, my lord.
ಎಲ್ಲ covered, sir.
My lord, page number 170, my lord.
That I am aware, sir. Yes.
Yes, my lord. Malad, Kim's Malad, already Malad similarly placed the contact based employee.
ನೋಟಿಸ್ ಕೊಡದೆ ಅಲೋ ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ, Swami.
ಮತ್ತೆ wait. 1 HCGP, 2 ಕಿಮ್ಸ್ ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ?
Patil, MN Patil.
MN Patil. Counsel MN Patil is directed to accept notice for the second respondent. Copy ಇದೆಯಾ madam? Copy ಇದೆಯಾ? Petitioner to serve set of papers upon both the learned HCGP and the second counsel MN Patil forthwith. List the matter on 19th. Yes.
Please.
Next.
What is matter cell number 30? Sunil Desai, SVRG.
Lord,
Non-amendment of cost title,
Lords, I request on Monday, Your Lordship.
tender.
Please, Your
Tender of
Lordship.
this hand blocks, so out of 12 hand blocks, the petitioner applied for only 2 blocks. Whereas the interim order is obtained for the entire 12 blocks, of which the impleading respondent, my lord, has invested more than a crore.
Impleading,
ಹೌದು 75 ಲಕ್ಷ ನಾನು ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ, 25 ಲಕ್ಷ EMD ಕೊಟ್ಟಿದ್ದೀನಿ.
ಬೇರೆಯವ್ರದ್ದು ಯಾಕೆ ನಿಮಗೆ ಮೇಡಮ್?
ಅದಷ್ಟು ಮಟ್ಟಿಗೆ interim order if lordship
What is the
modifies.
ground?
Please, Your Lordship.
What is the ground?
My
Pass
Lords,
over.
the ground is like within the span of 90 days, they have not.
Ground.
Ground.
That is the only ground, whereas the.
That is the only ground ಅಂದ್ರೆ ಎಲ್ರಿಗೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
ಇಲ್ಲ, my lord, the
ಗ್ರೀನ್ ಬೆಂಚ್ ಯಾವ ಗ್ರೀನ್ ಬೆಂಚ್? ಏನ್ ಮೈನಿಂಗ್ ದ ಇದು? ಅಲ್ಲೇ ಹೋಗ್ಬಿಡಿ ಮೇಡಮ್. ಗ್ರೀನ್ ಬೆಂಚ್
ಅಲ್ಲ, ತಾವು ಅಟ್ ಲೀಸ್ಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮಾಡಿಫೈ ಮಾಡಿದ್ರೆ
ಇಲ್ಲ,
ಎಲ್ಲ ಕಡೆಗೆ ಹ್ಯಾವ್ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ಮೈ ಲಾರ್ಡ್, ಈ ಸ್ಯಾಂಡ್ ಬ್ಲಾಕ್ಸ್ ಎಲ್ಲರೂ ಎಂಟೈರ್ ಸ್ಯಾಂಡ್ ಬ್ಲಾಕ್ಸ್ ಬ್ಲಾಕ್ ಆಗಿರೋದ್ರಿಂದ ದ ಸಕ್ಸೆಸ್ ವಿಡೋಸ್ ಕೆನಾಟ್ ಆಪರೇಟ್ ಸಿನ್ಸ್ ಜುಲೈ ಇಂದ ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಅನೆಕ್ಸರಿ ಎಲ್ ಮೇ 90 ಡೇಸ್ ತಮ್ಮದೇ ಜಜ್ಮೆಂಟ್ ಕೋಟ್ ಮಾಡಿದ್ದಾರೆ. ಫಾರ್ ಎ ಮಿನಿಟ್ ಐ ವಾಂಟ್ ಟು ರೀಡ್ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಶಾಲ್ ಬಿ ಕಂಪ್ಲೀಟೆಡ್ ಆಸ್ ಫಾರ್ ಆಸ್ ಪಾಸಿಬಲ್. ಪೇಜ್ 104 ಫಾರ್ ಎ ಮಿನಿಟ್. Annexure L, my lord.
My Lords, I request on Monday, Your Lordship.
Monday ಇಲ್ಲ ಮೇಡಮ್, tomorrow.
104.
My Lords.
Tomorrow in fresh matter list finally, in the event the petitioner would not make submissions, the interim order would stand vacated.
My Lords, I
Next.
request on Monday, Your
No,
Lordship.
madam, next.
My Lords, Monday.
Tomorrow, next.
Lords, senior is.
Ask him to appear online. Next.
Lords, some inconvenience. Monday, my Lords.
Yes, next. 3 ದಿವಸ ನಡೀತಾನೆ ಇದೆ. Next.
We requested on 29th ಅಂತ ಹೇಳಿ ಅವರೇ ಹೇಳಿ ಇಡಿಸ್ಕೊಂಡಿದ್ದು 30ಕ್ಕೆ ಮಾಡ್ತೀವಿ.
Tomorrow if you don't come, I am vacating it. Next.
My Lords, interim order may kindly be extended.
Interim order will continue. AC. Interim order. ಅನ್ನಪೂರ್ಣ ಮಾಡಿ. Interim ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ನೀವು AC ಅಂದ್ರೆ ನೋಡಲ್ವಾ? ಫುಲ್ ನೇಮ್ ಕರಿಬೇಕಾ? Yes.
My Lords, Waqf Management Committee, the Management Committee of the Anjuman Islam Mudhol is constituted and it is still term is there, my Lords. During subsisting of term, the new managing committee has been passed, my Lords, on the basis of the no confidence motion. My Lords, there is no provision as such in the enactment. And second submission is that, my Lords, notice is not sent to me as required under Rule 58 of the form number 50 of the Waqf Rules, my Lords, 2017.
Yes, sir.
I appear for the contesting respondents who were not having confidence moral in the precedent. Not the present petitioners attended the meeting that was convened for the purpose of discussing the no confidence, and it was resolved moral to approve the said no confidence motion to be moved against them. Then it was forwarded to district work officer.
83 ಹೋಗಲ್ವಾ?
ಯಾವುದು?
Tribunal
83 ಇದೆ. He has to challenge before the.
In fact, moral, all these issues which are urged have been considered by this honorable court. That whether the notice has to be issued, what is the term that is there, Marod? Provision ilde idru, Marod, the very question was discussed.
Paragraph?
Yes, the question, Marod, that I'm.
Issues ಇದೆಯಾ?
Yes, one point for consideration is framed. It is on page number 16, para 27. There also no confidence was moved, Marod. Last. Yes. It has been discussed and held that if the board is having supervisory power to appoint the members of managing committee, they also have the power to accord approval of removal.
ಅಲ್ಲ ಇದರಲ್ಲಿ 83 ಬಗ್ಗೆ ಇಲ್ವಾ?
83 ಬಗ್ಗೆ discuss ಮಾಡಲಿಲ್ಲ. The writ petition was considered on merits and it has been. Now what has happened is, majority of members are having no confidence. They have approved.
By interim order they are continuing.
That is continued, but we have already taken charge. The subsequent office bearers who were chosen, They have already taken charge pursuant
You continue.
before grant of interim order.
You continue.
If subject to that, my lord,
Subject to the result of the petition ಅಷ್ಟೇ.
by virtue of this, my lord, now they are.
ಈಗ ಸ್ಟೇ ಇಂದ ಅವರು ವಾಪಸ್ ಬಂದಿದಾರಾ?
ಇಲ್ಲ ಬರ್ಲಿಲ್ಲ. He has not produced anything to that effect.
No, my lords, we have already, they have not taken charge, my lords. Charge, how to take the charge that is defined in the enactment, my lords.
ಇಲ್ಲ ನಿನ್ನೆ ಅದೇನೋ
They high-handedly enter into the
ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಬೇರೆ
premises.
ಅಲ್ಲ.
My lords,
The learned counsel Girish Dharwad, appearing for the respondent, would submit that the issues stand squarely, the contentions raised in the subject petition are all answered by the judgment of the coordinate bench in so and so. The learned counsel submits by the time the interim order was granted, the new committee had already assumed charge of the Waqf. In that light, the interim order is modified to the effect that the impugned action shall remain subject to the result of the petition. List the matter on 6th in preliminary hearing.
my lords, if they have not taken charge, my lords, they should not interfere in the position, my lords. Because they have not taken a charge, they are making false submissions.
No,
That is also approved by the district work officer.
yes, next.
Please.
Bill number 32,
Much obliged.
Mahaleshwar.
My lord, I am petitioner, my lord. I taken the loan amount to Shriram Finance, my lord. I am.
One time settlement I will not direct.
My lord, full payment ಮಾಡ್ಲಿಕ್ಕೆ ready ಇದೆ, my lord.
ಆಗೋಗಿದೆಯಾ?
ಮೇಡಮ್
ಫುಲ್ ಪೇಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ my lord, ನಾವು ಆಲ್ರೆಡಿ ಈಗ 4,03,000 ತುಂಬಿದ್ದೀವಿ my lord. ಆದ್ರೆ ನಾವೇನಂತಿದ್ದೀವಿ ಅಂದ್ರೆ ಇವರು 4 ವರ್ಷದ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಇಂಟ್ರೆಸ್ಟ್ ತೊಂತಿದ್ದಾರೆ my lord. ನಾವು 2 ವರ್ಷಕ್ಕೆ ಇದು ಮುಗಿಸ್ತಿದ್ದೀವಿ ಮೇಡಮ್. ಇಲ್ಲಿವರೆಗೆ ಎಷ್ಟು ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ ಅಷ್ಟು ತಗೊಂಡು ನಮ್ಮ ಲೋನ್ ಕ್ಲೋಸ್ ಮಾಡಿ.
You serve on them and get them. ಶ್ರೀರಾಮ್ ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ ನೋಡಿ. Petitioner to serve on a panel counsel representing the respondent. List the matter on 6th in preliminary hearing. Next.
My lord, ವೆಹಿಕಲ್ ಸೀಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮೇಡಮ್. ಪ್ಲೀಸ್
Surface, I will not interfere, sir. List on 6th in fresh matters. Sir ಮಾಡಿ, we will see.
33, KL Patil.
Yes, Patil, sir.
This is a cooperative society matter, my lord. KSRTC employees cooperative society consisting of jurisdiction of Dharwad district, Gadag, Koppar, etc.
Election process stay ಮಾಡೋದೆಲ್ಲಿಂದ ಬಂತು?
What has happened is the general body has resolved to bifurcate the societies, and that general body resolution is before the
List
registrar.
tomorrow in office objections overruled. List matter tomorrow in fresh matters list.
Published. Yes.
Yeah, same order 26/9, same.
Hearing on IA matters, bill number 45, Priyanka H. Pawar.
CH mood. Yes, comment. ಅದು ಸಾಯಂಕಾಲದವರೆಗೆ ನೋಡಿ. ಸಾಯಂಕಾಲದವರೆಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ ಸೇಮ್. ರೈಟ್. ಎಸ್.
Agreement of objections are filed.
No representation by the petitioner. List after 2 weeks.
46, Umesh Siainapur, SS.
Dispensation. For the reasons indicated in the affidavit accompanying the application, production of certified copy of Annexure G stands dispensed with. 14%.
14%, sir.
ಯಾವ್ದಕ್ಕೆ ಇದಕ್ಕ?
46.
Your petitioner.
I am petitioner is Shivram L. Naik, my lord.
Why 14% ನೀವು?
ನಾವು ಅಸೋಸಿಯೇಷನ್ ಅನ್ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡಿದ್ವಿ.
ಯಾವ ಅಸೋಸಿಯೇಷನ್ ಇದು?
ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಮೈಸೂರು ಪೆನ್ಷನರ್ಸ್ ಕಮ್ಯುನಿಟಿ.
ಅಲ್ಲ, ಇದು ಯಾವ್ದು?
ಪ್ರಸಾದ್.
48, serial number
48. Okay, sorry.
Serial number
44.
45.
ಯಾರು ಇರ್ಲಿಲ್ವಲ್ಲ?
My colleague matter, my lord, there.
Colleague matter, nobody present.
ಮುಲಾದಿ ಪರ್ಮಿಟ್ ಮುಲ ಆಗಿದ್ದೀವಿ
2:30. ಆಯ್ತು ಮಂಡೆ. ಮತ್ತೆ ಕಲೀಗ್ ಮ್ಯಾಟ್ರ್ ಅಂತ ನೀವು ಬರಕ್ ಹೋಗಿ. ನೆಕ್ಸ್ಟ್
47, Umesh Sainapur.
My lords, date from which the period of regularization starts is the question, my lords. Page 124. He has been regularized from 1/7/2005 instead of, my lords, 1/2/1994.
When did you join?
My lords, 1977 I joined, my lords.
1977.
And my lords, on a daily wage basis. And subsequently in the year 1985, my lords, I was employed as a monthly wage basis. And it starts and annexure N, my lords.
85 and 95.
85.
ಆಮೇಲೆ.
And a committee was constituted after the 1990 regulations, my lords. That is page number 95. Committee comprising of respondents herein, wherein it was held that, my lords, along with 11 others, I am also entitled for regularization from 1/2/1994. 1/2/1994, annexure N, my lords, page number 95. Contrary to that, my lords, now the impugned endorsement is issued.
Why?
Stating that what has happened is 2 rounds I came before this honorable court. Initially for seeking mandamus, and my lords, that was allowed. And endorsement was issued saying that I am not entitled for regularization from the, I am not entitled for regularization. That was challenged before this honorable court. Page number 119, my lords, again writ petition was allowed. Now after
You have retired, is it?
Retired, I have retired. They state that, my lords, 3 grounds. One is, my lords, endorsement was issued at annexure V, my lords, page number 121. Cases are pending, and that is the.
What case is pending?
What had happened, my lords, 94 to 96. It was stated that I was irregular to the work. As such, I was removed from the work. And, my lords, I approached the labor court. Labor court stated that I was not irregular, and my petition was allowed. And I was directed to continue with the service. And, my lords, 50% back wages were given to me.
ಇದೆ ನೆನ್ನೆ ಆರ್ಡರ್ ತರ.
ನಿನ್ನೆ ಆರ್ಡರ್ ಇದೆ ಬಟ್
ಅಲ್ಲ ನೆನ್ನೆ ಆರ್ಡರ್ ತರನೇ.
That was reflected in endorsement, my lord, from which date he was entitled for regularization. At page 123 may kindly be seen. Paragraph number 3.
ಇದೆಲ್ಲ ಒಂದಷ್ಟು ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ಬೇಕು. ಎಷ್ಟು ಸರಿ ಕರೆಸ್ತೀರಾ ಇಲ್ಲಿಗೆ?
123 may kindly be seen. It is also important to mention that she so and so was subject to an unauthorized absence from the service and was reinstated by the Honorable High Court of Karnataka through judgment in writ petition so and so. Paragraph 9 of the said judgment specifies.
ಅಲ್ಲ ಕಂಟಿನ್ಯೂಟಿ ಆಫ್ ಸರ್ವಿಸ್ ಕೊಟ್ರಾ ಇಲ್ವಾ?
Yes, it was given.
It was given.
It was given.
ಕಂಟಿನ್ಯೂಟಿ ಆಫ್ ಸರ್ವಿಸ್ ಕೊಟ್ಟ ಮೇಲೆ
HDMC yesterday's HDMC
ಮಧ್ಯಾಹ್ನ ರಿಕ್ರೆಟ್ ಮಾಡುವ. Password 2:30 elected.
Much. Sorry.
Next
2:30.
Number 48, Ranjita. 13%.
Lord, 48, I appear for the respondents 1 to 3, please.
Yes,
The
Kasif.
case of mandamus, your lordship. Second
Mandamus.
direct, please.
Ranjita.
Please.
Lord, matter pertains to, my lord, payment of dearness allowance at the rate, my lord, prescribed in the.
He is appearing for you.
No, your lordship. I'm for the petitioner. He is appearing for respondent.
State Bank of India.
Respondent. Yes, madam.
Please. Where your lordship representation is at page number 112, your lordship.
Why is the association objecting to it?
We are not, we are supporting respondents.
Supporting. What's the matter?
They need to file objection if they are. Please. Wherein your lordship. Annexure 112, your lordship, is a representation.
Page 112.
Please.
Annexure 112.
Oh, sorry, your lordship, page 112. Annexure G is a representation. We are seeking pension, your lordship, in accordance with regulation 35(2). Now, your lordship, they are it is paying accordance with regulation 37 of the SBM pension. Wherein, your lordship?
35(2). ನಾನೇ ಒಂದು ಎರಡು
Regulation 30. They have, my lord, they have to pay in terms of regulation 37. But they are paying dearness relief in terms of.
I think I have myself written.
Please.
Yes, sir.
This is a one judgment.
ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ ಕೊಡ್ಬೇಡಿ, ನಾನು ಬರ್ದಿರೋದು ಕೊಡಿ ಅಂತ.
Also, Your Lordship, there's one Suhasini judgment, Your Lordship, wherein the observation is clearly made. And I've extracted the operative portion in the petition itself, Your Lordship. Paragraph
ಇದು
number.
ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
My lord.
There's one judgment I have.
May I?
Yes, Kasif.
Lord, Lord, what happened was, my Lord, on 11/11/2020, there was a bipartite settlement, not 11th bipartite settlement.
11/11?
11/11/2020. My Lord, as per the joint made, my Lords are aware, my Lord, under Regulation 35, dearness allowance
37.
on All India Consumer Price Index. Now, my Lord, in the joint note, it was agreed that the dearness allowance will be calculated at 0.07% for all those people who have retired on or after 2017. My Lord, petitioner retired in the year 2020, April 2020. Calculation is done as per the joint note. Lord, that is challenged. Lord, the second, if your Lordship sees in the writ petition, they have sought to strike down clause 9C of, my Lord, the joint note, which your Lordship will find at Annexure D, page 82. The relevant clause, my Lord, is
Right, we'll continue. 2:30.
Please. Submission,
Serial
my
number
lords.
57, my lords. Serial number 57. I need 2 weeks of adjournment, my lord.
ಆಯ್ತು, ಅಡ್ಜರ್ಮೆಂಟ್ ಯಾರಿಗೆ ಬೇಕು?
Impleading ಹಾಕಿದ್ದಾರೆ. ಅದನ್ನ ನಾನು
Serial number-
Yes, yes,
ಅಡ್ಜರ್ಮೆಂಟ್
please.
ಯಾರಿಗೆ ಬೇಕು?
Number 79.
Serial number 53, my lords.
79. The conducted matter already mana reserved for orders.
ಯಾವ್ದದು?
Serial number 79 mala the Bharat Civil. Mala the regarding mala the regularization. Already reserved for
ಆಯ್ತು,
orders.
ಇರ್ಲಿ, ಅದು ಅಡ್ಜರ್ನ್ ಮಾಡೋಣ.
technical error, my Lord, I got logged out.
VC wait, sir. Madam, 3 occasions in the Sunil Desai is taken time. Well, ಅವ್ರಿಗೆ ಹೇಳಿ, ಅವ್ರಿಗೆ ಮಂಡೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇರುತ್ತೆ ಹೇಳಿ.
My lord, serial number 111, my lords. Serial number 111, my lords.
ಅಡ್ಜರ್ಮೆಂಟ್ ಎಲ್ಲ
No, my lords.
ಕೋರ್ಟ್ ಆಫೀಸರ್
Refer to mediation, my lords.
ರೆಫರ್ ಟು ಮೀಡಿಯೇಷನ್.
Please.
ಮಧ್ಯಾಹ್ನ ಮಾಡೋಣ.
My lord, serial number 53, my lords. State government will have to file a statement of objection, my lords, in that because
Wait,
state
sir,
has to take a.
My lord, on memo for Andaluri, my lord. For serial number 6, my lord.
Serial number 51, my lord. That may be posted in the adjournment. ಮನೆಗೆ ಹೋಗೋಣ ಅಂತ ನಿನ್ನೆ ಕಾಂತಾರ ಮೇಡಮ್ 57 adjournment ಹೇಳಿದ್ದೀನಿ.
Madam, serial number 53, madam.
Sir, ಹೇಳಿ 43
53, 53.
53.
ಅದರಲ್ಲಿ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಇದೆ, ಅವರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಬೇಕಾಗಬಹುದು ಮೇಡಮ್. ಅದರಲ್ಲಿ ಐ ಆಮ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1.
Sir, serial number 53.
ಹೌದು
Adjournment.
ಹೌದು ಮೇಡಮ್.
ಯಾವಾಗ ಸರ್?
2 weeks ಸ್ಟೇಟ್ ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್ ಅದರಲ್ಲಿ.
So 11 sir? 11th of November?
11 ಅಲ್ಲ?
11th of November.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Hello, court officer, sir.
Yes, madam.
How many Passover matters are there?
Only one Passover, madam.
Okay, all right. Thank you, ma'am.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯಾಮ್ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಮ್ಯಾಟರ್ ಬಂದ ತಕ್ಷಣ ತಗೋತೀರಾ?
ಹಾ ಮೇಡಮ್, ಬಂದ ತಕ್ಷಣ ಕೇಳ್ತೀನಿ. 2:30 ಅಂತ ಇದೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಓಕೆ ಓಕೆ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಟಚ್ ಮಾಡ್ರ? One. Respondent Karkomani, I'll take it. Rajshekhar Burji. I'll take it at 4:30. Why? Why special orders? CRP. ಇಲ್ಲ ಆಯ್ತು, ಯಾರು ಅನಂತ ಹೆಗಡೆ ಸಾಹೇಬ್ರು ಮುಂದೆ ಹೋಗಿಲ್ಲ. ಸರಿ. We'll hear it. I'll reach. Wait. Yes. Yeah. Order 711. ಟೈಮ್ ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್. 139. KDB. Both the learned counsel appearing for the petition and the respondent would submit that in the event that if the matter would be referred for settlement to the referred for mediation for settlement, there are chances of the matter being settled. In that light, the matter is referred to mediation. On the parties to appear before so and so on 6/11/2025. Yes.
In serial number 40.
List the matter on 17/11/2025.
Serial number 49, my lords. I filed impleading IA. My name is not shown, my lords. Lordships.
ಬಂದಿಲ್ಲ ಇನ್ನು 49.
Sorry.
Please. ಆಯ್ತಾಯ್ತು, ಒಂದು ನಿಮಿಷ.
Serial number 51, my lords. 51. I'm for the petitioner in that matter. There is a delay of 75 days. He appears for the respondent.
Wait, sir. ಅರ್ಜೆನ್ಸಿನ ಎಲ್ಲದರಲ್ಲೂ.
He has some personal inconvenience in that.
ನಾನು ಇನ್ನೂ ಓದಿಲ್ಲ ಅದು, ಅದಕ್ಕೆ ನನಗೆ
ಓದಿಲ್ಲದೆ ಇರೋದು is not personal inconvenience, but that is professional inconvenience.
One date.
Lords, delay may be condoned and it may be listed in a fresh matter.
It be called.
Yes.
Please.
Serial number 76, my lords, with connected matter listed on tomorrow. Kindly.
Yes, Ruben.
Serial number
Bangalore matters.
I'll take now. I'll call it now.
Can I mention one matter, my lords? Lords,
Which one,
for
sir?
adjournment, my lords, serial number 4. We have informed everybody. Serial number 4, my lords.
Serial number 4.
Is that renewable energy policy matter, my lords? There's a batch of.
Yes. Is the
this was heard on the
RE
other
policy
day.
matter, my lords. No, my lords, this has not been heard before, my lords. This was, my lords, 2 weeks. If my lords, it's a batch matter. If my lords are whenever in Bangalore, it would.
Whenever
be,
your lordship
we'll
is
do it on
physically
VC
present
minutes,
in Bangalore, my lords.
We'll take it on 27th.
27th.
27th and 28th. Bench, I think, is in Bangalore. We'll take it on 27th.
28th, if it's convenient, Your Lordship. I have to travel from Delhi for the case.
No, 28th, sir. No problem.
27th, we'll make a start.
I am for the
28th.
petitioner in the lead matter, Your Lordship. 28th, if it.
Serial number 4. List the matter on 28th at 2:30 p.m.
Obliged.
Yes.
Grateful.
My lord,
Grateful.
Next.
My lords, those interim orders may be continued, my lords, in serial number 4. Great.
ಕರೆದ್ಬಿಡಿ ಎಲ್ಲ.
Matter pertains to principal bench. Serial number 1. Gowda and Jagdish.
I am for the petitioner in this matter, my lordship. Place for a 2-week accommodation to report the settlement, my lordship.
Learned counsel. ಮತ್ತೆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಮಾಡಲ್ಲ, ಕೊಡಿ ಇಲ್ಲಿ.
ಅಲ್ಲ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದು ಆಲ್ರೆಡಿ ಔಟ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಸೆಟಲ್ ಆಗಿದೆ. ಅದನ್ನ ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕು, ಹಾಗಾಗಿ ನೋಟಿಸ್ ಆಗ್ಲಿ ಅಂತ ಕೇಳಿದ್ದೆ. ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸರ್ವ್ ಟು ದಿ R2 minutes.
Petitioner seeks 2 more weeks time to report settlement in terms of the earlier submission. List the matter on Friday. That's the matter on 21st November. Yes.
Much obliged, my lordship.
Next. Dictating irli hange. Amel maad.
Serial number 3, Rajesh Kumar.
My lord, for the petitioner, my lord.
For the respondents, my lord.
Yes, sir.
Yes, my lord. Yes, my lord. My lord, just a brief introduction to the matter, my lord. My lord, this is a case, my lord, where there are basically 3 competing claims on the same property, and this is the third round of litigation. My lord,
yes.
One family belongs to the present plaintiff, that is Lachmaya's children. The second belongs to one Chettiar, represented by one Vijay Kumar.
My lord, if I may interrupt for a minute, this matter is fairly complicated. When your lordship comes to Bangalore, we'll argue it here, my lord. It will be more convenient, and we will be able to put forth our points.
List the matter on 27th.
27th, my lord.
Yes, list the matter on 27th at 2:30 p.m. for further hearing. Interim order, if any, subsisting, will continue to the next date of hearing. Yes.
Grateful to your lordship.
Next.
It is actually till further orders, my lord.
For the hearing, sir. Yes.
Yes, ma'am.
Interim order is until further orders, is it?
Yes, my lord.
Then don't continue. Yes, next.
Serial number 5, Kashyap.
I appear for the petitioner, my lord. BDA has not yet filed its objection. Which is that
Respondent, my lords, kindly press 10 days time, my lords. We are sought for the
The
instructions.
Learned Counsel appearing for the respondent seeks 10 days time. Oh, this is the toll plaza.
Toll gate matter. Yes.
Yes, sir.
On the last case, they said they were ready to give the endorsement and it will be filed with the objection. That was more than a month ago, my lord.
Counsel for the petitioner seeks, counsel for the respondent seeks 10 more days time to file statement of objections. In the light of the matter being heard on 22/7/2025 and later on a subsequent date, later on 18/9/2025. List the matter on 27th at 2:30 p.m. for the hearing.
Interim order may be extended, my lord.
System will continue till the next date of hearing.
Serial number 6,
Yes.
For the respondent in this matter, can I seek for 2 weeks time, my lord, to file my objection statement? Objections filed ಮಾಡಕ್ಕಾಗ್ಲಿಲ್ಲ in view of this lord census and things like that. Officials are not available now. That is the reason, my lord, I could not file my objection statement. Grant me 2 weeks time, my lord. I'll file my
The
objection.
Learned Counsel B.S. Satyanand seeks 2 weeks time to file statement of objections. List on 27th. Yes.
Please.
Objections, if any, by then as a last chance. Yes. Next. Go back to the list. Adral serial number 2 same. First preliminary ಮುಗಿಸ್ಕೊಂಡು.
Serial number 48.
Perfect for the respondents, please.
Yes, Kasif.
But in fact, I had not placed my objections on record. But claim pertains to, my lord, grant of dearness allowance at the rate prescribed in the pension regulations of the year 1995. My lord, what happened was, my lord, in 2017, after amalgamation and associate banks having been taken over by State Bank of India, a circular came to be issued, my lord, Annexure B, page 67. My lord, options were given to all employees of Associate Bank to either choose the service emoluments existing in the banks, or, my lord, to choose State Bank of India's emoluments. Now, my lord, as far as petitioner is concerned, my lord, he had availed the opportunity of continuing with State Bank of Mysore's emoluments. Now, my lord, in that will, your lordship will get that at page 73, my lord, the relevant portion. My lord, what happened then, my lord, was, my lord, Annexure D, page 82, joint note dated 11/11/2020 was signed. My lord, dearness allowance, my lord, which did not form part of, my lord, the circular 33/2017 Annexure B. My lord, dearness allowance, my lord, the rate at which it was supposed to be calculated was fixed in this joint note at 0.07% of pay. What the petitioner is claiming is, I am being paid pension. No, my lord, pension I am paying.
Which clause do I get? Which clause
Page
in the
number
settlement?
92.
Page 90, my lord, and 9C. I'm sorry, page 92, clause C, my lord, 9C.
92.
92, my lord, just above clause 10, serial number 9C, dearness relief on pension. My lord, this was notified that with effect from 1st November 2017 in respect of officers who retired or died while in service on or after 1st November 2017, dearness allowance shall be paid at 0.07% per slab on the basic pension. My lord, petitioner retired in the year 2020. My lord, based on this, it is calculated. Yes, my lord, April 2020. What the petitioner is now claiming, my lord, is because I had exercised the option of continuing with the emoluments associate bank, you pay me pension dearness allowance as per that and not as per joint. Dearness allowance was not part of the circular annexure P, page 33. Lord, in fact, I'm paying pension, my lord, in accordance with the exercise done by the petitioner. It is only about calculation of dearness.
Our chamber, yes. Yes, Kasif.
Yes, my lord. Lord, relevant portion by lord will get of annexure B at page 73. This was the option page 7. Lord, terminal benefits, pension, provident, and gratuity. AB, my lord, stands for associate banks. Associate banks employees will have an option in the offer letter to select SBI terminal benefits as mentioned below in option A in order to ensure that AB's employees are not at a disadvantage due to offering of SBI's terminal benefits to them.
Why did this settlement come? 1 minute, Kasif. Why did this settlement come about?
My lord, this settlement will not pertain to several other things. My lord, joint note, if your lordship sees, my lord, several other things, one of which was, my lord, rate of dearness allowance.
To whom
page, Lord, Indian Bank Association and Officers Association. In fact, my lord, there's a bipartite settlement of the even date, that is 11th bipartite settlement.
But
Lord, therefore,
those who have given, Kasif, those who have given option under the statute, when the settlement, when the regulations were notified on 29/9/1995, for coming into the fold of pension under the regulations, they would be covered by the statute throughout their service. How is that a settlement that comes? No, how is that a settlement that comes about in 2020 tinker with the rights of the persons who have already opted for pension under the regulations earlier?
If my lord sees, my lord, the pension regulations of my lord State Bank of Mysore that is produced by my learned friend.
Ultimately, pension now will have to be paid as a dearness allowance will have to be paid in terms of the statute. Correct.
In terms of, I'm not denying that. All I'm saying is, my lord, even under pension regulations, if my lord sees the pension regulations, dearness allowance is paid, my lord, as per my lord regulation number 37.
37, correct.
My lord, 37, page 46, your lordship will find. My lord, computation is at appendix, which my lords will get at page 62.
Yes, respondent, ಏನು ಮಾಡಿದ್ದಾರೆ ಈಗ? In terms of this settlement, what is done?
They have not amended pension regulation from the date of initial notification.
That is what was observed in Suhasini Shetty also.
Sir.
Yes. Position remains the same?
Remains same.
Even today, you have not
even
amended
today
the
they have not amended.
Lord, that's because the amalgamation happened much later, my lord, in 2017. And then, my lord, Mysore State Bank of Mysore ceased to exist. Now, State Bank of India, my lord.
Yes.
In fact, in other cases, they are admitted that they are paying accordance with the rule 37, regulation rule 37.
The document what I have submitted today is a letter from State Bank of India to All India Retired Bank Employees Association, wherein they have admitted that they have paid, dearness relief has been paid in terms of regulation 37 of Bank Employees Pension Regulation 1995. It is in writing, sir.
One document, one application they have filed today.
Can I have a look at that later and then Lord respond?
They have filed today.
Today, copy serve ಮಾಡಿ ಅವರು.
ಇಲ್ಲ serve ಮಾಡಿದ್ದಾರೆ. It is before your
ಅವರು ನಿಮಗಲ್ಲ ಬ್ಯಾಂಕ್. Yes. The learned counsel appearing for the petitioner and the counsel representing the petition respondent representing the union submit that the State Bank of India has itself communicated to the petition respondent association that the dearness allowance would be paid to all the retired
Has
employees.
been paid.
Is being paid to the retired employees in terms of regulation 37 of State Bank of Mysore officer employees pension regulations 1995. The learned counsel for the petitioner seeks to distinguish the same on the score that State Bank of Mysore is no longer in existence, as on 1/4/2017 the banks come to be merged to become all the subsidiary banks to the State Bank of India get merged into State Bank of India. In therefore the communication or communication that is now placed before the court be served upon the bank, list the matter on 18th in fresh matters list.
Yes, right.
Please. Okay.
49, Himmat Reddy Sahuka.
This matter filed an impleading application which has not, the name is not reflected in the cause list.
One submission.
Matter in
Compromise petition, Lok Adalat decree has been challenged. May I request to take up page number 17? Page number 17 of the writ petition.
Oh, stay there.
Stay there.
Some of the defendants have been deleted in the trial court.
Date of the suit for
Partition and separate possession.
Suit of the year
2017.
17 minutes. ಇಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ two facts which are required to page number 17 minutes. Family tree is there.
I am there.
Yes, minutes. Minutes they claim under Shobha. Prativadi number 5. Prior to this there was suit wherein Shobha has relinquished her claim in that suit, OS number 64, wherein she has relinquished her claim. Thereafter she lived and subsequently.
Where is the relinquishment?
Along with my statement of objection I have produced.
ಈಗ ಸೂಟ್ ಹಾಕಿರೋದು ಬೇರೆ
ಇದು ಬೇರೆ ಸೂಟ್. One of the defendant, one of the sister LRs were not brought on record.
ಈಗ who are you? Petitioner ಯಾರು?
Husband and daughter of Shobha.
Where is the relinquishment deed?
Relinquishment deed ಅಲ್ಲ, compromise decree. That is also compromise decree. That they have not challenged.
ಮತ್ತೆ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ಈಗ?
Subsequent suit wherein my lord, so another daughter was given with the share. In that my lords, that compromise decree they are challenging.
ಇವ್ರಿಗೂ ಬರುತ್ತಲ್ಲ?
ಇಲ್ಲ, 64 my lord, she relinquished her share in the suit property.
Other daughter also had relinquished the share.
Yes, ಅಲ್ಲಿ ಏನಾಗಿತ್ತು, one of the LRs were, one of the branch LRs were not made party. So what they did is they filed a suit wherein ನಾವು ಅವ್ರಿಗೊಂದು ಶೇರ್ ಕೊಟ್ವಿ, that was compromised.
ಅದಕ್ಕೆ ಅವ್ರು ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ, ನೀವು ಒಂದು ಶೇರ್ ಕೊಡಿ, ಇದು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ.
ಅಲ್ಲ she has
ಅಲ್ವಾ ಹನುಮಂತ ರೆಡ್ಡಿ ಅವರು?
ಅಲ್ಲ,
Their claim is that the relinquishment, it is to be adjudicated in suit. They died during the pendence of the suit. They litigated among themselves. They compromised the matter. Refer to media, the Lok Adalat.
Who had a right in the property?
Shobha
had a right.
Yes.
Shobha entered into a compromise.
No.
Then who entered into compromise?
She has been deleted from the cause list
after death.
Yes.
Cause list
in the present suit.
ಅಲ್ಲ,
OS death ಇಲ್ಲ OS number 64.
OS ಯಾವ ವರ್ಷ?
64.
1964.
ಇಲ್ಲ OS number 64 of 2015.
Present suit is 162 of 2017.
When did this here Shobha was a party?
Yes, my lords.
What happened to this suit?
In this suit we all compromised.
Date of compromise.
Date of compromise, my lords. 14/6/2016.
When did Shobha die?
She died on 10/2/2019.
E compromise was never questioned by Shobha?
Never.
Anything else, sir?
This Shobha is implicated in the present suit.
After the death file
Yes.
ಮಾಡಿದ್ದು.
ಇಲ್ಲ ಇಲ್ಲ
ಈ suit ಯಾವಾಗ ಹಾಕಿದ್ದು?
2017.
17.
Why did you implicate Shobha again?
ಅಲ್ಲ ಅವ್ರು ಮಾಡಿದ್ರು, ನಾವು ಮಾಡಿಲ್ಲ. Plaintiffs in that suit, they arrayed and they got it deleted.
Anything else, sir? If Shobha was aggrieved by the compromise, she would have questioned it from 14/6/2016 to 10/2/2019.
According to us, my lord, there is no compromise at all.
Who is saying so?
No, but they say that it.
Who is saying so? No compromise at all, anta.
No, but since.
Who is Shobha is saying so? Is Shobha saying that there is no compromise?
But subsequently, my lord, the suit for partition is filed. She has been implicated.
They deleted later. After the death delete ಮಾಡಿದ್ರ ಮುಂಚೆನೆ ಮಾಡಿದ್ರ?
It's a deletion 26/8/2019 it was deleted.
ಯಾವತ್ತು?
26/8/2019.
ಅದೇ ಡೆತ್ ಆದ್ಮೇಲೆ ಡಿಲೀಟ್ ಮಾಡಿದ್ದೀರಾ? ಮುಂಚೆ why did who arraigned? Who was the plaintiff there?
Plaintiff in that suit.
Plaintiffs.
In that suit, my lords. ಇಲ್ಲ ಇಲ್ಲ ಆ suit 164.
ಯಾವ್ದೋ ನೀವು ಮೂವಿ ಹೆಸರು ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಅಮರ್ ಅಕ್ಬರ್ ಅಂತ
ವಿನಯ್ ನಿರ್ಮಲಾ.
ವಿಜಯ್ ವಿನಯ್ ವಿಶಾಲ್. But yes.
And in
They filed a suit, and in that suit, not firstly, not they implemented, subsequently, not they were deleted. And now, not in fact, we have filed an
You
application.
show me one thing. You are claiming under Shobha. You are Shobha's husband and daughter, correct?
Yes.
No doubt. Show me one document to demonstrate that Shobha herself questioned this compromise to be a fraud. Adu idu ella from 14/6/2019 till 10/2/2019. Shobha is not the plaintiff in the subsequent suit. She was a defendant. Somebody else had filed the suit.
No, but one of the sister has filed.
Maybe if Shobha herself had questioned it, then it's a different. ಬಿಟ್ರೆ ಇನ್ಯಾರು ಕ್ವಶನ್ ಮಾಡ್ತಾರ ಆಮೇಲೆ?
But a suit is filed, not, and admittedly, they are deleted. Among themselves, they have settled it without giving any share to other defendants. Not only this defendant number 5.
Shobha's right stood extinguished. That also, Shobha was the plaintiff there?
Yes, my lords. Plaintiff number 2.
ಯಾವ್ದ್ರಲ್ಲಿ?
OS number 64.
64 ಅಲ್ಲಿ she was plaintiff number 2. Yes. ಇಲ್ಲ, plaintiff and defendant in a partition suit is illusory, but
I will get instruction about that matter. What is the
And they
subsequent
were
suit?
aware in the another suit, they have clearly stated that, my lords, OS number
But,
64. They
admittedly,
cannot say
my lord,
that,
they
my
have
lords, we
deleted.
had no knowledge.
if Shobha had questioned it during her lifetime saying that it was a fraud, then it's a different thing. She is herself the plaintiff. The suit is compromised. Share is, she is allotted shares?
ಇಲ್ಲ, she relinquished her rights.
ಯಾವಾಗ? In the compromise itself.
ಹಾ, in compromise itself.
Why?
ಅಲ್ಲಿ 1.5 ಗುಂಟೆ ಬೇರೆ ನಮಗೆ ಜಾಗ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರು ಮೊದಲೇ ಮದುವೆಗಿಂತ ಆ ಟೈಮಲ್ಲಿ. ಸೊ ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಫೈಟ್ ವಿತ್ ದಿ ಬ್ರದರ್ಸ್.
ಎಷ್ಟು ಬಂದಿರೋದು ಶೇರ್ ಅಲ್ಲಿ?
ಶೇರ್ 1.5 ಗುಂಟೆ ಬೇರೆ ಟೈಮಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು.
ಎಷ್ಟು ಶೇರ್ ಬಂದಿರೋದು ಒಬ್ಬೊಬ್ರಿಗೆ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ?
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಬರ್ತಾ ಇದೆ.
ಎಷ್ಟಿದೆ?
ಮಿನಿಟ್ಸ್
ಅದೇ ಕೇಳ್ಕೊಂಬನ್ನಿ ಅಷ್ಟೇ. ಲಿಸ್ಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಅಂಡ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್.
ಅಲ್ಲ, ಅದು ನಮ್ದೊಂದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
ನೀವ್ ಯಾರು ಸರ್?
ನೇಮ್ ಇಸ್ ನಾಟ್ ಡಿಸ್ಪ್ಲೇಡ್ ಟುಡೇ.
ಪರವಾಗಿಲ್ಲ, ಅದೇ ಹೋದ್ರೆ ನಿಮ್ದೇ ಹಾಕ್ಬೇಕು. ಯು ಆರ್ ಸಪೋರ್ಟಿಂಗ್ ಹಿಮ್ ಆರ್?
ಎಸ್.
Yes, next. Tuesday.
Interim order may kindly be.
Tuesday preliminary hearing, interim order subsisting will continue to the next date of hearing. Yes.
Till number 50, Santosh R. Kolkar, CVMD.
Dispensation. In person?
No, no minutes. Petitioner, my lord.
Yes, sir. What's the dispensation?
Related to the petroleum outlet, dealership of petroleum outlet, my lord.
Correct.
Wherein
ಅಂಗಡಿಯವರು ರಿಪೇರ್ ಆಗ್ತಿದ್ದಾರೆ ಅಂದ್ಮೇಲೆ.
yes, And they have also filed the objection statement also.
Buildings complete,
Completed. Everything is completed.
Case ಹೇಳಿ.
Please, man.
Argue, sir.
Please. Wherein the company had issued the advertisement for calling the dealership of outlets, wherein they have asked the required land, wherein I have mentioned in Annexure A, page number 13.
You are not selected?
I have selected, sir. I have selected in group 1, wherein the land was
land name ಸ್ವಂತದ್ದಾ?
ಸ್ವಂತದ land.
Group 1 select ಮಾಡಿದ್ರು.
Group 1 selected, wherein the company has asked the required land on page number 13, sir. Annexure A. 25 meter into 25, wherein I have complied the same, sir. Wherein thereafter they have visited the land evaluation committee, visited to the land, sir, wherein I have produced the document and the land evaluation committee have verified the land and they have intimated to the company that the land offered by the petitioner is not required as per the NH norms.
ಏನ್ NH norm?
Because the location shown is situated on a national highway, sir. National highway, wherein in the advertisement they are not mentioned whether the location shown by the company is situated at the national highway or state highway or within the city. That has been not shown.
Right. ಅಷ್ಟೇನಾ? That's all the ground.
That's all.
Yes,
Even the one submission, if the company is required additional land, the petitioner is ready to provide the additional land.
ಈಗ ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
No, sir.
ಬೇರೆ ಯಾರಿಗಾರ ಅಲಾಟ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, no.
ಯಾರಿಗೂ ಮಾಡಿಲ್ವಾ?
No.
The entire notification containing 1135 locations are produced the document at annexure R1, my lord. No doubt, my lord, this particular location in question, the size of the land to be offered,
correct ಆಗಿದೆ.
It is shown as 25 to 25 square meters. Then, my lord, at the last page of this particular notification, there are certain notes, my lord. With permission, I'll read, my lord. This page number 32 of my statement of objections. That's of paramount importance, my lord. Page number 32. Last 4 lines I'll read, my lord. The explanation of the columns in the table is given in the brochure, which also contains detailed guidelines of selection procedure for dealership, along with application form and other relevant details. The brochure is available in the corporation website, and can be downloaded free of cost. Then it is in bold letters. The applicants, in their own interest, should carefully go through the brochure and understand. Yes, my lord.
Conditions apply.
Yes, ma'am. That brochure have produced it at annexure R4, my lord. In that brochure, in relevant contents, my lord, it is at page number 102. Annexure R4.
Why have you rejected his pen?
No, because as per this particular brochure terms and conditions, for the sites which are abutting the national highways, those sites should meet the NHA norms, my lord. For that, my lord, which is statutory and which cannot be bypassed, my lord. So I
will give you another land.
Pardon, my lord?
He will give you another land.
No, it is all the eligibility criteria to be satisfied as on date of cutoff.
He is the only thing, right?
He is the only person.
Advertisement ಏನಿತ್ತು? Where is your advertisement?
Advertisement, my lord, location, it is in a stretch of 3 points.
Have you indicated in the advertisement or calling for applications?
We have shown the detail.
Brochure ಅಲ್ಲಿ ಓದ್ಕೋಬೇಕು ಅಂತ ಹೇಳಿರ್ತೀರ.
Yes, my lord.
ಇವ್ರಿಗೇನು ಗೊತ್ತಾಗಲ್ಲ. ಅದು ಪಾಲಿಸಿಲಿ ಕಂಡೀಷನ್ಸ್ ಅಪ್ಲೈ ಅಂತ ಚಿಕ್ಕದಾಗಿರುತ್ತೆ.
Because my lord,
ಏನು ಗೊತ್ತಿರಲ್ಲ.
These NHA norms are to be dealt separately by the applicant, because it cannot be, my lord, avoided. This provisions
apply tiny ಆಗಿರುತ್ತೆ. ಅದರ ಮೇಲೆ you will build up your case when it comes to the.
No, my lord, this stretch is
problem. Even if understood, but it can't be abutting the national highway. ಅದನ್ನ ಹೇಳಿದ್ರೆ ಅವರು ಅಪ್ಲೈನೇ ಮಾಡ್ತಾರೆ.
No, section 28 and 29.
They would not have applied at all if that was indicated in the advertisement.
In their own interest, that's why not the note was put. They should read the brochure in entirety and they should ensure that the NHI norms are complied.
ಯಾರು ರೈತರು ಜಮೀನು ಇಟ್ಕೊಂಡ್ರು ನಿಮ್ ಬ್ರೋಷರ್ ನ ಓದ್ಕೊಂಡು ಕೂತಿದ್ರು.
The applicant is company also, sir. No, the applicant is ex-employee of the corporation.
Required to follow the brochures.
My applicant is
ex-employee of the corporation. After retirement, he has applied.
Applicant is not the ex-employee.
Then, my lord, this particular guidelines, my lord, I have produced.
Why is Suryaland sir waiting? 128, which Bangalore matter? ಇಲ್ಲಿದೆನಾ? Time fix ಮಾಡಿದ್ನಾ?
ಇಲ್ಲ, this has come up before the earlier roster. We don't have an interim order, that's why.
We'll see. What 7 o'clock is your flight? 8 o'clock. What time is your flight?
I'm taking the train. I have time. I'll
Then
wait.
no, wait. Yes.
Well, there's two sections under this Control of National Highways Act 2002. I'll draw your honor's kind attention.
No, I am with you in so far as it concerns.
Yes,
if it is abutting the highway, license should not be granted.
Yes.
But why you do not inform that?
That
He is an ex-employee of the corporation, is it?
No, that we have intimated. We have intimated that letter of communication he has impugned in this writ petition. I also produced the guidelines at annex number R2.
He will give you another land.
Not that provision is not there, my lord, because
Provision is not there.
eligibility criteria, they're all as on the date of the cutoff date, my lord, because this particular annex R2, my lord, page number.
No. IOC and Takshna, you can't. Yes.
My lord, this annexure R2, may I draw my lord's kind attention to annexure R2, page number 49. That NHI norms mandate that the site should be of minimum size of 13 to 30 square meters. So therefore, my lord, we cannot consider this application at all, my lord, because without taking permission of NHI, my lord, he cannot gain access to the national highway, my lord. That is the gist of section 28 and 29, my lord. They will never give permission. So even if we are inclined, my lord.
One opportunity for alternate land. He has been found eligible. He has his own land under group 1, he is found eligible.
That is one aspect.
Correct.
But dimension.
That is the only aspect.
Yes.
Now you give another chance for him to give an alternate land. Take it.
But there is no provision, my lord, because it is
division bench. Your provision is made in the division bench.
We will consider his request and pass orders.
ಅದನ್ನೇ ಮಾಡಿರೋದಿಲ್ಲ.
Yes. But in the guidelines, my lord, there is no provision. That's what my submission.
Guidelines no provision ಇಲ್ಲ ಅಂದ್ರೆ. Who asked you
all
to say conditions apply ಅಂತ ಸಣ್ಣದಾಗಿ. Advertisement ಹೇಳ್ಬೇಕು ತಾನೆ ಎಲ್ಲ.
Correct, but that
these are the ineligibilities and you should project, not ineligibilities when it comes to the court.
I do concede to your lordship's views. This notification which contains 1135 locations. It cannot be given on all final details.
At least that should have, you should have highlighted all that. And you should always have a disclaimer. If they don't look into it and then come up with something, the corporation is not responsible.
And they have given undertaking.
ಅದಾಗಲ್ಲ ಯಾಕಂದ್ರೆ ನಿಮ್ಗೆ ಯಾರಿಗೂ ಕೊಡಬೇಕಾಗಿರುತ್ತಲ್ಲ ಅದು ಹೋಗ್ಬಿಡುತ್ತೆ.
No, there is the sole applicant, not that to ex-employment.
You will have so many favorites to be given. No, that will go away if you say ella correct agi.
No, there was only one applicant and he was not meeting the eligibility criteria because there were 1135 locations. All final details cannot be depicted in the advertisement notification.
Not location wise, sir. Why don't you understand? While saying so, the highway, abutting the highways, these properties will not be considered.
No, that is why in the brochure I respectfully drew your lordship's attention, my lord, that NHI norms has to be met.
This man is okay. He is an ex-employee. Now some farmer will apply, a landowner.
That's why, my lord, they have to read.
Who will read, sir?
And they have to give that.
Brochure ನೋಡಿ ಎಲ್ಲಿದೆ ಅಂತ 1135 pages ನೋಡ್ಕೊಂಡು ಎಲ್ಲಿದೆ ಇದನ್ನ ನೋಡ್ಕೋಬೇಕಾ?
No, my lord, the brochure, my lord.
Why don't you issue a call for applications with clarity?
No, because of this big number of locations advertised, only at the bottom they have said one has to read.
Asking you to do location wise as a generic stance. Why don't you indicate that if there is any property is in violation of so and so will not be considered?
Correct, my lord. That could have been.
ಎಲ್ಲ ಕಂಡೀಷನ್ಸ್ ಅಪ್ಲೈ ತರ ಸ್ಮಾಲ್ ಆಗಿ ಇದನ್ನ ಬ್ರೋಷರ್ ನೋಡ್ಕೊಳ್ಳಿ.
But in the last paragraph, my lord, that one note is there in capitals, my lord. The brochure should be read in entirety.
If you really want something to come out, you should not make the process cumbersome.
These are all norms, my lord, set by the
R1, my lord, wherever the location are there on a national highway, they have specifically shown that the location is on NH ಅಂತ ಹೇಳಿ.
ಇದರಲ್ಲಿ ನಿಮ್ ತೋರಿಸಿಲ್ವಾ?
ಇಲ್ಲ ತೋರಿಸಿಲ್ಲ ಸರ್.
Because my lord, this stretch of road pertaining to this location,
serial number 327,
it is 3.7 kilometers.
R1 sir, page number 15.
317 and 27.
ಇಲ್ಲ ಎಕ್ಸಿಬಿಟ್ ಆರ್ ಅನೆಕ್ಷರ್ R1.
Annexure R1 ಅಲ್ಲೇ ಇದೀನಿ.
R1 ಪೇಜ್ ನಂಬರ್
serial number ಏನು?
ನಮ್ದು 317.
317.
327 may kindly be perused, my lord. Wherein it has been shown, clearly shown that Taluka Londa on NH 748.
No, here, my lord.
That is the location. Wherein
in 6 kilometers, Taluk Londa NH 748.
Wherein in serial number 317.
ನಿಮ್ದು ಅದು?
ಹೌದು. Serial number 317.
No, 317, it is heterogeneous, my lord. It is totally measuring 3.7 kilometers. First 1.8 kilometers, it is portion of the national highway. Remaining 1.7 kilometers, it is not.
Why have you not indicated?
I have
objection ಅಲ್ಲ, ಇಲ್ಲಿ ಯಾಕೆ ಹೇಳಿಲ್ಲ?
Yes, ma'am. I have produced the.
ಇಲ್ಲಿ ಯಾಕೆ ಹೇಳಿಲ್ಲ?
Yes,
and one more, sir. On page number 18.
ಅದೆಲ್ಲ ಮಿಸ್ಟೇಕ್. ಇಲ್ಲಿ ಬಂದು ಡಿಫೆನ್ಸ್. Why you did not indicate?
Not because of these big number of locations.
You have indicated here 6 kilometers range ಅಲ್ಲಿ ಇದೆ ಅಂತ. ಇದು 3.7 kilometers ಅಂತ ಇದ್ರೆ ಅದನ್ನ ಇಂಡಿಕೇಟ್ ಮಾಡಕ್ಕೆ ಏನಾಗಿದೆ?
But the brochure says, my lord, wherever the site is abutting.
ಆಯ್ತು, brochure says this. Why you have indicated that in the brochure?
But brochure categorically states, my lord.
Sir, 327 indicate ಮಾಡ್ತೀರಾ, 317 ಯಾಕೆ ಮಾಡಲ್ಲ?
My lord, because
I will allow the petition to directing you to give it in this place only.
My lord,
for the IOC's folly. So the whole problem is you IOC and other officers, you think you're sitting in the ivory tower and don't listen to anybody, don't do whatever at your whim and fancy you do.
Not seen that.
That's the whole problem.
There could have been finer details, but in the last para, my lord,
finer details ಬೇರೆಯವರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ವಾ ಇಲ್ಲಿ? 327 ಗೆ ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ finer details?
On page number 18.
Yes, but here it is serial number. It's a mixture.
Page number 18, serial number 470.
Location is a
470.
Allu.
Kilometer from Rupali
towards
convention.
NH 48.
Yes. And dimension is shown 20 meter into 20 meter.
Yes, sir. Here, my lord, I have produced a map at an
R5. ಅವ್ರದಲ್ಲೆಲ್ಲ ಮಾಡಿದಿರಲ್ಲ, ಬೇರೆಯವ್ರದಲ್ಲಿ ಮಾಡಿದಿರ, ವೈ ಇದರಲ್ಲಿಲ್ಲ?
But here, my lord, out of 3.7 kilometer length specified location, first 1.8 kilometers is forming part of the national highway. Remaining 1.7 kilometers, it does not. Because there could have been some applicant whose site would have been abutting the state highway portion vis-a-vis the national. Yes, my lord. But finally, at the last two notes, my lord, the highlighted note, my lord, it categorically says you have to meet the NHI norms. That's a general requirement for all the candidates, my lord.
ಆಯ್ತು ಸರ್, ಇವರು ಅಪ್ಲಿಕೇಶನ್ ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿದ್ಮೇಲೆ ಬೇರೆಯವ್ರಿಗೆ ಮಾಡಿದಂಗೆ ಇವ್ರಿಗೆ ಮಾಡಕ್ಕೇನು?
But this particular brochure, my lord, it categorically states you have to meet NHI norms and there should be no high tension wire lines passing both the offered site, all those things. They're compulsorily applicable to all the applicants.
The petitioner is before this, petitioners are before this court calling in question an order of calling in question an intimation dated 23/10/2024 issued by the respondent Indian Oil,
HPCL.
Respondent Hindustan Petroleum Corporation Limited, hereinafter referred to as the corporation for short. Reject ಮಾಡಿದಾರೆ ಈಗ?
Yes,
rejecting the claim of the petitioner for seeking allotment of a petroleum outlet on the score that his petroleum, the land that he has offered for establishment of a petroleum outlet abuts the National Highway 48.
548H.
548H. ಅದ್ಯಾವುದು 548H? AH NH?
NH. NH 548H.
AH NH?
NH.
It is national highway, yes.
AH ಅಂದ್ರೆ ಏನು?
It's not, it is shown as national highway number 548H.
But what is AH?
NH.
What is AH?
I have to seek clarification.
Roads funded by World Bank are called Asian highways. They are AH. You will find lots in the country. NH is National Highway Complete Local Funded.
Yes.
AH ಅಂತಾನು ಇದೆ, ನೋಡಿಲ್ಲ ನೀವು?
Yes. I wasn't aware.
Big roads, it is AH. Yes. The petitioner is so and so. Heard so and so. The respondent corporation issues an advertisement calling for applications for award of regular/rural retail outlet dealership in Karnataka state. The petitioners claiming to be the owners of certain parcels of land and on the plea that they come under group 1 category to get a regular outlet dealership apply in terms of the said advertisement. On scrutiny of the documents on 19/10/2023, the application of the petitioners was provisionally accepted and was declared to be provisionally selected by the respondent, as no other applicants had submitted any application under group 1 category. Therefore, the petitioners were the land of the petitioners or the application of the petitioner was provisionally processed and selected. The respondent is said to have directed the petitioner to remit the amount of rupees 40,000 towards initial security and upload all documents specified in the intimation. The land evaluation committee of the respondent corporation then fixes a date to inspect the property of the petitioner. The land evaluation committee is said to have found that the land offered by the petitioner is not meeting the required norms of offered land, as it was abutting the land offered to a portion of it was abutting the National Highway 548H, and the dimension required was 30 into 30 for urban stretch and 35 into 35 meters for a rural stretch, and therefore the land of the petitioner was not the petitioner's land was not found to be eligible. It is this that has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that that on scrutiny of the documents, the name of the petitioner figured at serial number 317. There was no indication in the said drawal of the eligible lands that it abutted the national highway. As an illustration, the learned counsel would take this court through serial numbers 327 and 470, where the national highway, where it was clearly indicated that it abuts the national highway. He would also seek to place reliance upon the judgment rendered by a division bench in Rate Appeal 608 of 2021 to buttress his submission of reconsideration of the case of the petitioner. Per contra, the learned counsel for the corporation C.V. Angadi would vehemently refute the submissions, contending that the petitioner cannot be shown any indulgence, as his land, a portion of his land to the tune of 1.7 acres, does abut the national highway NH 48H. Therefore, his land being not suitable, notwithstanding the fact that he was provisionally selected in Group 1, cannot be considered. He would submit that if this court would show indulgence and approve the place, it would throw a danger to the vehicular movement and endanger the lives. The learned counsel would seek dismissal of the petition. I have given my source. Therefore, narrated facts are not in dispute. The petitioner, in terms of the advertisement, does apply along with all the documents. The documents are processed. The processing of the documents leads the petitioner to be selected provisionally, subject to the land inspection committee inspecting the property of the petitioner and drawing a report. The land inspection committee, after the petitioner being provisionally selected, draws a report that the land of the petitioner does not qualify for establishment of a petroleum unit on the ground that the land, half of the land of the petitioner does abut the 1.7 acres.
It only measures 25 to 25 meters. 1.7 meters is the length of the road.
The measurement that the petitioner's land was at 25 to 25 meters would somewhere abut the national highway, and therefore the application could not be considered. The learned counsel, could not be considered. Therefore, it becomes necessary to notice the indication ಅದೇ ಇದ್ಯಾವುದು ಪಾಲಿಸಿಯಲ್ಲಿ
ಆಮೇಲೆ annexure R4 page number
ಗೈಡ್ಲೈನ್ಸ್
102.
ಗೈಡ್ಲೈನ್ಸ್ ಏನಿಲ್ಲ ಅಲ್ವಾ ಇದ್ರ ಬಗ್ಗೆ?
Pardon, miss?
The guidelines.
Guidelines is also there, my lord. This is
the guidelines for selection of regular and rural outlets through draw of lots is appended to the statement of objections.
Page number 102, my lord.
The identification of locations under the guidelines read as follows. The guidelines does indicate that if it is in contravention with the National Highways Act, such properties would not merit consideration at the hands of the corporation. The issue now would be whether the land of the petitioner that is offered would abut the national highway or otherwise. Though there is no indication in the list of allottees drawn, the learned counsel for the petitioner, learned counsel for the respondent would, or the submission of the learned counsel for the respondent would merit some semblance of acceptance, as it would throw a security risk to the vehicular movement on a national highway if a petroleum outlet abuts a national highway. But nonetheless, since the petitioner had been chosen to be provisionally selected and under Group 1, as he did have his own land, one more opportunity must be granted to the petitioner to satisfy the requirements of the respondent, qua the National Highways Act or the advertisement. I am fortified, in my view, by the judgment rendered by the division bench in Writ Appeal 608 of 2021, which the petitioner therein had challenged the rejection of the writ petition on somewhat identical circumstance. The division bench has held as follows. Para 7 in the end. The division bench then directs the respondents to grant an opportunity to the appellant to produce documentation to show that he was eligible for participation in the selection of Group 1. In the case at hand, the petitioner is already chosen for Group 1. Therefore, I deem it appropriate to dispose the petition with a direction to the respondent to reconsider the case of the petitioner if he would offer any other land or
abutting to the same lands. Already offered.
Any other land which would not abut the national highway. Highway ಮೇಲೆ ಕಟ್ಟಬೇಕಾ ನೀವು? ಮತ್ತೆ which would not abut the national highway. Yes, for the aforesaid reasons, the following order. The writ petition is allowed. The respondents are directed to afford an opportunity to the petitioner to offer any land any land in the vicinity which would not abut the national highway or create any problem to the vehicular traffic in the event that the land is chosen for the establishment of a petroleum unit, ordered accordingly. ಬಂದ್ಬಿಡ್ತಾ?
230 moved list. Serial number 1, KL Patil.
This is the
ಎನ್ನೇದಿತ್ತಲ್ಲ ಸೇಮ್ ಆರ್ಡರ್ ಸೇಮ್ ಪ್ರೊಸೀಡಿಂಗ್
same proceedings. Are they same proceedings? Here petitioner is the president.
All right, same proceeding ತಾನೆ?
Same proceedings.
ನೆನ್ನೆ ಎರಡು ಆಗಿದೆ.
I'll pass on the number.
ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ?
I have that.
ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. Tag this petition along with sounds.
Please.
Serial number 2, BC Gnanaya Swami.
Madam.
Lords, petitioner, your lordship, applied for post of Anganwadi worker. Your lordship, she obtained 574 marks in her PUC, and the selected candidate is your lordship 487 marks. She has been appointed.
Karana?
No, my lord, I filed objection, my lord.
Qualifying exam ಅಲ್ಲಿ 4, 5?
Your lordship, PUC 574 marks.
Our MLA close, yes.
Page number 25.
The petitioner is before the court. ಈಗ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗೋಗಿದೆಯಾ?
Final list ಬಿಟ್ಟಿದ್ದಾರೆ.
The petitioner is before this court calling in question the final select list of Anganwadi helper.
ಅಲ್ಲ, ಅಂಗನವಾಡಿ ವರ್ಕರ್.
Anganwadi worker to ಎಲ್ಲಿದು?
ಎಡ್ಡೋಣಿ ವಿಲೇಜ್ ಮಿಲೋಡ್. ಪೇಜ್ ನಂಬರ್ 25.
ಯಾವ ವಿಲೇಜ್?
ಎಡ್ಡೋಣಿ.
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 ಆಯ್ತು, ಅದೇ ನಂಬರ್ ಕೌಂಟ್.
Number 3.
The learned counsel for the petitioner submits the petitioner and the selected candidate, the 9th respondent, in the qualifying examination for the purpose of such selection, have secured 574 and 487 respectively. The petitioner at 574 marks and the selected candidate at 487. Therefore, the respondent state to explain as to why the candidate who has far less merit than the petitioner is now found in the select list and the petitioner is not. Therefore, further proceedings shall remain state till the next date. List the matter on 18th in fresh matters list. Instructions be sought and submissions be made on the said date. No objection in ಹಾಕ್ಬೇಕಾಗಿಲ್ಲ.
Please, Your Lordship, I'll get instructions.
Till number 3.
ಮೂರು ಅದೇನಾ?
This is she is a widow, my lord.
ಇದು ಮೂರು ಅಂಗನವಾಡಿದೇನಾ?
ಅಂಗನವಾಡಿ.
ಮೂರು ಅಲ್ಲಿದೇನಾ?
ಅಲ್ಲಿ ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್.
ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್. ವಿಡೋಗೇನು?
She is a widow, my lord. For give a preference, my lord, as per the notification, my lord. Page number 13.
Marks ಎಷ್ಟು?
Marks, my lord, 295, my lord.
ನಿಮಗೆ?
Please.
Selected candidate.
Selected candidate, my lord, she obtained
501.
439. Notice me.
Anything else?
It may be.
Entry order ಕೊಟ್ಟಿರೋ parity ಇಲ್ಲೇ ನಿಮ್ದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು ಈಗ. ಮಾಡ್ಲಾ?
ನೋಟಿಸ್ ಮಾಡಿ.
ನೋಟಿಸ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ. ಆಯ್ತು. Learned HCGP accepts same day.
Please,
Accepts notice for the respondent 1 to
8, my lord.
1 to 8.
8, my lord.
1 to 8, 9 emergent notice. 9
To 8, 9 notice.
9 emergent notice returnable by the 18th. ಅದು 18th 18th in fresh matters list. ನಾನು ಸ್ವಾಮಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಬೇಕು.
ಪ್ಲೀಸ್ ಅದಕ್ಕೆ ನೋಟಿಸ್ ಹೋಗಿ ಬರಲಿ.
ನೋಟಿಸ್ ಹೋಗಿ ಬರಲಿ, ಆಮೇಲೆ ಡಿಸ್ಮಿಸ್.
Till number 4.
This is also same notification, my lord.
Widowna?
House, she obtained 501 marks, my lord.
501?
Also. Selected candidate, my lord, obtained 452, my lord.
The petitioner is before the court calling in question the final select list drawn in the for appointment to the post of Anganwadi worker. According to the select list, the petitioner, we don't either know.
Illa,
normal. According to the petitioner has secured 501 marks in the qualifying examination, and the select candidate now has secured 437.
452,
which is grossly below the marks secured by the petitioner. ಅದೆಲ್ಲ ಏನು ಬರ್ದೇ ಇಲ್ಲ ಮೇಡಮ್. ಫಸ್ಟ್ ಅಲ್ಲಿ to secure instructions as to how ಅದೆಲ್ಲ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಬಿಡಿ. 18th.
Please.
So take 2, give 1 free.
Number 5. Sachin Angi.
Petition, my lord. A tender matter, my lord. Lord, this court, my lord, last time heard, my lord, and passed the order for subject to disposal of the writ petition, my lord.
ಎಲ್ಲಿದೆ?
In the order, my lord.
Date?
1710, my lord.
Further proceedings shall remain subject to the result of the petition. ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ?
My lord, identical matter, my lord, in Bangalore means, my lord, permitted the petitioner to participate in the tender matter, my lord.
ಇವತ್ತು ಲಾಸ್ಟ್ ಡೇಟ್?
Yes, my lord. Today.
Participate. The learned counsel for the petitioner. This court on 17/10/2025 had passed the following order. The learned counsel for the petitioner now places reliance upon an interim order granted by the principal bench, which permits the identically placed petitioner to participate in the tender. The interim order reads as follows. Kudi.
ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಎಂಟ್ರಿ ಮಾಡೋರಲ್ಲಿ ಆಯೇ ಹಾಕಿದ್ದೀನಿ ಆಡ್ ಫೈಲ್ಡ್
ಇಲ್ಲಿದೆ.
ಮಾಡಿಫಿಕೇಶನ್
So and so. ಇಲ್ಲಿ page 6 ಅಲ್ಲಿ ಇದೆ ಲಕ್ಷ್ಮಿ. In the light of the interim order so granted to the petition, identically placed petitioner, the petitioner also is entitled to the same order. Respondents are directed same. Ide quote ಮಾಡಬಿಡಿ ಮತ್ತೆ. Yes, list after 2 weeks.
may I seek hand delivery my lord today.
Kudi. Next.
51 Pawan B Dodati.
There's a delay in filing.
51 controversy ಇಷ್ಟೊಂದು.
Please. There is a delay. There is a delay in filing.
Suit for
declaration and injunction notes. Right of preemption is sought. After sale deed is executed.
When is sale deed executed?
Please.
711 application rejected.
Please.
On what ground?
Lords, that the issue involved has to be decided only after full-fledged trial. Anta. It has been rejected.
And is it contrary to Article 58?
Please.
You are relying on Article 58 of the Limitation Act.
Please. Even on limitation and lords, my submission would be that they are not co-sharers, lords. They are hailing from a different ancestors.
Andre evidence ಆಗ್ಲೇಬೇಕು correct ಆಗಿ.
ಅಲ್ಲ pleadings.
Anything else?
ಅಲ್ಲ pleadings. ತಾವೇ ನೋಡಿ ಸ್ವಲ್ಪ pleadings.
Cause of action and pleadings ನಿಮ್ದು ಡಿಫೆನ್ಸ್ ಅಲ್ಲ.
ಅವ್ರ pleadings ಅಲ್ಲಿ
711 ಗೆ only pleadings.
ಅಲ್ಲ that is what lords. I am referring to pleadings only.
ಹೇಳಿ.
Para 5 lords. ಸ್ವಲ್ಪ genealogy ತಾವು ನೋಡಿದ್ರೆ.
Genealogical. ನಾನು ನೋಡ್ಲೇಬೇಕು ಓದಕ. Page
lords 22. My lords clients are hailing from Rajesh Saab. Para 5 lords at the bottom. My clients are defendant number 1 and 2. Mohbad Saab. So it is not their case that they are brothers. So they
are others.
Allah, they are far relatives.
Yes. Girish, will hear it.
Please.
Delay the 73 days. Will accept notice ತಗೊಂತೀರಾ? Condone ಮಾಡೋಣ.
Please.
I have appeared for the.
Allah. Already appeared.
Adhe. Plaintiff.
I am for the plaintiff. I have appeared.
Delay condoned. For the reasons indicated in the affidavit accompanying the application being satisfied with the same. Delay of 73 days stands condoned. List on Monday for admission.
Please. Fresh matters.
Admission. CRP fresh matter. Admission. Yes.
Please.
Next.
52.
Vacating stay. Venkatesh Karvi.
IA filed by me, my lords.
IA filed by?
Wife, my lords. Respondent. Wife.
What's the matter of the husband?
My lord. Question is, my lord, sir.
Our husband.
Please, my lord. The petitioner has filed challenge the interim maintenance order passed by the civil judge and JMH.
How much granted?
2,000, my lord.
2,000 rupees.
2,000. My lord, because of on the ground that she has got a second marriage and started to lead married life with the second husband, my lord.
Second husband, second marriage. Husband. So first husband, no maintenance.
No maintenance, my lord.
ಆಮೇಲೆ
ಲಾರ್ಡ್
ಅದು ನಿಮ್ಮ ಅಪ್ರೆಹೆನ್ಷನ್ ಇಮ್ಯಾಜಿನೇಷನ್ ನಿಜವಾಗ್ಲೂ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಸರ್ ನಿಜವಾಗ್ಲೂ ಆಗಿತ್ರಿ ಸರ್.
ಆಗಿದೆಯಾ?
ಆಗಿದ್ದು ಹೇಳಕತ್ತೀವಿ ಸರ್.
ಆಗಿದ್ದು ಇದೆಯಾ?
ಆಗಿದ್ದೆ ಸರ್.
ಯಾಕೆ ಸರ್?
ಇಲ್ಲಿ ನಾವು ಕೊಡಾಕೇನ್ ಪ್ರಾಬ್ಲಮ್ ಇದ್ದಿದ್ದಿಲ್ಲ ಸರ್.
ಕೊಡಾಕೇನ್ ಪ್ರಾಬ್ಲಮ್ ಇರಲ್ಲ. ಕೊಡಾಕೇನ್ ಪ್ರಾಬ್ಲಮ್ ಇರಲ್ಲ ಬಿಡಿ ಕೊಡಕ್ಕೆ.
ಕೊಡ್ತಿದ್ದೀವಿ ಸರ್ ನಾವು.
ಎಸ್ ಸರ್.
ಮೈ ಲಾರ್ಡ್ ಸರ್.
You are married for the second time?
No. It's the allegation. I am ready to file the affidavit.
Affidavit alla?
Yes, in criminal court also I have filed affidavit that I have not got. We are not contact with the second marriage.
You are not appointed?
Contact with second marriage. So that is the case, my lords. Even my lords, section 125, even though why woman include the divorce wife.
Oh.
Divorce agide.
Agidya?
Agide. So even though she is entitled for my lords maintenance.
Second, ಬೇರೆ ಮತ್ತೆ ಮದುವೆ ಆಗಿಲ್ಲ?
ಆಗಿಲ್ಲ. I filed affidavit also. Section 125, subclause 1, my lords. B, it is clearly says that, my lord, when the respondent
got second marriage, she would not be entitled.
Correct. Second marriage ಆಗಿರ್ಬೇಕಲ್ಲ.
ಆಗಿದೆ my lord.
ಎಲ್ಲಿದೆ?
My lord, I would like to bring some facts of the case, my lord.
ಫ್ಯಾಕ್ಟ್ಸ್ ಅಲ್ಲ. ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್ ಆಗಿರೋ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಬಿಡಿ.
Yes, my lord. My lord, first marriage got on 29.
ಫಸ್ಟ್ ಮ್ಯಾರೇಜ್ ಬಿಟ್ಬಿಡಿ ಸರ್, ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್ ಹೇಳಿ.
My lord, second marriage, my lord, 2/5/2021.
2/5.
First marriage, my lord, 29/5/2020. Second marriage, my lord.
ಒಂದು ವರ್ಷದಲ್ಲೇ ಬಿಟ್ಬಿಟ್ರ ನಿಮ್ನ?
ಹೌದು ಸಾಹೇಬ್ರ, ಓಡಿಸ್ಕೊಂಡು ಹೋಗಿ ಮದ್ವೆ ಆಗಿದ್ದೆ ಸರ್ ಇದು ಬೆಳಗಾಂ ಒಳಗ.
ನೀವು ಏನಂದ್ರೆ
ಇದು ಓಡಿಸ್ಕೊಂಡು ಹೋಗಿ ಮದ್ವೆ
ಆಗಿದೆ.
ಅದಕ್ಕಾಗಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದ ಕೇಸ್ ಹೇಳಿದ್ರು ಇದು ಸ್ವಲ್ಪ ಇದು ಆಗಿದೆ.
ಸೆಕೆಂಡಾ ಫಸ್ಟಾ?
ಸೆಕೆಂಡ್ ಸರ್.
ಸೆಕೆಂಡ್ ಓಡಿಸ್ಕೊಂಡು ಹೋಗಿ ಮದುವೆ ಆಗಿದೆ.
ಅಂದ್ರೆ ಬಾಡಿಗೆ ಮನೆಯಾಗ ಇದ್ದವನು ಬಾಡಿಗೆ ಮನೆಯವ್ನು ತಗೊಂಡ್ ಹೋಗಿದ್ದು ಮದ್ವೆ ಆಗ್ಯಾನ ಸರ್.
ದಿಲ್ವಾಲೆ ದುಲ್ಹನಿ ಅಲೆ ಜಾಯಂಗೆ.
ಹಿಂಗಾಗಿ ಸರ್. Only with an intention to escaping from the offense of 494 bigamy offenses, he has filed a divorce petition, my lord. Maintenance petition, my lord. Maintenance, divorce, PC
ಎಲ್ಲ ಆಗಿದೆಯಾ?
ಎಲ್ಲ ಹಾಕ್ಯಾರ ಸರ್. ನಾ ಎಲ್ಲ ತಗೊಂಬಂದೇನೆ ಸರ್.
ಎಲ್ಲ ತಗೊಂಬಂದಿರಿ?
ಎಲ್ಲ ತಗೊಂಬಂದೇನೆ ಸರ್.
2,000 ರೂಪಾಯಿ ಕೊಟ್ಬಿಟ್ರೆ ತರದೇ ಬೇಕಾಗಿರ್ಲಿಲ್ಲ.
My lord, the issue is, my lord, there is allegation that that
is not
wife has
allegation,
contacted
my lord.
second marriage. The allegation
But
not
see, unless it is proved
yes,
that second marriage has been contacted by evidence, till then you will have to pay.
My lord, the Honorable 4th JMFU Court and Honorable High Court of Karnataka and Honorable High Court of Karnataka second time and
Karnataka second.
Second time sir. ಎರಡು ಸತಿ ಕ್ವಾಶ್ ಗೆ ಬಂದಾರ ಸರ್. ಎರಡು ಟೈಮ್ ನಾಗನು ಸಹಿತ this Honorable Court directed to the trial court to conduct the trial, my lord.
ಏನ್ ಟ್ರಯಲ್ ಏನಾಗಿದೆ ಈಗ?
For the offense punishable under section 494 of IPC, my lord.
ಬೈಗಮಿ,
my lord. My lord,
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಏನಾಯ್ತು?
ಚಲ್ತಿದಾರಿ, ಬೇಲ್ ತಗೊಂಡಾರಿ ಅವರು. ಬೇಲ್ ತಗೊಂಡು ಅಪೇರ್ ಆಗ್ಯಾರ ಸರ್ ಅಲ್ಲಿ.
ಅಂದ್ರೆ
ಸೆಕೆಂಡ್
ಆಗಿಲ್ಲ ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್
ಇನ್ನು ನಡೆದೈತಿ ಸರ್. ಟ್ರಯಲ್ ನಡೆದೈತಿ ಸರ್. CC number 1284/2022 which is pending before the second JMFC court Belagavi.
still pending consider.
ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರ ಅವ್ರನ್ನ?
Please, no, my lord.
My lord,
It is allegations, my lord.
My lord,
This is only allegations.
It's
And
not
other accused are already acquitted by this honorable court.
ಅದರ್ ಅಕ್ಯೂಸ್ ಇರಲ್ಲ ಬಿಡಿ. 494
ಅಲ್ಲ, 494 ನು ಹಾಕಿದ, ಅವ್ರ ಮೇಲೂ ಹಾಕಿದ್ರು. That was hold by this honorable court and
my lord, our contention of the respondent contended in criminal miscellaneous filed by the respondent before the trial court. She has narrated that my lord may NDB Peruges I have produced annexer C, my lord. Annexer C, my lord. ಅದ್ರಾಗ ಹೇಳ್ತಾರ ಸಾಹೇಬ್ರು, they have contended false. She has alleged stating that, my lord, on 10/9/2020 ಅವಾಗ ಗುಳಿಗೆ ತಗೊಂಡಾರಂತ ಸರ್. ಗುಳಿಗೆ ಔಷಧ ಅದು ಅಬಾಲಿಷನ್ ಆಗಿದ್ದು 12/9/2021 ಗಂತ. ಅಬಾರ್ಷನ್ ಆಗಿದ್ದು ಒಂದು ಗುಳಿಗೆ ತಗೊಂಡಿದ್ದು 1 ವರ್ಷ 2 ದಿವಸಕ್ಕೆ ಅಬಾರ್ಷನ್ ಆಗೈತೆ ಅಂತ. Whether it is valuable, my lord.
it is allegation in the divorce petition that is already divorced. It was already divorce.
4 ಪಿಟಿಷನ್ ಒಳಗೆ
ಅವ್ರು ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ರೆ ಬಿಡಿ ಇಲ್ಲಿ.
Divorce.
4 ಪಿಟಿಷನ್ ಒಳಗೆ ಹಂಗೈತೆ.
And divorce in the second marriage is not proved in issue number 2 and 3. That allegation is not proved.
ಈಗೇನು ಸ್ಟೇ ವೆಕೇಟ್ ಮಾಡ್ಬೇಕು?
ಅದು ವೆಕೆಂಟ್ ಮಾಡಿ ನಮಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಕೊಡಿ. We will file for
ಇರ್ಲಿ
so
ಬಿಡಿ.
since from 2020 my lord is unable to appear the court and also now he has appeared since 2020.
2000ಕ್ಕೆ ಹಿಂಗೆಲ್ಲ ಆಡಲ್ಲ ಬಿಡಿ ಅವರು, ತೊಂದರೆ ಇಲ್ಲ.
But we file application for my lord's announcement of that interim maintenance.
I am not going to vacate the stay.
Please, my lords, kindly dispose ಮಾಡಿ.
Yes, heard the learned counsel appearing for the petitioner and the respondent. The interim order is operating in the case at hand. The case has checkered history and a maze of facts as to when the respondent wife has got married for the second time after the divorce that has happened with the present petitioner, the husband. Therefore, considering the application and hearing, the main matter would be the same. The IA therefore stands rejected. Post the matter in B group. Writ petition tane. Post the matter in B group on 1st December.
Maybe dispose, my lord, because
1st December.
As per the provision of law, my lord, she is not, she is entitled for the. Even though divorce, my lords, the provision is very clear.
We'll
Only
decide.
allegation, no, my lords, yes. No income, ತಂದೆಯವರು ರಿಟೈರ್ಡ್ ಗ್ಯಾರೇಜ್
Full
ಆಗಿ
income ಆ?
ಅಲ್ಲ ಅವಳಿಗೂ ಇಲ್ಲ ಅವ್ರ ತಂದೆಯವ್ರಿಗೂ ಇಲ್ಲ.
ಯಾಕೆ ತಂದೆಯವ್ರಿಗೆ ಏನಾಗಿದೆ?
ತಂದೆಯವ್ರಿಗೆ ಗ್ಯಾರೇಜ್ ಮಾಡಿ ಈಗ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ. ಇಸ್ ಏಜ್ ಆಫ್ 55 to 60 my lords.
55 to 60 ಗೆ
ಗ್ಯಾರೇಜ್
that
ಕೆಲಸ
is not
ಮಾಡ್ಲಿಕ್ಕೆ
old, sir.
ಆಗ್ತಾ ಇಲ್ಲ. No.
ನನ್ಗೂ 50.
It's not
ಅಯ್ಯೋ,
unable to.
54. Yes.
My lord, that is what may be disposed. Otherwise, date may fix, my lords. Date may.
December 1st.
Well, otherwise, the vacate ಮಾಡೋದು.
Otherwise December 1st.
ಅಲ್ಲಲ್ಲ.
Vacating stay rejected.
ಅಲ್ಲ ನಾನು ಹಾಕಿದ್ ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
ನೀವು ಹಾಕಿದ್ದೆ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು.
ಬಟ್ ಇಂಟರ್ ಮೇಂಟೆನೆನ್ಸ್ ಸ್ಟೇಟ್ ಬೈ ದಿಸ್ ಆಲ್ ಕೋರ್ಟ್ ಇಟ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್
Vacating ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಸರ್.
ಕರೆಕ್ಟ್. ಬಟ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಇಂಟ್ರಿಮ್ ಇಸ್ ಇನ್ ಫೋರ್ಸ್ ದೆನ್.
ಅಷ್ಟೇ ಕನ್ಫರ್ಮ್ ಆಯ್ತು ಅಷ್ಟೇ. Vacating
ದಟ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಆಸ್ ಪರ್ ಇಟ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ಪ್ರೊವಿಷನ್ ಆಫ್ 125.
We will decide it.
ಕರೆಕ್ಟ್.
December 1st decide ಮಾಡಿ.
ಪ್ಲೀಸ್.
Number 55, Srikanti Patil.
Waste time for some objections.
But petition is filed by my lord the association.
ಒಂದು objection ಆಗ್ತೀವಿ sir. File objections.
ಏನ್ ಶ್ರೀಕಾಂತ್? Dismissal.
I filed application, my lord, for dispensation of certified, production of certified copy. It may be dispensed.
Vacating stay ಯಾರ್ದು ಹಾಕಿರೋದು?
ಅಲ್ಲ.
Cell number 55, my lord.
55, my lord.
55.
I appear for the respondent number 4.
Scheduled tribe. Who is the
that is-
petitioner?
Lord, petitioner is an association, my lord.
What's
Raised
the
under
matter?
the Cooperative Societies
What's
Act.
the matter?
So, Societies Act. Lord, challenging, my lord, the order passed, my lord, by the DC in respect of, my lord, the endorsement issued. Annexure G, my
Objections
lord.
ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, I will file objection, my lord.
First of all, locus standi.
Dispensation for the reasons indicated in the affidavit accompanying the application and being satisfied with the same. The application is allowed. Production of certified copy of annexure G stands dispensed with. Yes.
2 weeks time,
The
Lord,
learned
sir.
counsel for the respondent seeks 2 weeks time to file statement of objections. List the matter on 20th November. Objections if any by then.
Please.
Yes, next.
56, Sabil Ahmed, B. Mohammed Ali.
Today they have served the vacating IA and statement, my lords. Today they have served the copy to me, my lords. Now.
Yes, SO I have filed, my lord.
The learned
Served a copy today.
objections ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ, ಇವತ್ತು
The
ಕೊಟ್ಟಿದ್ದೀನಿ.
learned counsel of the petitioner submits that the objections to the petition is served upon him today. List the matter on 19th, rejoinder if any, by then interim order if any subsisting will continue to the next date of hearing. Next.
Much obliged.
58, A. Lad Khan, MB Kanvi.
14%. 14%. Non-compliance of office. Kodil, the office objections have been left uncomplied for the last 5 years. Therefore, as a last chance, list this matter on 19th. In the event there would be no representation or the office objections would remain uncomplied, the petition would be dismissed for its non-prosecution. Next.
59, Anvi Hiremat.
Please, my lord, I appear on behalf of the petitioner, my lord. The present petitioner is challenging with regarding to this rejection of his compensate appointment, wherein, my lord, an endorsement is issued stating that unless and until I get a decree from an civil court stating that I am the adopted son of the deceased, my lord, our claim cannot be considered. And also taking into provisions of Rule 3, Subclause 3, adopted son and daughter is not entitled. That is the reason for rejection of my endorsement, my lord.
Yes, sir.
My lord,
ಹೇಳಿ ಕಲ್ಸರ್ ಮಾಡಿ.
please, my lord, the impugned order is at annexure F, my lord, page 49, my lord. In that, my lord, only with regarding to the civil decree and with regarding to the provisions of Rule 3, my lord, they have rejected my endorsement. But the adopted registered deed was taken place on 10/1/2017. My father died on 12/11/2019, my lord. After lapse of registered sale deed, adopted deed, my father died, my lord. Thereafter, immediately adopted son, my lord, adopted son. The petitioner is the adopted son.
Judgment ಕೊಡಿ.
My lord, my lord, insofar as the adopted son is concerned, my lord, Honorable High Court of the Punjab has held that, my lord, only insofar as since adopted son cannot be taken away as per the Hindu succession law, but insofar as the claim of relief seeking compassionate appointment has been negativated in that judgment note. But however, the Lordship's judgment insofar as the Bhuneshwari case is concerned, the Lordship has held that in view of the amendment, Bhuneshwari's case, my lord.
Bhuneshwari.
Bhuneshwari, sir, married daughter.
Married daughter, my
that's
lord,
on
but
a
yes,
different
my lord.
footing, sir. ಆ ತರ ಫ್ಯಾಮಿಲಿ ಆಡ್
ಅಲ್ಲ,
ಮಾಡ್ತಾ ಹೋದ್ರೆ ಎಲ್ಲ
This order helps him.
ಕನ್ಸಿಡರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್
ಅಲ್ಲ ಇದರಲ್ಲಿ ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ಮಲಟ್ ವೆರಿನ್ ಮಲಟ್ಸ್ ಅಡಾಪ್ಟೆಡ್
ಹಾ
ಅಲ್ಲ ಅವ್ರಿಗೆ ಫೇವರ್ ಆಗುತ್ತೆ ನಾನು ತಗೊಂಡು ಬಂದೆ
ಇದನ್ನೇ ಬರೆದ್ ಬಿಡೋಣ
ಅದನ್ನು ಬರೆದು ನಡೆಯುತ್ತೆ ಬಟ್ ಓನ್ಲಿ ಥಿಂಗ್ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಮಲಟ್ಸ್ ಅಬ್ಸರ್ವ್ಡ್ ಈಸ್ ಮಲಟ್ಸ್ ದಿ ಮಲಟ್ಸ್ ದೇ ಸೇಸ್ ದಟ್ ಮಲಟ್ಸ್ ಇನ್ ದ ಇಯರ್ 2017 the adoption malats deed was malats registered before the malats sub register. After that malat in the malats earlier records which was maintained by the malats the respondent herein malats there were no malats any malats details with regards to the malats adopted son and all. So even
details ಎಲ್ಲ ಕೊಡ್ತಾರೆ ಈಗ ಬಿಡಿ.
If that is malats given,
the petitioner is before this court seeking the following prayer. The petitioner is said to be the adopted child of one Gurunath, an employee who was working as a loader in respondent town municipal council Harapanahalli. He dies in harness. Before the death of he dies in harness on 12/11/2019. Before the death of the said employee, a registered adoption deed is said to have been executed adopting the petitioner as his son. ಎಷ್ಟು ವರ್ಷ ಅವಾಗ?
he was aged about now he is aged about 24 malats.
ಅಲ್ಲ ಅವಾಗ 2019 ಅಲ್ಲಿ
19 ಅಲ್ಲಿ ಅಂದ್ರೆ
18 ಗಿಂತ ಕಮ್ಮಿ ಇತ್ತಾ?
ಇಲ್ಲ ಜಾಸ್ತಿ ಇತ್ತು.
ಅದ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ ನೀವು?
ಅದೇ that is the malad the doubt which was created and opinion was sent malats and malats they opined that malats in the certificate which was issued wherein the name of the father found malats is biological father.
The learned so-and-so. The said claim, the petitioner after the death of the father submits an application seeking appointment on compassionate grounds. The same comes to be rejected on the score that the petition, there are no documents produced by the petitioner with regard to the adoption prior to the date of the death of the employee. Even otherwise, the endorsement is that he is not eligible under the relevant rules. The learned counsel Kalsur Mutt would reiterate the grounds set out in the petition to contend that the adoption takes place long before the death and all the documents were submitted to the petitioner, to the respondent to consider the case of the petitioner. The same has not merited any consideration. He would, the learned counsel would seek to place reliance upon so and so. The learned counsel appearing for the respondent would vehemently refute the submission in contending that the documents of adoption that was handed over to the respondent was containing the name of the biological father and not the name of Gurunath, who was the employee who died in harness. The learned counsel for the respondent petitioner would now join issue in contending that all the necessary documents would be handed over to the petitioner and the case of the petitioner be considered in terms of the judgment rendered by the division bench in 100362 of 2022. In the light of the said submission and contra submission, I deem it appropriate to dispose the petition with a direction to the respondent to consider the case of the petitioner in terms of the judgment of the division bench in so and so. So and so. In the event the respondents would need any documents, they are free to solicit the same from the hands of the petitioner, and the petitioner shall furnish all the documents that are sought for. If the respondents are satisfied with the documents that are now that documents that would be placed before them by the petitioner, the application of the petitioner shall be processed strictly in consonance with law and appropriate orders be passed. The exercise of the said exercise shall conclude within 12 weeks from the 16 weeks from the date of receipt of the copy of the order, if not earlier, ordered accordingly.
One submission, the impugned endorsement has to be set aside.
In the light of for the aforesaid is the following order, the impugned endorsement stands quashed. The matter is remitted back to the hands of the respondents to reconsider the claim of the petitioner in consonance with law and bearing in mind the observations made by the division bench in so and so.
Please,
Next.
please.
ಕರೆದಾಯ್ತಲ್ಲ ಎಲ್ಲಿದ್ದಾರೆ ಆಮೇಲೆ ನೋಡ. Next.
Seal number 62. Santosh Narvam.
Please, Your Yesterday's matter, Your Worship, annexure M. Yesterday, day before yesterday, this honorable court had directed to raise the document to show that which examination has to be.
Red
The same what they
there
have
were
said.
two
First
circulars
examination
issued.
ಆಗಿದೆ.
ಇಲ್ಲ. There were two circulars issued in the year 1997 and 1998. The employees were to complete that is a departmental examination within the time fixed by the circular in pursuance of the government circular.
ಏನಾರು ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ ಎಕ್ಸಾಮಿನೇಷನ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ಅಂತ?
ಇದೆ sir. In annexure M dalli, there is an endorsement by virtue of the order passed by this honorable court in writ petition, earlier writ petition. And he were to appear and complete the examination within 1998-9. But whereas he has appeared for the examination in the year 2003, so he is not that is qualified to get
ಅಪಿಯರ್
promotion.
ಆಗಿ ಏನಾಗಿದೆ?
First class ನಲ್ಲಿ pass
2003 ದಲ್ಲಿ ಆಗಿದೆ.
ಅಲ್ಲ.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
Sanitary inspector.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
Sanitary inspector.
ಅಲ್ಲ ಬೇರೆ ಏನಾದ್ರೂ ಇದೆಯಾ? ಗ್ರೌಂಡ್ ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ?
That is the ground, my lord.
Yes.
I am referring both the circulars, my lord.
We will refer to both the circulars.
Please.
The petitioner is before this court. Examination clear ಮಾಡಿಲ್ಲ ಅಂತ ಬೇರೆ. Yes.
ಅಲ್ಲ clear ಮಾಡಿಲ್ಲ ಅಂತಲ್ಲ sir.
The petitioner is
Before
before
the time stipulated by virtue of the circular issued by the
the
government.
petitioner is before this court calling in question an order dated 26/6/2024 passed by the respondent denying ಏನಿದು increment
Promotions.
promotion
House.
Promotion and pay scale.
promotion to senior sanitary
Senior
inspector. Promotion to ಇನ್ನು ಸರ್ವಿಸ್ ಇದ್ರೆ ರಿಟೈರ್ ಆಗಿದೆ.
ಇಲ್ಲ retired, he is already retired from service also.
ಯಾವಾಗ
2012, 29/2/2012.
ಅಲ್ಲ ರಿಟೈರ್ಮೆಂಟ್ ಮುಂಚೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, Your Worship.
ಎಲ್ಲಿದೆ?
Earlier in
ರಿಟೈರ್ ಆಗಿದೆ ಯಾವಾಗ?
2012, Your Worship. 29/2/2012.
ಹಾ ಸರಿ, ಈಗ ಇದೆಲ್ಲಿದೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್? ಎಲ್ಲಿ?
Annexure D, Your Worship.
ಡ್ಯೂರಿಂಗ್ ಸರ್ವಿಸ್ ಕೊಟ್ಟಿರೋದು?
ಅಲ್ಲ, no, Your Worship.
During
After
service he has not.
I will not grant promotion.
During service he has not made.
During service, if you have not agitated, you
No,
can't agitate.
no, my lord.
But there is only one examination that has been conducted.
Where is the representation before service, sir?
Your Worship, that is the annexure. Page number 38, Your Worship. 39. That already the examination has been given and has been cleared, Your Worship.
ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ನೀವು ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ? ವೈಲ್ ಇನ್ ಸರ್ವಿಸ್.
No, that time it has not been given.
But other orders are passed by the
Yes,
court
Lord.
already.
No, my lord. Earlier this honorable court.
That question we can't go back because that was not the issue that is projected by you earlier. That service ಅಲ್ಲಿ ಇದ್ದ ಕೊಟ್ಟಿಲ್ಲ representation ಅಂತ. ಈಗ ಆಗೋಗಿದೆ ಅದೆಲ್ಲ.
He has to claim that is service, that is promotion.
Pay scale is concerned.
He did not make any application before he got retirement, my lord.
ನಾನು ಹೇಳಿದ್ದು ಕೇಳ್ತಾ ಇದ್ರಿ,
Yes,
ಇಲ್ಲಿವರೆಗೆ
yes,
ಹೇಳಿಲ್ಲ
yes,
ಅದನ್ನ.
yes, my lord.
You are taking cue from the court, don't do that. The earlier the writ petitions ಅಲ್ಲಿ was that the defense?
No, my lord.
Then
his representation was not considered properly.
Correct, sir.
Yes.
ರಿಟೈರ್ಮೆಂಟ್ ಆಗಕ್ ಮುಂಚೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಏನಾದ್ರು ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ಕೇಳ್ಬೇಕೆಲ್ಲ, ರಿಟೈರ್ ಆಗಿ 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಅಲ್ಲ.
Yes, sir.
How can you put the clock
Order
back
is at
now?
annexure H, my lord.
Annexure is the.
ನೀವು ಮ್ಯಾಡಮ್ಸ್ ಕೇಳ್ತೀರಾ, ನಾವು ಕೊಡ್ತೀವಿ. ಯಾವ್ದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಹಳೇದಿದೆಯಾ ಕೇಳಿ.
He was given, Your Worship, but that representation has been not considered by the commission.
Produce the copy. ಇಲ್ಲರೆ ಮತ್ತೆ ಕೋರ್ಟ್ಗೆ ಬರ್ಬೇಕಾಗುತ್ತೆ.
I'll produce it, Your Worship.
List the matter on
Day after tomorrow, Monday. Monday,
Tuesday.
much.
Tuesday.
Please.
Preliminary hearing.
Much.
That is the first submission you should make.
Please. And
An employee in service should agitate his rights.
yes, yes.
Particular for promotion.
Yes.
10 ವರ್ಷ ಆದ್ಮೇಲೆ ಅಲ್ಲ, retire ಆಗಿ 10 ವರ್ಷ ಆದ್ಮೇಲೆ.
Even also, Lordship, the pay scale, Lordship, earlier, they are not written the examination, that has been given to them.
ರಿಟೈರ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಅಲ್ಲ
Yes,
ಸರ್
yes,
ಹೇಳೋದು.
please.
Yes.
Number 64, 18 and a half.
My lords, I'm appearing for the petitioner, my lords. I beg to appear through VC.
ಅದೇ
My lords,
13
it's
hours,
illegal
13
custody for
hours
13
illegal
hours.
arrest.
Yes, my lords, yes, my lords.
Legal custody notice ಕೊಟ್ಟಿದ್ದೀವಿ my lords.
ನೋಟಿಸ್ ಕೊಟ್ಟು ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದೀರಾ?
Arrest ಮಾಡಿ.
ಯಾಕೆ ಅರೆಸ್ಟ್
No, my
ಮಾಡಿದ್ರು?
lords. My lords, may kindly peruse at page 11 and 12. I have produced the photographs. On page 13 of
Why was he taken into custody?
Madam, my lords, I have made one video wherein I have shown that what are the other right-wing organizations are doing, and I have sought for the police interference in that. Only for that video, they have registered a complaint against me, and that too after taking me into their custody. In the morning, 10 o'clock, they have come to my home without there being any warrant from the court, my lords.
Earlier objections. Produce the records ಕೊಡಿ. I asked for the diary ಕೊಡಿ.
Please.
ಕೊಡಿ ಎಲ್ಲಿ? Tuesday preliminary hearing. ಅದು ಫೈಲ್ ಗಡಿ. Next.
65,
Please.
Abhinandan Hiremat.
ಇಲ್ಲ ಅಂದ್ರೆ ಶಿಲ್ವಂತ್.
My
ಏನಿದೆ
request,
ಇಷ್ಟೊಂದಿದೆ?
my request 2 weeks time, my lord. The state is required some instructions.
2025 matter. ಅಲ್ಲ 2008 connected. What's the
Yes.
matter,
With
Shilpa?
regard to management of the Malos temple, you know the enactment of Malos Hindu Religious and Charitable Endowments Act. This Malos institution run by Malos, managed by the under the decree of the court. District judge is the Malos administrator, right from 1906. 1906. Avag bylaws agiddu. I mean, there is no amendment to the bylaws or it is not changed. Subsequent to coming into force of the act, automatically the earlier administrator or ceases to have role to play, and the committee comes into play. Now that that is stayed in Supreme Court, except Section 25.
Correct.
Section 25. Now, as on today, Section 25 is in operation. If that is the case, my lords, the district judge cannot appoint a committee or constitute a committee. They have to follow the procedure under 25. That's one thing. That is the my lords, main crux of the matter. And 25 is not stayed by the Supreme Court. It has made it clear.
It was stayed later on.
Later on, court said, my lords,
Clarified except 25.
because my lords, because of the reason.
Management will go away.
Because of the reason, the moment act came into force, they have taken the management.
Entire act was stayed.
Entire act is, even amendment is also stayed. But as far as 25 is concerned, that is the.
ಆಗ್ಲಿ ಬಿಡಿ, ಹಾಗಾದ್ರೆ ಬರ್ಲಿ. Because that ಅಲ್ಲಿ ಟಿಂಕರ್ ಮಾಡುವಂತದ್ದೇನು ಮಾಡಬಾರ್ದು.
ಅಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಅದಕ್ಕೆ ತಾವು ಮೊನ್ನೆ ಹೇಳಿದೆ, ಅದು ವಿತಿನ್ 3 months
ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ.
ವಿತಿನ್ 3 months it should be disposed of ಅಂತ.
2 weeks ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
My lords, only with regard to the instruction, whether it is comes under the endowment act, religious.
List the matter on 19th as a last chance for the state to make their submit. Heard the Learned Counsel V.M. Shilwant appearing for the petitioner. List the matter on 19th as a last chance in preliminary hearing. It is made clear no adjournment will be granted to the state on any count whatsoever. Yes.
66, K.S. Patil. Dish Patil.
Next, J. Malad, page 75 is the impugned order passed by the Deputy Commissioner.
ಏನದು?
Being the chairman of the Malad Nirmiti Kendra, dispensing the services of the petitioner Malad, who was appointed as Malad project director during the year 2012. After lapse of 12 years, without holding any inquiry, Malad, without holding any power, because it is the governing council of the Nirmiti Kendra which has got the power to Malad.
Yes,
Take-
Patil, sir.
Your lordship, that this order was earlier challenged by the very same petitioner. He has withdrawn it, your
Not the
after
same order,
11
Malad.
months. He filed the same, challenging the same order.
Where is the order?
Page 71 I have produced.
Where is the order of withdrawal?
But page 71, my lords, may kindly see the earlier order passed by the Malad authority of the same date, that is 29/6/2024, page 71. I have produced that
Where is
copy
the
also.
memo?
Not
Page
memo I have not produced, the order copy I have produced, annexure.
ಅದು ಗೊತ್ತು 74 ಅಲ್ಲಿ ಕಾಣ್ತಾ ಇದೆ ಮೆಮೊ ಬೇಕಲ್ಲ
71, 72 may
70
kindly be seen, the prayer in the
ಗೊತ್ತಾಯ್ತು.
writ petition.
ಅಲ್ಲ,
Yes,
prayer
circle
ಬೇರೆ
ಇದೆ.
ಇದೆ. Order the subject.
96
without
2024.
liberty has withdrawn.
My submission is, subject matter of the writ petition, what the order, the passed by the deputy commissioner is entirely different than the subject matter of this writ petition.
What is the date of
Oh,
the
orders-
no, what
of
is the date
course.
of the present order, sir?
Present order date is 29/6/2024, which came to my lords, may kindly come to page 7.
ಇಲ್ಲಿ ಎರಡಿದೆ 29/6/2024.
ಎರಡು ಸೇಮ್ ಡೇಟ್ ಇದೆ,
ಒಂದು ರಿಲೀವಿಂಗ್ ಒಂದು ಇದನ್ನ ಮಾಡಿದ ಅಷ್ಟೇ, ರಿಲೀವಿಂಗ್ ಆರ್ಡರ್ ಚೇಂಜ್ ಮಾಡಿ, ಸಾರಿ ಹೇಳಿ ಹೇಳಿ.
But page 75, though the order, the subject matter of this writ petition is bearing the same date, that is 29/6/2024.
Where is the memo?
Memo I have not produced, if my lords direct.
ಈಗ ಹೊಸ ಟೈಪ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಡಿ.
ಇಲ್ಲ, ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ,
ಅದಕ್ಕೆ ನಾನು ಮೆಮೊನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
But the reason is, but the order which is challenged in this writ petition is entirely different. Of course, my dates are same, contents my lords may see. Contents.
ಎರಡೇ ಆರ್ಡರ್ ನಿಮ್ದಿರೋದು, ಒಂದು ಟರ್ಮಿನೇಷನ್, ಒಂದು ರಿಲೀವಿಂಗ್.
ಹೌದು,
ಕರೆಕ್ಟಾ?
ಕರೆಕ್ಟ್.
ಮೂರನೇದು ಯಾವುದು?
ಇಲ್ಲ, ಎರಡೇ ಆರ್ಡರ್.
ಎರಡೇ ಅಲ್ವಾ?
ಫಸ್ಟ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ನಾನು ಬರೀ ರಿಲೀವಿಂಗ್ ಇದ್ದು ಅಷ್ಟೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೆ, ಟರ್ಮಿನೇಷನ್ ಒಂದೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೆ. ಸೆಕೆಂಡ್ ರಿಟ್ ಪಿಟಿಷನ್
ಒಂದೇ.
ಹೌದು, ಅದ್
ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಮಾಡಿದ್ರಾ?
ಅದ್ ಮಾಡಿತ್ತು.
ಟರ್ಮಿನೇಷನ್ ಮಾಡಿದ್ರಾ?
Termination was challenged. Page 75, this order came to be passed in came to be served upon the petitioner in a subsequent date, that is 4/7/2024.
ವಿಡ್ರಾ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಿ.
ಮಾಡಿದ್ದಾರೆ on the assurance that if I withdraw the petition. In fact, I am off the record, I am submitting virtually the
ಮಾಡಿ ಆಫ್ ದ ರೆಕಾರ್ಡ್ ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ.
virtually the petitioner, he was given threat to withdraw the petition. Of course, I have stated in the petition that they have given the assurance to reinstate me. But order is dated 4/7/2024. Though that writ petition is withdrawn, this order came to be served upon the petitioner subsequently, which is stigmatic in nature.
Which one?
The subsequent order, which is the subject matter of this writ
Subsequent
petition.
order.
Page 75. Page 75. And it is passed only on the instruction issued by the Honorable Minister of the District in charge Minister.
Page 75.
Page 75.
74 annexure J ನ ಇರ್ತದೆ.
ನೋಡ್ಯಾ?
ಅದು 29/6/24.
ಹೌದು, ಕೆಳಗಡೆ ನೋಡಿ. It came to be served upon the petitioner on 4/7/2024. Now, my lords may kindly differentiate the contents of both the orders passed by the authorities.
After withdrawing the writ petition,
that was termination in simpliciter. This is stigmatic in nature. They pass a certain remarks against the petitioner.
Where is the earlier order?
I have produced it, page 71. Page 71.
70.
71.
annexure G.
Annexure G. May I read mods?
ತಕ್ಷಣದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿ
ಅದು ಮೇಲ್ ಕಂಟೆಂಟ್ಸ್ ಫಸ್ಟ್ 3 ಲೈನ್ಸ್. ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಮಾನ್ಯ ಅಬಕಾರಿ ಸಚಿವರು ಹಾಗೂ ಬಾಗಲಕೋಟೆ ಜಿಲ್ಲಾ ಉಸ್ತುವಾರಿ ಸಚಿವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ರಂದು ಜರುಗಿದ ಕೆಡಿಪಿ ಪ್ರಗತಿ ಪರಿಶೀಲನಾ ಸಭೆಯಲ್ಲಿ ನೀಡಿರುವ ನಿರ್ದೇಶನದಂತೆ ಹಾಲಿ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಅವರನ್ನು ತಕ್ಷಣದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿ ಆದೇಶಿಸುವುದು. ನೌ ಮೈ ಲಾರ್ಡ್ಸ್ ಮೈ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪೇಜ್ 75.
ಇದ್ರ ಒರಿಜಿನಲ್ ಎಲ್ಲಿ? ಇದಕ್ಕೆ ಸೈನ್ ಇಲ್ಲ, ಏನಿಲ್ಲ, ರಿಸೀವ್ ಆಗಿಲ್ಲ, ಏನಿಲ್ಲ ನಿಮ್ಗೆ?
Page 75, my lord.
When have we received this?
No, the subsequent order, page annexure J, my lord. Annexure J, my lord. That is served on 4/7.
ನಲ್ಲಿ ನಿರೀಕ್ಷಿತ ಪ್ರಗತಿ ಸಾಧಿಸದೇ ಇರುವುದು ಮತ್ತು ಕಾಮಗಾರಿಯಲ್ಲಿ ಗುಣಮಟ್ಟ ಕಾಯ್ದೆಗಳು ಕಂಡು ಬಂದಿದ್ದು
ನಿರ್ಮಿತಿ ಕೇಂದ್ರಕ್ಕೆ.
ಅದೇ ನಿರ್ಮಿತಿ ಕೇಂದ್ರ.
ಒಬ್ಬ ದಕ್ಷ ಮತ್ತು ಪ್ರಾಮಾಣಿಕ ಯೋಜನಾ ನಿರ್ದೇಶಕರ ಅವಶ್ಯಕತೆ ಇರುವುದರಿಂದ ಹಾಲಿ ನಡೆಸುತ್ತಿರುವ ಸೋ ಅಂಡ್ ಸೋ ನಿರ್ಮಿತಿ ಕೇಂದ್ರವನ್ನು ತಕ್ಷಣದಿಂದ ಸೇವೆಯಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಲು.
This is nim signature ಇದು 4/7/24.
Please marks. Since this came to be served upon the petitioner on a subsequent date, but I preferred this writ petition challenge. My lords, my lord.
No, we'll expunge everything that is there in that.
Please.
Earlier order withdraw ಮಾಡಿ ಇದನ್ನ ಯಾಕೆ ಸರ್ವ್ ಮಾಡಿದ್ರಿ ಈಗ?
Well, now ಮಾಡಿದ್ದು this is has been after this yours.
Let the
deputy commissioner in a different so you also that in page I have produced along with my statement of objects.
After
he joined at Mysore. If he was continued in the same position.
Continuation
that in page 7, in page 7 your lordship me. Statement of objections I filed it on 6th August 2025.
Reasons also I have stated. Objections filed to the impeding application.
ಕರ್ನಾಟಕ ರಾಜ್ಯ ನಿರ್ಮಾಣ ಕೇಂದ್ರ ಕಾರ್ಮಿಕದ ಉಪನಿರ್ದೇಶಕರ ಹುದ್ದೆಗೆ ವರದಿ ಮಾಡಿಕೊಂಡಿರುವ ಬಗ್ಗೆ. The very same person.
ಅಲ್ಲ, ಅಲ್ಲಿ ಜಾಯಿನ್ ಆಗ್ತೇನೆ. Since salary was not paid to me.
He has received it on 4/7/2024. You would not have joined at the Mysore.
We'll expunge the remarks in
Yes,
the
sir.
order.
Allah, because he
Now,
was,
my
he
lord, by
was, he
virtue
was
of the interim
raided.
order, I am working.
DA, that disproportionate assets may case hakidru. In that case,
It is
you are
different as
taken a
well, that
content.
separate proceedings are going.
Wait, sir.
Separate proceedings are going on.
Patil, sir.
Yes, sir.
Patil
Yes,
versus Patil.
Allah, ನಾನು ಅಷ್ಟೇ ಇದನ್ನು.
ಹೇಳಿ.
If at all you would also say he would not have continued with the same department, he would not have joined at the Mysore University. That's the
ಇದು ಸೇಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದು.
same like Karnik and the different department at Mysore.
My lords, may kindly see my lord, page 8 of the my lord, statement of objections filed by me, my lord, to the impleading application. My lord, of course, my lord, I joined the my lord,
ಸ್ಟಿಗ್ಮಾ ತಾನೆ.
stigma ಒಂದೇ ಅಲ್ಲ.
I'll remove those sentences
But
from the
termination
impugned order.
itself is illegal because of the
Oh,
reason
no.
that it is passed by the my lord, incompetent authority and without holding inquiry by extracting my lord, my service for a period of 12 years. And moreover, my lord, the person who is challenging my lord, reinstatement was only my lord, was interested with the in charge my lord, he was given an in charge post. He is working as a not project engineer only on the basis of
All right, ಬರ್ಕೊಳ್ಳಿ.
but in fact government has to file the objections not by statements.
The petitioner is before this court seeking the following prayer. This very petitioner had preferred a writ petition challenging the very orders.
No, not this.
One minute. I'll say. Very orders in writ petition 103-730-2024. The orders that are subject matter of challenge in the said petition are as, the prayer sought is as follows. First page 73. A memo is filed seeking to withdraw the petition without seeking any liberty to prefer a different or a fresh petition on the cause of action. The memo is accepted and the petition is dismissed as not pressed.
May I request my memo mod, of course, mod is not the part of the record. If my lord
Parallel,
stands, I'll
not
peruse the
pressed.
memo and whether liberty was sought for or
ಅಲ್ಲ,
not.
you are sought for, in terms of the memo ಹೇಳಿಲ್ಲ ಇಲ್ಲಿ.
ಹೌದಾ?
Yes, as not pressed. The petition now, same petitioner again springs into action by coming before the court, by challenging, raising a challenge to the very orders that were subject matter of challenge. The learned counsel appearing for the petitioner A.S. Patil submits that there is marked difference between the two orders. One, the subject matter of challenge in the earlier proceeding, which reads as follows, and the other, the subject matter of challenge in the present petition, which reads as follows. In the normal circumstance, when a writ petition is withdrawn or disposed as not pressed as the case would be, without seeking liberty to file a fresh petition on the same cause of action would not be entertainable in the light of the judgment of the apex court in the case of Sarguja Transport versus so-and-so, AIR 1987 SC 881. In the light of the said judgment, the subsequent petition on the same cause of action would not be entertainable. However, there is slight difference in the impugned order therein and the impugned order in the present case. The impugned order in the present case is said to have been served on the petitioner on 4/7/2024. The learned counsel for the petitioner submits that the impugned order casts a serious stigma and the said order is, if it is stigmatic, is passed without holding any inquiry. The submission of the learned counsel for the petitioner would have merited acceptance in the light of the law being clear that a stigmatic order could not be passed without at the outset holding an inquiry. There is some development in the interregnum. The petitioner who is terminated from the service of the Nirmiti Kendra at Bagalkot joins the service of a different organization. The joining of the service of different organization is also produced by the respondents as an annexure to the statement of objections. The order of appointment there or the service now being rendered by the petitioner is as follows. In the light of the petitioner joining the service of another organization and the facts narrated herein above, the only relief that can be granted now is that the observations made in the impugned order herein, which according to the counsel and on a perusal in the view of the court is stigmatic, will have to be expunged as it is, and the termination be treated as termination simpliciter. The learned counsel for the petitioner projects several legal grounds for maintaining the subject petition. In the light of the withdrawal of the earlier petition of the same order, those grounds need not be considered, and it would suffice if the observations made in the impugned order would stand expunged. The learned counsel for the respondent has no objection for the expunging of the remarks that are made in the order impugned in the subject petition. The order would read without the references. The order would read without references to the conduct of the petitioner. ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಇದು ಪಾಟೀಲ್ರೆ? ಕಾಮಗಾರಿಯಲ್ಲಿ ಗುಣಮಟ್ಟ ಅದು ಕಂಡು ಬಂದಿದ್ದು ಸರ್ಕಾರ.
It is found that there is no murder.
ಅದು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಡಿ, ಅದು ಯಾವ್ದು ಹೇಳಿ ಸರ್. ಸಂದರ್ಭದಲ್ಲಿ ಕಾಮಗಾರಿ
ಕೇಂದ್ರಕ್ಕೆ ಒಬ್ಬ
ಅನುಷ್ಠಾನಗೊಳಿಸಿ
ದಕ್ಷ ಮತ್ತು ಪ್ರಾಮಾಣಿಕ ಯೋಜನಾ ನಿರ್ದೇಶಕ.
ದಕ್ಷ ಮತ್ತು
ಪ್ರಾಮಾಣಿಕ ಯೋಜನಾ ನಿರ್ದೇಶಕ ಅವಶ್ಯಕತೆ ಇರುವುದರಿಂದ
ಅನುಷ್ಠಾನಗೊಳಿಸಿದ್ದು ಬಾಗಲಕೋಟೆ ನಿರ್ಮಿತಿ ಕೇಂದ್ರಕ್ಕೆ.
If my lord peruses the my lord appointment order, they only say that I am very my lord honest and annexure B is the order passed by the my lord.
ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ರು?
12 ವರ್ಷ ಮಾಡಿದ್ರು.
12 ವರ್ಷದಿಂದ might have been that.
ಲೋಕಾಯುಕ್ತ ರೇಡ್ ಆಯ್ತು, ಅದ್ರ ಮೇಲೆ they approach this honorable court.
No, that's all right.
It is not the my lord part of the
ಯೋಜನಾ ಬಾಗಲಕೋಟೆ. The following words be deleted. ಇಲ್ಲಿ ಈಗ ಎಷ್ಟು ಹೇಳಿದೀನಿ, ಈ ವರ್ಡ್ಸ್ ಡಿಲೀಟ್ ಮಾಡಿ.
But ground on which my lord observed that I have joined the services my lord, that is the subsequent order. In fact, though I have joined, I have submitted a resignation there because they have not paid the salary to me.
ಯಾರು?
ಇನ್ನೊಂದು organization.
ಅದು ಅವ್ರ ಮೇಲೆ ಕೇಳಿ.
ಅಲ್ಲ, fact remains that I was no more in the job not as on
If you had not withdrawn the earlier petition, we would have considered the whole hog. Yes. ಇವ್ರು ಮಾಡಿರೋ ತಪ್ಪಿಗೆ ಆಮೇಲೆ ಒಂದು ಇನ್ನೊಂದು ಆರ್ಡರ್ ಕೊಟ್ಟರೆ ತಪ್ಪಿಗೆ ಆಗಿರೋದು ಅಷ್ಟೇ.
Remand the matter, directing them to hold the inquiry. Not till then, I may be continued in the matter.
ನೀವು earlier petition ನೀವು withdraw ಮಾಡಿದ್ದೀರಿ, ಎಲ್ಲ ಕೊಡ್ತಾ ಇದ್ದೀರಿ.
The facts are stated, virtually they have threatened the petitioner to withdraw the petition. If
these people have done a mistake by serving another order. Why did you serve? ಇನ್ನೊಂದು ಆರ್ಡರ್ ಯಾಕೆ ಸರ್ವ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, ಅವ್ರ ಗವರ್ಮೆಂಟ್
ಗವರ್ಮೆಂಟ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸಾರಿ,
ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್, he is appearing for the private person who was given an additional charge of this post.
Even after taking the charge by me without making me a party to the proceeding, they filed a writ petition.
Because of the way ಎರಡು ಸರಿ ಸರ್ವ್ ಮಾಡ್ತಾರೆ ಆರ್ಡರ್ ನ.
That is why they are required to file their statement of objection as to how they are entitled to.
ನಿಮಗೇನು ಎಕ್ಸ್ಪಂಜ್ ಆಗಿದೆ ತಾನೆ ಎಲ್ಲ?
Expunge ಅಲ್ಲ, I should be continued in the position. That is the reason. Now by virtue of the interim order, I have assumed the charge. He has been relieved. ಇಲ್ಲ,
ನಿರ್ಮಿತಿ ಕೇಂದ್ರದಲ್ಲ.
ಹೌದು.
ಇವ್ರು ನಾವು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಾನು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
He has been relieved from
given a letter also that I have never given the
separate order came to be passed by the deputy commissioner asking me to take over the
view
charge.
of this interim order, not by your lords. In view of this interim
My
order.
lords may kindly peruse the orders passed by the deputy commissioner.
My order.
Please, lords.
My order.
My lords were pleased to modify the interim order under which
status quo
kotre.
I have produced along with my statement of objections. I never given a.
This is not my order.
Yes, sir.
Page 4 of the objections filed by the impleading applicant. Page 4, which is my objection to the impleading application.
Terminate ಆದ್ಮೇಲೆ how can you go back?
Terminate ಆದ್ಮೇಲೆ
how can you go back?
I have been reinstated by virtue of a separate order passed by the deputy commissioner. He doesn't challenge that order, and he was by one more separate order. He was asked to relieved from the post. Page 4 of the murder.
Forget about him.
Yes.
An order of termination from service.
Yes.
Which to 2024 though. You take an interim order in 2025 and you are reinstated pursuant to the interim order.
Order by followed by the deputy commissioner's separate order.
It's a final relief that you have to get.
Subject to the outcome of writ petition anta ಅವರು ನಮಗೆ reinstate ಮಾಡ್ತಾರೆ. But fact remains that I am in service since
ಒಂದು petition ಹಾಕಿ ಅದು withdraw ಮಾಡಿ ಎಲ್ಲ ಆಯ್ತು.
That is the reason I am requesting my lords to if at all when there is no inquiry while terminating the services of the petition.
Why did you file a petition and withdraw it?
But even otherwise, not that.
Even otherwise,
Alla-
ಇಲ್ಲ, only
alla.
because
Prior
of-
order, my lord, merges with the second order because it is stigmatic in nature. Now I have questioned that
Not
order.
stigmatic in nature. ಇವ್ರಿಗೆ ಬೇಕಂತ ಬರ್ಸ್ಕೊಂಡಿದ್ದೀರಾ ಆರ್ಡರ್ ಅವರು.
ಅವ್ರು ಮಾಡಿದ್ದದ್ದು ನಾನು
ಅದೇ ಹೋಗಿ
ಸಪರೇಟ್ ಟೂ ಆರ್ಡರ್ಸ್.
ಯಾರಾದ್ರೂ ಟರ್ಮಿನೇಟ್ ಮಾಡಿದ್ಮೇಲೆ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಕೊಡಿ.
ಅಲ್ಲ, ನಾನೇ ಬರ್ಸ್ಕೊಂಡಿದ್ದೆ ಅಂದ್ರೆ I would have challenged that order also in the matter earlier writ petition. This order was not the.
ಅಲ್ಲಿ ಬರ್ಸ್ಕೊಂಡ್ ಬಂದಿದ್ದೀರಾ, ಒಂದು ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಆಮೇಲೆ.
If that was the case, model, then petitioner would have definitely challenged this order, which is the subject matter of this writ petition in the earlier writ petition also.
Earlier writ petition ಯಾವ ವರ್ಷದ್ದು ಸರ್?
2022.
22 ಅಲ್ಲಿ 24 ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಅಲ್ಲ, 24.
Immediately they
24 ಅಲ್ಲಿ ನಾನು ಮಾಡಿದ್ದು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಓನ್ಲಿ ಮಲಾಡ್ ಅನೆಕ್ಷರ್ ಜಿ ಮಾಡ್ ವಾಸ್ ದಿ.
ಸುಮ್ಮನೆ ಆರ್ಡರ್ ಮೇಲೆ ಆರ್ಡರ್ ಕೊಟ್ಟು ಮೇಡಮ್ ವಾಟ್ ಇಸ್ ಲಿಟಿಗೇಷನ್ ಜನರೇಟ್ ಮಾಡೋದು ಇದೇ ಕೆಲಸ. Why two orders? Who is this deputy commissioner who has passed this order?
Let them file their statement of objections.
ಇದೆಲ್ಲ ಹಂಗೆ ಇರಲಿ. The petitioner on the strength of the interim order is said to have joined service. The deputy commissioner who has passed a second order on 29 of the same date on 29/9/26 29/6/2024, they shall file an affidavit of explanation as to why a second order had to be passed on the same date and serve it on the petitioner on 4/7/2024, notwithstanding the earlier order on 29/6/2024 having been served upon him and him raising a challenge to the said order in writ petition 103-730 of 2024. The affidavit of the signatory to the said order dated 29/6/2024 shall be placed before this court on the next date. List the matter on 19th at 2:30 PM.
Please.
Will direct the deputy commissioner to be present who has passed this order. In the event the affidavit would not be filed, the deputy commissioner who has passed the order shall be present before the court.
Please.
19th better. Before 15th euros any day.
Before
14th.
15th ಆಗಲ್ಲ.
But interim order ಮಾಡಿ.
Interim order subsisting. ನಿಮ್ದೇನಿಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ ಅದಕ್ಕೆ interim
ನಾನು
order
first ಗೆನೇ ಹೇಳಿದೆ, it is for the deputy commissioner to defend these orders.
Interim order subsisting will continue to the next.
If at all they want to file the objections, they can file
You don't
in the
worry.
meanwhile.
First affidavit ಬರ್ಲಿ.
Please,
Yes.
please.
67, Mrityunjay Tata Bangi, Suresh Gundi.
Taken next week, my lord, I will seek some instruction from the bank also.
ಏನ್ ಮೃತ್ಯುಂಜಯ್?
Lord, no objection, but my lord, one request. Lord, Swamiji, who had opened an account with the bank, he passed away in 2016. Successor Swamiji, my lord, he is appointed, registered, my lord, Samputa Patra, registered documents have been executed in favor of the petitioner.
ಅಕೌಂಟ್ ಆಪರೇಟ್ ಮಾಡಕ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಕೊಡ್ತಾ ಇಲ್ಲ, ಅದನ್ನೇ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. Either in the name of the present Swamiji or the trust.
Some instruction.
The learned counsel Shukeel Patil seeks 10 days time to secure instructions and make his submissions or file objections as the case would be. List on 18th objections if any by then. 18th in preliminary hearing. Next.
Connected matter is of a different bank of the same petition.
ಅದೇನು?
Same relief.
Same, yes. Patil sir, next time ಮುಗ್ಸೋಣ.
68, SB Hebbali, Jay Shetty.
Please, my lord. Appearing for petitioner, my lord. Petitioner has filed an
You are
application.
Pranav.
Please, my lord.
ನೀವು ಯಾರ ಜೊತೆ ಇದ್ದೀರಾ?
I am attached to two of his, my lord.
Attached to
SB.
High Court? Yes.
Please. Petitioner has filed an application to enter her name in death certificate of her husband, my lord, which was rejected
Why?
because there were two wives claiming that they are the legal wives. Later, there was a
Your
compromise.
second wife?
No, I am town municipal council.
Government ga?
Town municipal.
Town municipal.
PMC ga?
PMC.
Later, my lord, there was a partition suit which was compromised, and the compromise petition is at page 10, my lord.
TMC was a party to it?
No, my lord.
No.
It has indeed,
ಏನೇನ್ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
there it is, in para 3, my lord, it is clear that the petitioner herein is the first wife of the deceased, my lord.
The second wife was also a party?
Please.
Oh.
It was between first wife and second wife, the partition between first wife and second wife.
Put an enter a safeguard, ಏನಿದು? Compromise petition ಎಲ್ಲಿದೆ?
Page 10, my lord. Relevant is in page 11, para 3, my lord. May I read?
My lord,
ಯಾವಾಗಿಂದ correct ಅಲ್ಲ ಹಾಕಿ.
Para 3, may I read, my lord? ಅರ್ಜಿ fourth line, my lord. ಅರ್ಜಿದಾರರು ಸದರಿ ಚಂದ್ರಶೇಖರಪ್ಪ ತಂದೆ ಗುರುಸಂಗಪ್ಪ ಹಳಪೇಟಿ ಇವರ ಮೊದಲನೇ ಪತ್ನಿ ಇದ್ದು.
ಈಗ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
To enter the petitioner name in death certificate of her husband, my lord, in column number 7, where the name of husband or wife is entered.
Register of TMC.
death certificate has been issued, my lord, long back on 15/9/2020.
In terms of the compromise correct ಮಾಡಿ ಅಷ್ಟೇ.
Terms of the
ಯಾರನ್ನ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಯಾರನ್ನು ಮೆನ್ಷನ್
ಹಸ್ಬೆಂಡ್
ಮಾಡಿಲ್ಲ.
ನಿಲ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, blank ಇದೆ.
ಬ್ಲಾಂಕ್ ಬಿಟ್ಟು.
ಯಾರಾದ್ರೂ ಹಸ್ಬೆಂಡ್ ಇರ್ಬೇಕಲ್ಲ?
ಅಲ್ಲ, husband's name, my lord, is Chandrasekhar Hore. Page number 8 may kind of listen. It was issued on, my lord, 15/9/2020.
ವೈಫ್ ನೇಮ್ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅವರು. It was, my lord, issued already.
ಈಗ suit
Now they are saying that, my lord, it should be incorporated now by virtue of the compromise decree. In fact, my lord, already issued question of, my lord,
ಕರೆಕ್ಷನ್ ಮಾಡಕ್ಕೆ
correction, my lord,
ಕರೆಕ್ಷನ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ವಿಷಯ
ಮಾಡಬಹುದು. By virtue of the order of the court.
Obviously, yes. The petitioner is before this court seeking the following prayer. The petitioner is said to be the legally wedded wife of one employee of the town municipal, employee na alla.
Employee.
Wedded wife of one Chandrasekhara Halapeti. The petitioner submits an application for entry of her name as a wife of the deceased in the death certificate before the officer under the Registrar of Deaths and Births and Deaths Act in the Town Municipal Council. The said application comes to be rejected on the score that the death certificate has already been drawn long ago and the wife's name is shown as blank, as no person was indicated in the application. The learned counsel for the petitioner submits that the petitioner, that the deceased had two wives. The two wives were before the concerned court, civil court in 398, in OS 398 of 2024, by 2024 for a declaration as to who is the legally wedded wife. In the said suit is compromised. The terms of compromise is as follows. The suit is decreed on the strength of the said compromise. The compromise clearly indicates that the present petitioner is the legally wedded wife. In the light of the compromise and the decree drawn by the competent civil court, the TMC now cannot deny the entry of the name of the petitioner as the wife of the deceased in the death certificate. The impediment projected by J.S. Shetty, the learned counsel appearing for the respondent, is that once the death certificate is issued, the same cannot be tinkered by including the name or excluding the name. In the light of the aforesaid circumstance, I deem it appropriate to direct the respondent TMC, the competent authority under the Registrar and Births and Deaths of the TMC, to act in accordance with the compromise and redeem the grievance of the petitioner by entering the name into the death certificate as being the wife of the deceased in the teeth of the said compromise. While so doing, it is open to the respondent to solicit any other document that would be needed for the needful action. If the aforesaid reasons, the following are allowed, quashed, matter is remitted. The authority, the mandamus issues to the respondent authority to bear in mind the observations in the course of the order and pass necessary orders in accordance with ordered according. Next.
Please. 59, M.R. Hiremat.
My lord, I am for a respondent 2357. My lord.
Petition for.
My lord, in this writ petition.
To submit.
Why you, sir?
To submit. The petitioners have filed this petition, Your Honor,
challenging the compromise decree passed. Compromise decree before the Lok Adalat. Enter by the respondents and including the property of the petitioners.
Sir, I am for a respondent, sir. Though, sir, petitioner are not at all a party in this compromise decree, sir.
It's all right. Suit ಗೆ ಅವ್ರ party ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, sir.
My humble
Suit for partition and compromise decree has been.
Correct, sir. Suit for partition. Who are they?
Sir, they are no one, sir.
Nobody ಅಂದ್ರೆ?
Sir, ಅವರು ಈ ಪಾರ್ಟಿ ಇದರಲ್ಲಿ ಪಾರ್ಟಿನೇ ಇಲ್ಲ ಸರ್. ರೆಸ್ಪಾಂಡೆಂಟ್
ಪಾರ್ಟಿ ಅಲ್ಲ, ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್.
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್.
ಆಮೇಲೆ
ಸರ್ ಇದು ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ರಿನ ಸರ್ ಡಿಸೆಂಬರ್ 2023 ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಇವರು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇರೋದು 2025 ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಸರ್. ಸರ್ ಇಟ್ ಇಸ್ ಲಿಮಿಟೇಷನ್ ಪೀರಿಯಡ್ ಇಸ್ ಎಕ್ಸ್ಪೈರ್ಡ್ ಸರ್. ಲಿಮಿಟೇಷನ್ ಪೀರಿಯಡ್
ಯಾವುದು ರಿಟ್ ಪಿಟಿಷನ್ ಇದಾ?
ಅಲ್ಲ ಸರ್, ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ರಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ.
ಫ್ರಾಡ್ ಇದ್ರೆ ಇನ್ನೊಂದು 20 ವರ್ಷ ಬಿಟ್ಟು ಚಾಲೆಂಜ್ ಮಾಡಬಹುದು
ಸರ್. ದಿಸ್ ಇಸ್ ನಾಟ್ ಅ ಫ್ರಾಡ್ ಸರ್.
ನೋಡೋಣ, ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಅವ್ರನ್ನ ಬಿಟ್ಬಿಟ್ಟು ಯಾಕೆ ನೀವು ಪಾರ್ಟಿಷನ್?
ಸರ್ ಇದು ನಮ್ಮ ಸರ್ ಅವರು
my humble submission, my lord, they have implemented us as a necessary party in the suit. They have included our property. The total property of survey number 27 was
delete ಮಾಡ್ಬಿಟ್ರ ನಿಮ್ಮನ್ನ?
18
delete ಮಾಡಿದ್ರಾ?
ಹೌದು ಸರ್, delete ಮಾಡಿದ್ದಾರೆ. 20 acres 18 acres of land 1984 ದೊಳಗೆ PT ಶೀಟ್ ಆಗಿದೆ. 1984 ದೊಳಗೆ ನಮಗೆ 7 acres 34 ಗುಂಟ ಬಂದಿದೆ. ಅವ್ರಿಗೆ
ಪಾರ್ಟಿ ಮಾಡಿದ್ರೋ ಇಲ್ವೋ ನಿಮ್ಮನ್ನ?
ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಸರ್. ಅದು DDLR ಮುಂದೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ. ಯಾವಾಗ ಅವ್ರದ್ದು ಟಫ್ ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ರಿ ಮಾಡ್ಕೊಂಡ DDLR ಮುಂದೆ ಹೋಗ್ಯಾರಲ್ಲ, ಅವಾಗ ಹೇಳಿದಾರ ಇಲ್ಲ ಅವ್ರು ಪಾರ್ಟಿ ಆಗ್ಬೇಕು, ಅವ್ರದ್ದು ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ಕೊಂಡಿರಿ ಅಂದಾಗ ಅಲ್ಲಿ ನಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ತಾರ.
ಎಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ರು?
DDLR ಮುಂದೆ.
ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ರು?
ಹಾ, ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡ್ತಾರೆ. ಕೈಂಡ್ಲಿ ಪೆರೋಸ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಸರ್ ಇಫ್ ಐ ಮೇ ಸರ್, ಸರ್ ಅವ್ರ ಹತ್ರ ನಾನು ಫಸ್ಟ್ ಕ್ವಶನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸರ್. ಅವ್ರಿಗೆ ಏನ್
ಕೇಳಬೇಡಿ,
ಸಾರಿ ಮೇಡಮ್, ಮೈ ಅಪಾಲಜೀಸ್ ಮೇಡಮ್. ಸರ್ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಏನ್ ಸರ್? ಅವ್ರದ್ದು ಪ್ರಾಬ್ಲಮ್ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದಾರ. ಏನಂತ ಪ್ರಾಬ್ಲಮ್ ಸರ್? ಅವ್ರು ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿಲ್ಲ?
ಎನಿವೇ ಅವ್ರನ್ನ ಬಿಟ್ಟು
if we go to the map sir, which is submitted hand map sir,
my humble submission, kindly peruse the annexure F.
These things should stop. ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಬಿಟ್ಬಿಟ್ಟು ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕೋದು, ಅವ್ರ ಪಾರ್ಟಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡೋದು.
sir respondents are divided their property in the 10 acres 13 guntas, which is
84 ದನ್ನ PT sheets ಅನ್ನ
will revive the suit.
Yes sir,
I'll revive the suit now.
Yes sir,
I'll revive the suit to be contested.
Yes sir,
everything will become all right.
Yes sir, that we welcome sir.
Revive the suit, all of you contest the partition.
Yes,
suit now. No compromise.
Whatever they contest taken, they
please don't
trial.
Please don't
compromise, send the matter back to the
Saunur
court.
Yes sir,
Saunur court. The suit.
Yes sir,
that's okay, correct.
Yes
we will we are having evidence sir, we will prove that.
Compromise ಎಲ್ಲ close ಮಾಡ್ತೀರಾ, ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ contest ಮಾಡಿ.
But please don't cancel this compromise decree sir.
I will annul that sir.
Yes sir,
I will annul the compromise, restore the suit, make them parties, contest the suit and take it to its
yes
logical
yes sir, yes yes please my lord.
ಅಷ್ಟೇ ಅಲ್ವಾ?
Yes ma'am.
ಮತ್ತೇನಾಯ್ತು? ಅದಕ್ಕೆ ಯಾಕೆ ಇಷ್ಟೊಂದು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದೀರಾ ಮತ್ತೆ?
No my lord, they have taken stay my lord.
ಅದನ್ನೇ ಸ್ಟೇ ಅಲ್ಲ, ಸೂಟ್ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿನೇ ಹೋಗುತ್ತೆ ಈಗ.
Yes your honor.
Yes, all right.
But ಸ್ವಲ್ಪ ಅಂದ್ರೆ ಹೊಳ್ಳಿ ವಾಪಸ್ ಅದನ್ನ ಇದನ್ನ ಮಾಡಕ್ಕೆ
ಹೊಳ್ಳಿ ಅಲ್ಲೇ
ಚಾಲೆಂಜ್
ಅದೇ ಕೋರ್ಟ್
ಟೌನೂರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಚಾಲೆಂಜ್
ಸೂಟ್ ನ ರೆಸ್ಟೋರ್ ಮಾಡ್ತೀನಿ.
Yes thank you. Yes
ಎಲ್ಲರೂ ಕಂಟೆಸ್ಟ್ ಮಾಡಿ
ಆಯ್ತು.
ಹೊಳ್ಳಿ ಎಲ್ಲರೂ ಅಲ್ಲೇ ಹೋಗಿ. Yes,
much obliged.
ನಾಳೆ ಮಾಡ್ತೀನಿ.
Yes,
because there's one more I have reserved.
Yes,
we'll see whether a non-party can challenge the compromise. We'll see.
Thank you.
My lord, may I submit in 68 my lord time frame ಒಂದು
ಯಾವುದಕ್ಕೆ?
ಅದು mandamus ಕೊಟ್ಟು.
The action shall be taken within 12 weeks from the date of receipt of the copy of the order. Yes.
Please.
Next.
My lord, initially I was appointed as a member of a consumer redressal forum.
Initially?
Allah, first term, he was appointed as
17.
By virtue of annexure E, he is appointed for second time.
Learned AGA seeks to file a statement of objections. The same is taken on record. Copy sir ಮಾಡಿದಾರಾ? ಕೊಡಿ. Copy of which shall be served upon the counsel appearing for the petitioners list on Wednesday in preliminary hearing. Next.
Connected matter file, but complaint of office objection.
Office objections be complied with in the meantime in 70.1.
Already complied.
Complied?
Please.
Counsel for the petitioner submits office objections have been complied with, office to verify. Next.
My lord, On submission, small point was involved in my case.
Objection ನೋಡೋದು ಬೇಡವಾ?
Please note. Yes.
ನೋಡ್ಬಿಟ್ಟು ಬನ್ನಿ.
Please.
ಸ್ಮಾಲ್ ಪಾಯಿಂಟೇ ವೆಡ್ನೆಸ್ಡೇ ಮಾಡೋಣ.
Please, please. Wednesday.
Ramchandramari.
My lord, I am appearing for the respondent number 2 and 3 institution, my lord. I pray for short accommodation to file my objections, my lord.
Learned Counsel J. Manil Kumar seeks 10 days time to file, 2 weeks time to file statement of objections. List the matter on 20th November in preliminary hearing. Objections, if any, by then.
It is covered already, my lord, time was granted. In fact, the institution itself, my lord, has submitted a proposal for approval, my lord, for our regularization. Clear case.
20th ಮಾಡು.
72, Sharanam Basuraj.
Petition.
Hiremat.
Annexure order passed by permanent local adalat, where compensation is granted 25 lakhs 98,000, 97,000, my lord. As per section 22C, my lord, there is a bar for granting.
Entry model ಇದೆಯಲ್ಲ.
Entry model.
All are served.
All are served.
ಇನ್ನೊಂದು opportunity ಕೊಡೋಣ.
Please.
List on 19th in preliminary hearing. Yes, next. Interim order subsisting will continue till the disposal of the petition.
Please, published.
Sri Ravi Hegde.
Interest on the belated payment of leave encashment.
ಇದೆಲ್ಲ ಎಷ್ಟಿದೆ ಇವತ್ತು?
I am giving the list.
ಕೊಡಿ.
21.
21 matters. ಕೊಡಿ. ಎಲ್ಲದರಲ್ಲಿ ಯಾರು ಪ್ರಶಾಂತ್ ಉಸ್ಮಾನಿಯಾ?
Please.
ಪ್ರಶಾಂತ್ ಇದಾರಾ ಇಲ್ಲಿ? ಟ್ಯಾಗ್ ದಿಸ್ ಪೆಟಿಷನ್ FR ಕೊಡ್ತೀರಾ?
ಇಲ್ಲ WP ನೂ ಇದೆ.
WP ಇದೆ. FR ನ ಟ್ಯಾಗ್ ಮಾಡಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಮುಗೀತಾ ಮೇಲೆ.
ಅಲ್ಲ.
ಇಷ್ಟು ಮಾತ್ರ ಟ್ಯಾಗ್ ಮಾಡಿ FR ನ ಕಂಪ್ಲೈ ಮಾಡಿ.
Please. I have already complied, my lord.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಇದನ್ನ tag this petitions along with so and so only if the office objections are complied with and the stage of the writ petitions have traveled beyond the FR numbers and list them all on
18th.
19th? 18th. Yes.
Please.
74, Sajid Ahmad Godwala.
Lord, in this, order is passed without jurisdiction. The second respondent, my lord, has passed the order. It is the third respondent who ought to have passed the order.
Who appears for the respondent?
State, my lord. And page 35 may kindly be seen, my lord.
Who is the competent authority?
Land Tribunal. Land Tribunal.
Who has passed the order?
Deputy Commissioner. Kindly, my lord, page 35.
The learned counsel for the petitioner submits that the issue lies in a narrow compass. The land tribunal, which ought to be passing the impugned order, the deputy commissioner has passed. He is chairman of the land tribunal.
No, my lord, assistant commissioner is the chairman.
The deputy commissioner has passed the order. Therefore, the order is without jurisdiction. The learned AGA seeks time to secure instructions and make his submissions. List the matter on next Thursday.
Meanwhile, stay, my lord, because they'll issue to the rival tenants, my lord. They'll issue the form number 1.
Status quo, the issue be maintained till the next date of hearing.
Obliged.
List on Thursday.
75, Sachin Siangli.
Government.
ಅದು ರಾಂಗ್ ಆಗಿ
ನೀವಿಲ್ಲ ಮೇಡಮ್.
ರಾಂಗ್ ಆಗಿದೆ.
AG registry delete the indication of AGA as appearing for 1 to 3 73 ಅಲ್ಲಿ.
Yes. Please.
75, Sachin Siangli.
My lord, 75, my lord, the respondent state has opened the rowdy sheeter, my lord, against the petitioner, my lord, rowdy sheeter C, my lord. My lord, only on the ground, my lord, the influence on the political influence, my lord, the respondent has opened the rowdy sheeter against me, my lord.
AGA is notice ಆಗಿದೆಯಾ?
Yes, my lord, already ಆಗಿದೆ.
File objections.
Objection. Why, sir? The learned AGA seeks time to secure instructions and make his submissions. NC rowdy ಆಗ?
C rowdy sheeter, my lord.
ಅಂದ್ರೆ ಈಗ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆಯಾ?
Yes, my lord.
ಆಮೇಲೆ ಅಪ್ಗ್ರೇಡ್ ಆಗುತ್ತೆ B A.
No, my lord. My lord, it's initially, my lord, the first complaint, my lord, it is a non-cognizable offense, my lord. Second one, my lord.
ರೌಡಿ ಶೀಟ್ ಓಪನ್ ಮಾಡಕ್ಕೆ ನಿಮ್ ಥ್ರೆಟ್ ಇದ್ರೆ ಸಾಕು. ಅಲ್ಲಿ ಇಲ್ಲಿ ನೀವು ವಿಸಿಲ್ ಹಾಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರೆ ಸಾಕು.
No, my lord, he is my lord, there is a local leader, my lord.
Local leader?
Yes, my lord. My lord, what happened, my lord, situation, my lord, in the local area of the, my lord, one company is work establishing the work, my lord, Rentica company, my lord. On that time, my lord, they are not paid the amount to the landlords, my lord.
ಅದಕ್ಕೆ ನೀವು ಲೋಕಲ್ ಲೀಡರ್ ಅಲ್ಲೂ ಗಲಾಟೆ ಮಾಡಿದ್ರಿ.
No, my lord, we are approached the police authority and their DC, my lord, only for the restricting this petition, my lord, they are open the rowdy sheeter, my lord.
ಅದೇ ಟೂಲ್ ಬೆಳಗ್ಗೆ ಅದಕ್ಕೆ AAG ಹೇಳಿದ್ ನಾನು. Externment ಇವೆಲ್ಲ they are tools of misuse at the hands of the officers. If we don't control them.
Even, my lord, they are arrested, my lord, in another one case, my lord.
ಅದೇ you don't like his face, rowdy sheet, externment ಎಲ್ಲ ಮಾಡ್ತೀರಾ.
Even within 2 days, my lord, they are open rowdy sheeter, my lord.
ಅದಕ್ಕೇನು ಟೈಮ್ ಲಿಮಿಟ್ ಇದೆಯಾ?
My lord, at least hearing ಮಾಡಿ ಅದು detail order pass ಮಾಡಬೇಕು sir. There is no detail order also.
List on look into the judgment BN Prakash. ನೋಡಿದ್ದೀರಾ? ಏನ್ ನೀವು ಬರ್ಕೊಳ್ಳಿ. WP 4504 of 2022 disposed on 22/4/2023. ಅದ್ರಲ್ಲೊಂದು ಚಾರ್ಟ್ ಹಾಕಿದ್ದಾರೆ ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ರು ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ. ರೌಡಿ ಶೀಟ್ ಓಪನ್ ಮಾಡ್ಬೇಕಾರೆ. ನೆಕ್ಸ್ಟ್
76 Ganapati Bhatt.
Petitioner, my lord. My lord, election is already held in respondents.
Dispose ಮಾಡೋಣ. Dispose. Elections already held.
My lord, this honorable state for declaring the results. Meanwhile,
Correct, sir. I will direct declaration of results. Sir, administrator ಇದು. 76 ಏನಿದು?
Sir, 76.
Appointment of administrator ಅಂತಿದೆ.
The said action is questioned in this present writ petition, my lord.
The said action is stayed. Yes, Ramesh.
Administrator is appointed, my lords.
Charge assume ಮಾಡಿಲ್ಲ ಅಂತ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ.
Yes, my lords.
Assume ಮಾಡಿದಾರಾ ಇಲ್ವಾ ಏನು? ಅವ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ. Yes. List the matter on 18th.
Please.
Interim order subsisting will continue to the next date of hearing.
Connected matter listed on tomorrow. Kindly list this.
Connected matter ಯಾವ್ದಿದೆ? ಒಂದೇ ಇರೋದು.
106790 of 25.
ಒಂದೇ ಇರೋದು ಇಲ್ಲಿ.
ನಾಳೆ ಲಿಸ್ಟ್ ಇದೆ my lord, ಇದು
ನಾಳೆಗೆ ಇವತ್ತೇ ನೀವು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಿದ್ರಿ. ನಾಳೆ ಬರ್ರಿ. ಎಸ್
77 Syed Arich.
Post immediately after service of notice upon response 2 and 3. ಯಾರಿಗೆ?
Equitas Bank, my lord. Equitas Bank, my lord.
Equitas.
Yes, my lord.
2 and 3.
Yes, my lord.
Learned counsel Sachin Angdi undertakes to enter appearance for respondents 2 and 3. Register to print the name of so and so is appearing for respondents 2 and 3. Thus completes the service of notice. List the matter on Tuesday in preliminary hearing. Next.
A fresh matter, my lord. There is a pending, my lord.
Surface in
Yes, my lord.
list the matter on Tuesday in fresh matters list. Next.
79 HM Dharwad.
But the identical matters already, my lord, the heard and resolved part orders.
ಇದೆ ಏನದು?
ಅದು my lord, the government, my lord, the granted 6,000 acres to the.
Oh, that one. Yes, all right. Then we'll adjourn it by 4 weeks. ಅದೇನಾಗುತ್ತೆ ಅದೇ ಆಗುತ್ತೆ.
ಅದರಲ್ಲಿ respond number 11 and 12 Shivraj Hiremat is appear.
Register to print, learned counsel Shivraj Hiremat is directed to accept notice for respondents.
11 and 12.
11 and 12. Register to print the name of so and so.
13 government, my lord.
List on 4th December. Ashal pronounce ಮಾಡುತ್ತೆ. Yes.
Interim ಮಾಡ್ರಿ.
Interim ಮಾಡ್ರಿ ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಇದೆ.
ಅದರಲ್ಲಿ ಇದ್ರೆ
ಇಲ್ಲ ಇದರಲ್ಲಿ
ಬರಲ್ಲ ಬಿಡಿ ಏನು ತೊಂದ್ರೆ.
Please.
Next.
For respondent number 14, my name and kindly be shown.
So and so Sangram Kulkarni accepts notice for respondent number 14. Register to print the name of so and so is appearing for respondent. Next.
Kind request for compromise. Compromise.
100.
Yes.
100 Prithvi case.
Offense in.
No, it's my lord, land reforms and my lord, compromise decree, civil case. Yes, this is the petition. My lord, 2 applications are listed today.
Serial number 100.
100 my lords. Compromise is in the 100.1 GMRES matter. I'll just my lord,
parties to the list. ಏನು ಹೇಳ್ಬೇಕಾ?
ಅದು ಅಪ್ಲಿಕೇಶನ್ ಸಲುವಾಗಬೇಕಾಗಿತ್ತು. That please.
The petitioners are before this court seeking the following prayer. The parties to the list during the subsistence of the subject petitions have entered into a compromise by drawing up certain terms of compromise. The terms of compromise reads as follows. Madam, flag ಇದೆ. Reads as follows. In the light of the compromise so entered into between the parties, ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದಿಲ್ಲಿ?
Compromise decree Manoj before the Lok Adalat.
The compromise decree that is subject matter of challenge shall now stand modified in terms of the compromise that is entered into before this court in the subject petition as quoted herein above. The decree, the concerned court shall draw up a decree accordingly accordingly indicating the aforesaid compromise. The parties to the list are present before the court and are identified by the respective learned counsel. Our signatures.
Yes, please. With regard to those, by virtue of this compromise, serial number 100, which is challenging form number 7, rejection of form number 7, that's withdrawn by them.
The learned
That's
counsel
also
for
a
the
term.
petition. In the light of the compromise entered into in 100.1, the learned counsel for the petitioner files a memo seeking to withdraw the petition, 100 number, withdraw the petition. In the memo is taken on record, the petition is disposed as withdrawn.
In 100.1 Manoj, there are two applications. What had happened is Manoj, the plaintiff in the suit was represented by his GPA. Now GPA is also
application.
permission to prosecute by himself and on application hakide. First application. He was earlier represented by GPA. That he has to Manoj, that has to be allowed. And GPA has filed an impleading application to come on record because he is also
the two applications are orderly baradbidi mele. Two separate order sheet. Two applications are filed in the subject petition. One seeking permission to prosecute as the petitioner was not a party before the.
No, petitioner was represented by his GPA. Now he wants to prosecute in his.
Petitioner was represented by his general power of attorney, but wants to prosecute himself. In the light of the reasons indicated in the accompanying affidavit, the application stands allowed. You know, the
GPA now wants to implead because he is also getting a right in the compromise.
The holder of the general power of attorney is also wanting to implead into these petitions. The impleadment application, the applications are not opposed by the respondents. In that light, the applications stand allowed.
Memo to delete respond number 6. She has died, my lord.
During the subsistence of the subject petition, the 6th respondent is said to have died. Therefore, the memo is filed to delete the respondent number 6. In the light of the death, the respondent number 6 be deleted from the array of parties.
Petitioner name spelling mistake ಇದೆ ಅದೊಂದು ಕರೆಕ್ಟ್ ಮಾಡಿ petitioner name spelling mistake ಇದೆ
In the
cost title
of the petitioner is Mallari, MALLARI.
original petition ಮೇಲೆ
ಏನು ಹಾಕಿದ್ದೀರಾ?
Originally
ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ ಸರಿ ಇದೆ ಒರಿಜಿನಲ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
LHARI ಅಂತ ಆಗಿದೆ. That has to be MALLARI. ಅಷ್ಟೇ
ಪ್ಲೀಸ್
ಅದು ಹೇಳ್ಬೇಕಾ?
ಅದೊಂದು oral request.
Learned counsel Vishwanath Hegde submits the name of the petitioner is wrongly spelt in the petition. It has to be MALLRI but has been printed as MALARI.
MALLARI.
ಏನ್ ಆಗ್ಬೇಕೀಗ?
LLARI.
LLARI. ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ಮಾಡಿ.
Grateful words.
Yes. Next. ಕರೀರಿ.
Serial number 141, the employee is going to retire.
ಅದೇನೋ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂದ್ರಲ್ಲ, ಆಯ್ತು ಕೊಡಿ. ಯಾರು ಗುರುಜಿ?
141.
Come this side.
The validity of rule is called in question. Government has to.
What's the matter, sir? ಹೇಳಿ.
It's a petition for absorption of services. He is working as
Mike.
He is right now working as part-time lecturer. He is seeking absorption services. For last about 25 years, he is working as part-time lecturer. The facts of the case are that in 1991, he passed MA in mathematics, scoring 51.6% marks. In 1993, July, he was appointed as a part-time lecturer in mathematics.
Today also is a part-time lecturer. Even today.
Yes, even now.
Yes, Subbuji.
Lord, rule has called in question, Lord.
What rule?
Lord, Annexure K, my lord. The rules, my lord, absorption of a person working as part-time.
1993 rules.
Lord,
1993 rules.
2010 rules, my lord.
Uh,
So government has to say, my lord, I'm not. He's working in the management.
He's taken by surprise. Yes, madam.
My lords will find, my lord, that ink page 77.
Consider very mandamus iradu.
And subsequently, he got amended the rules.
Writ petition was amended
Why?
because Annexure K, that is the rules relating to a pre-university college, was challenged.
The petition challenges the, which rules are there?
No, Annexure K, my lord.
Annexure K.
Annexure K.
Karnataka Educational Institution, absorption of.
The petition challenges the so and so rules, Annexure K in Nodi. Therefore, the state shall secure instructions and make the submissions. List on 19th.
It kindly be taken tomorrow.
Tomorrow, rules act challenge madri.
Hardly 8 months time is left out because.
Correct. Rules challenge madadmel state has to answer. List on 18th at 2:30
I will require just half an hour to complete my submissions.
I won't take even that much time to get to know the case. I need 5 minutes, but let them answer. Half an hour, yav case ku tagonde illa. Don't. Yes.
No, maximum, that's what I'm saying.
No, nan threshold minimum nandu helidde. List on 18th.
Huh? 18?
At 2:30 p.m. Next.
If it can be posted.
Service matter, ardha gante. Oh.
No, I can finish it in 15 minutes. That's not
No problem. Yes.
If it can be posted next week.
No, sir. Let them answer. Let the government advocate, let the HCGP look into
No,
it.
let him take time. I have no objection for that.
ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿ ಮತ್ತೆ ಅವ್ರನ್ನ ಪೀಸ್ ಮೀಲ್ ಕೇಳೋದೇನು ಒಂದೇ ಸರಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
But at least it will be parted so that it can be.
I am not going till December, sir. I am here only. Yes.
Last 6 months it is being listed, but it is not reaching final hearing.
It will reach, sir. Don't worry. You don't worry about all that. You come prepared on the next day, madam. Yes. Next.
B group matter still number 81 FP Patil.
Land acquisition matter, my lord. Prepared a short synopsis, my lord.
Ready?
Please. Ready.
Hey, Shavrat sir idara?
Either. Lord, I have prepared a short synopsis, my lord.
You are there today?
Lord, my learned friend said that.
ನಾಳೆ ಆ ಕೇಸ್ಗೆ ಇದ್ದೀರಾ? ಇಲ್ಲೇ ಇರ್ತೀರಾ? ನಾಳೆ ಆಗ್ತೀನಿ ಅಂತ.
ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಒಂದು ಫಸ್ಟ್ ಕೋರ್ಟಿನ ಮ್ಯಾಟರ್ ಇದೆ some part. 17th or 24th, your lordship may have it.
Lord, I'll just
see what is it.
5 minutes, my lord, not more than. Please.
What's the matter, sir?
The preliminary notification, my lord, is of the year 2011. The purpose for acquisition, my lord, is for a stockyard to, my lord, store iron ore. My lord, final notification is also of the year 2011, my lord. In 2013, my lord, the Honorable Apex Court, my lord, recommended, my lord, for closure of, my lord, C category mines.
Correct.
And cancelled, my lord, all the lease.
Samaja Parivartana Samhita.
Subsequent to which, my lord, there is a government notification also, my lord, wherein, my lord, the license, the lease that is awarded to the respondent number 5, my lord, who is the beneficiary, my lord, stood cancelled. The acquisition, my lord, was specifically, my lord, for the benefit
purpose of
the purpose, my lord, storage for respondent number 5, who is the beneficiary, my lord. Their lease, my lord, came to be cancelled. After the Supreme Court judgment, my lord, the award came to be passed in the year 2013, my lord. Subsequent to which, my lord, as my lord, there was, as their lease was cancelled.
You are the landowner, is it?
I am the landowner. On 3 occasions, my lord, they write to the deputy commissioner to say, my lord, that don't proceed with this acquisition, and we have deposited 1 crore in the treasury, which may be refunded to us. On 3 occasions, my lord, they write to the deputy commissioner.
What happens later?
My lord, later, my lord, because the matter was pending before this honorable court, my lord, it was not proceeded. When, my lord, this matter was heard on the last occasion, my lord, and for final disposal, at that time, my lord, not before the coordinate bench, my lord, at that time, my lord, that is on 30/8/2023, my lord. My lord, they have now written a letter to the same deputy commissioner saying that please proceed with the acquisition, and we don't want the land for this purpose, but for afforestation.
It's not so, my lord. I will make my submissions. Lord, this C category has nothing to do with this acquisition. It is for the purpose of.
The deputy commissioner communicate thrice that you don't
Lord,
want
that has
the
been
land.
withdrawn long back.
But not once, twice, thrice. Why?
No, no, Lord, we have.
2013 to 2023, what happened?
Lord, position is taken, award is passed, the amount, my lord, is dispersed in respect of some of the landowners, and you lordship may kindly see, this is for the purpose of storage of, my lord, iron ore, and, my lord, the cancellation has nothing to do with, and, my lord, he was a contractor under the fifth respondent, and, my lord, he was responsible for cancellation of this lease, L number, my lord, license number 995. We terminated, my lord, that contract because of his, my lord, dumping the waste in a, my lord, prohibited area. That led to the cancellation, and, my lord, this acquisition has nothing to do with, my lord, that. We will, my lord,
That's
convince
all.
you.
I've heard him. ನಿಮ್ದು ಅಷ್ಟೇ ಇನ್ನು ಯಾವತ್ತು ಬೇಕು?
ನಾನು 17th or 24th.
List on 17th in preliminary hearing.
ಅಲ್ಲ ಅವ್ರು
ಅವ್ರಿಗೇನೋ 17th.
ಒಂದು ಬಾರಿ ಮುಗಿಸ್ಬಿಡ್ಲಿ, ನನಗೆ ಇವ್ರು ಟೈಮ್ ತಗೋತೀನಿ ಅಂತ ಹೇಳಿ ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ.
ನಾನೇ ಕೇಳಿದ್ದಾನೆ ಏನ್ ಕೇಸ್? I asked what is the case.
ನಾನು ಎಲ್ಲ, my lord, in fact I have submitted my points of submissions already. I'll just, my lord, take your losses through the submission.
ಮುಗಿಸ್ತೀರಾ?
ಅಲ್ಲ, next hearing ನಲ್ಲಿ ತೋರಿಸಿ.
24th, please.
List on 24th. Yes.
Lord, I have also marked the judgments with paragraph
Yes.
number.
List on 24th. ಅಷ್ಟೇ.
ಅಲ್ಲ, my lords may kindly see, he has, my lord, no interest in the, my lord, in the acquisition of the lands for the purpose of, my lord, storage of iron ore. This is not for mining purpose. And, my lord, he says that I want to use it for mining purpose. That is why I have, my lord, purchased it.
We'll see. Yes, list on 24th.
Please, I'm obliged.
Till 84.
Preliminary
Yeah,
hearing.
230.
Same stage. Next. 80?
82, my lord. Statement of objection is not filed, my lord. It may be called after 2 weeks.
2012.
ಹೌದು, ಅವರು
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
ಮೇಡಮ್
In this, my lord,
ಮೊನ್ನೆ ಇತ್ತಲ್ಲ ಅದ?
ಹೌದು.
my lords, in this they are, I'll file rejoinder.
Rejoinder.
ಇಲ್ಲ, statement of objection.
Finally, this time is granted to file statement of objections to respondents 2 and 3. The matter is of the year 2012. In the event objections would not be filed by the next date, it shall be construed that there are no objections to the petition. List the matter on 18th. Yes,
Please,
next.
obliged.
18th ಇದೀರಾ?
19th.
19th, yes.
84.
Please.
Shivraj P. Mudhwa.
For petitioner, for seeking compensate appointment, no, Lord. Lord, the petitioner husband died on 10/1/2023, 2013, Lord. But after that, Lord, the petitioner made an application to the
Ram Sahayaka.
Ram Sahayaka. Kindly make
How rules ನಿಮಗೆ applicable? Same compassionate appointment rules?
ಇಲ್ಲ ಕಂಪಲ್ಸನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಬರಲ್ಲ.
ನಿಮ್ಗೆ ನಿಮ್ಮ ಅಪಾಯಿಂಟ್ಮೆಂಟ್
Annexure C, may kindly annexure C, Lord. Lord, ಅದರಲ್ಲಿ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಿಮಗೆ ತಿಳಿಸಿದಂತೆ ನಿಮ್ಮ ಪತಿಯಾದ ಸ್ವಯಂ ಇವರು ಮೃತರಾದ ಕಾರಣ ಖಾಲಿಯಾಗಿರೋ ಜಾಗ ಸ್ವಯಂ ಹುದ್ದೆಗೆ ಬಿಟ್ಟು ನಿಮ್ಮ ಪತಿಯ ತಮ್ಮನಾದ ಪ್ರವೀಣ್ ಇವರನ್ನು ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲು ಹೇಳಿಕೆ ಮತ್ತು ಒಪ್ಪಿಗೆ ಪತ್ರ ನೀಡುತ್ತೀರಿ. ಆದರೆ ಕಾನೂನಿನಲ್ಲಿ ಸೇವೆಯಲ್ಲಿ ಮೃತರಾದ ಗ್ರಾಮ ಸಹಾಯಕ ಕುಟುಂಬಕ್ಕೆ ಮಾತ್ರ ಅನುಕಂಪ ಆಧಾರದ ಮೇಲೆ ಆದ್ಯತೆ ನೀಡಬೇಕಾಗಿ ವಿನಂತಿ ಮಾಡಿಕೊಳ್ಳಲು ಅವಕಾಶ ಇರ್ತದೆ.
Annexure C, page number 22.
ಆದ್ಯತೆ ನೇಮಕಾತಿ ಬೇರೆಯವರ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಆದರೆ ಕಾನೂನು ಸೇವೆಯಲ್ಲಿ ಮೃತರಾದ ಗ್ರಾಮದ ಸಹಾಯಕ ಮಕ್ಕಳಿಗೆ ಮಾತ್ರ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ
ಆದ್ಯತೆ ನೀಡಿ ನೇಮಕ.
ಯಾರು ಬರ್ದಿರೋದು ಆರ್ಡರ್?
ತಹಶೀಲ್ದಾರ್ as well, sir.
As per the circular, your lordship.
Where is the circular?
Produce, annexure G, page number 36 is the type of copy, 37, item number 3, page number 34.
37, sorry, 37.
ಸೇವೆಯಲ್ಲಿ ಇರುವಾಗ ಮರಣ ಹೊಂದುವ ಗ್ರಾಮ ಸಹಾಯಕರ ಮಕ್ಕಳಿಗೆ ಕುಟುಂಬಕ್ಕೆ ಅನುಗುಣವಾದ ಮೇಲೆ ಗ್ರಾಮ
ಸಹಾಯಕ ಕೆಲಸ ನೀಡಲು
ಆದ್ಯತೆ ನೀಡಬೇಕು.
Without considering my reapprentice, issued a fresh notification.
It is ಆದ್ಯತೆ. ಆದ್ಯತೆ when
ಆದ್ಯತೆ ಇರಬೇಕಾದ್ರೆ ಸಾಧ್ಯತೆ ಕೇಳ್ತಿರೋದಿಲ್ಲ.
Subsequently notification has been called for. Thereafter I have applied.
ಸರಿ, ಆದ್ಯತೆ ಕೊಟ್ಬಿಟ್ ಮೇಲೆ ಮಾಡಿದ್ರ? Oh, you are the selected candidate.
Yes, my lords.
Yes, madam.
Your Lordship, as per the notification, petitioner is entitled, Your Lordship. But somehow.
Again, stay ಆಗಿದೆಯಾ ಇದು?
ಇಲ್ಲ, stay ಇಲ್ಲ. 2013 order.
ಆಯ್ತು,
There is
ನೀವೇನು
a delay
ಜಾಯಿನ್
in-
ಆಗಿದ್ದೀರಾ ಈಗ?
Yes, my lord. 2013 ಇಂದ I am working here, my lords, from last 12 years.
Family members not.
10 ವರ್ಷ ಆಗಿದೆ, ಅನುಕಂಪ ಎಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ ಈಗ. Why did you call for applications without looking
Without
into it?
considering, my lord, objection.
ಈಗ ಇವ್ರಿಗ
Because as
Your
per.
pursuant to selection process is now selected.
Yes, ಹೌದು.
10 ವರ್ಷದಿಂದ ಅವ್ರು ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ.
He's working.
12 ವರ್ಷದಿಂದ.
12 ವರ್ಷ.
On delay also,
Your
Your Lordship.
Endorsement ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ I have no case not. Because of Tahsildar being, my lord, given endorsement.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದು? ಯಾವ ವರ್ಷ?
2013 ನಲ್ಲಿ endorsement ಕೊಟ್ಟಿದ್ದಾರೆ.
2008.
13 my lord, annexure C.
ನೀವು ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ 2018 ಅಲ್ಲಿ. 5 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ?
KT ಹೋಗಿ.
KT
KT ಹೋಗಿ 17 July they withdrew it. And
KT is not maintainable.
Yes, December 18. There also after 1.5 years they have approached the writ petition.
ಆಮೇಲೆ immediate note, immediate the endorsement, immediate made an application.
Follow Sajad Ahmad Mir and say 12 years ಆದ್ಮೇಲೆ ಕಂಪಲ್ಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಬರಲ್ಲ. ಇಲ್ಲರ ಅವ್ರಿಗೆ ತೊಂದರೆ ಯಾಕೆ ಕೊಡ್ತೀವಿ? ನೀವೆಲ್ಲೋ ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ತೀರ.
Tomorrow,
is also ನೀವು ಗ್ರಾಮ ಸಹಾಯಕರು ಅವರಿಗೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
tomorrow, fresh matter.
ಇದು ರಾಬಿಂಗ್ ಪೀಟರ್ ಪೇಯಿಂಗ್ ಪಾಲ್ ಆಗಲ್ಲ ಇಲ್ಲಿ.
ತಹಶೀಲ್ದಾರ್ ಅದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ I have no case not.
ಆಯ್ತು, we'll resolve something. Yes, we'll take it on Tuesday.
Please.
ಏನಾರು ಒಂದು ಮಾಡುವ ತಾಳಿ. ನಿಮಗೂ ಏನಾರು ಆಗ್ಬೇಕು, ಅವ್ರಿಗೂ ಉಳಿಬೇಕು. We'll think it over.
ಬೇರೆ ಊರಲ್ಲಿ ಏನಾದ್ರು
Left them.
We'll pass some more.
85, Anandar Kolli.
Your Lordship, kindly next week, Your Lordship.
Planet Council seeks a week's time to go through the papers and make her submissions.
Please.
19th.
Please, Your Lordship.
87, Shivraj Isbanduri.
Petitioner is a government contractor, my lords, seeking GST refund from the government authorities. My lords.
AG want to appear.
ASG.
AG ಅವರು ಬರ್ತಾರೆ. Next
And maybe
week. ಅಲ್ಲ ಗಂಗಾಧರ್ appears.
AAG.
AG.
ASG ಯಾಕಪ್ಪ?
May be permitted to place on record, my lords, covered by your lordship's judgment.
ನಾನೇ ಬರ್ದಿದ್ದೀನಿ ಕೊಡಿ.
Even there are two other judgments of this coordinate bench of this court, my lords.
The learned AGA submits that the learned AAG would be wanting to appear in the case at hand. List the matter on Tuesday. Refund of GST is covered.
I'll collect the copies and my lords.
ಯಾರಿಗೆ? AAG ಕೊಟ್ಬಿಡಿ ಅದು. Yes, next.
As per the arbitration clause, my lord, he has to approach the competent authority.
For what, sir? Refund of GST.
Illi what has happened is several authorities have been implicated in one petition.
Why?
Comprehensive petition. There are
Comprehensive ಅಲ್ಲ. ಅವರು ಯಾರ್ಯಾರು GST ಕಟ್ ಮಾಡಿ there is a reason for doing so.
Please, my lords.
Justice Krishna Kumar our order ನೋಡಿ.
At para 4, my lords.
he has entered into different contracts.
Correct. Different organizations I know, but that need not result in arbitration. See Justice Krishna Kumar's order there. ಇಲ್ವಾ ಕೊಟ್ಟಿಲ್ವಾ?
Please, my lords. It is there. It is there.
Completely covered by that. Yes.
At para 4, para 7, my lords.
88, Harachandra.
Highly obliged, my lords.
This, my lords, it may kindly be posted in the third week. My lords.
Allotment of an industrial site, he has made an application, my lord. And he has deposited, and he has been allotted a site, my lord. Thereafter, as per the terms and conditions imposed by the respondent, my lord, he has deposited a preliminary amount, my lord. And thereafter, he were to deposit a balance amount within 6 installments, my lord. since he belongs to minority. And without providing an opportunity, my lordship, all of a sudden, a notice was issued cancelling the allotment, my lordship.
Stay there.
Stays there.
At the request of counsel, Srimati Sharmila M. Patil, list the matter on 19th as a last chance. It is made clear no further adjournment would be granted in the matter. Interim order, absolutely.
No,
Interim
from
order
time to
subsisting
time.
will continue to the next date of hearing. Next.
My request in preliminary hearing. Please.
We'll reach everything and leave. Don't.
Yes, I pay for petitioner, my lord. Petitioner is seeking, my lord, the regularization of his service with retrospective effect, my lord.
The objection hakbaka?
They have filed objection.
19 ಎಲ್ಲ ಓದ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ಬರ್ಕೊಳ್ಳಿ ಯಾವತ್ತು. List on 19th.
Not it may be listed, my lord, on the
19th in preliminary hearing.
Please.
Yes.
93 Sangram is Kulkarni.
20th. List on 20th.
94 Shantif Gowda.
Your Lordship, I appear for the petitioner. It may take some time to argue this matter, Your Lordship, if Your Lordship may fix a date.
So what? Let it take time, no problem.
Your Lordship, my senior is also out of station at the moment. If it
Yeah,
may be.
Prashant Gowda is out of station now.
No, Your Lordship, Rohan Kothari.
Who?
Rohan Kothari.
Rohan Kothari, Your Lordship, for the petitioner.
He is now on record, is it?
He has come on record.
He is on record, Your Lordship. There's a NOC Vakalat filed.
All right. Prashant Gowda ilva? He's not there.
No.
On record, he's not there.
He on record, he is also there, but I think he'll be.
Right. List the matter on 19th.
Please.
Grateful.
95 Anand P. Saudi. KL Patil.
ಏನು CH ಮೂಡ್ ಅಂತ ಇದೆ ಅಲ್ಲ? No representation. ಅದು 5 ಗಂಟೆ ಆಗೋಯ್ತು. List the matter on 21st November. Next.
96 A. Mali Patil.
Please, it's a writ of mandamus, my lords.
Respondent ಯಾರು? State ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು?
My lords, I have given the representation to the my lords as per annexure
90
E, E1, G and H, my lords.
Representation for what, sir? Consider representations ಹೌದು.
Page number 197, my
Sir,
lords.
general award covered.
Please. He says that.
ಇಲ್ಲಿ
not
general
seized.
award judgments.
Yes.
ಅಲ್ಲಿ ಇದಕ್ಕೆ consider representation same general award ಅಂತ ಹಾಕಿ. Yes. Next.
97 Jagdish Patil. VS Kamte.
Compassionate ground, Your Lordship. Short date, you know.
ಏನ್ ಮ್ಯಾರಿಡ್ ಡಾಟರ್ ಇದು?
ಇಲ್ಲ.
Come sir ilva. Yes. List the matter on 19th.
19th better. 12th or 13th. Sorry.
12th, 13th. Okay, 13th.
Yes.
98 Girish V. Bhatt.
Same 13th.
99 Vidyavati M. Kotur Shetter.
Short date. Interim order extended.
Interim order ಇದೆಯಾ? List the matter on 25th November. Interim order subsisting will continue.
My lord, short date.
Shortest date ಕೊಟ್ಟಿದೆ. Yes, next.
Not one.
ಎಲ್ಲಾರು ಯಾಕೆ ಇಲ್ಲಿ? ಈಗ ಆಯ್ತು, ಕ್ಲೋಸ್ ಆಯ್ತು. Yes. ನಿಮ್ದಲ್ಲ ನಿಮ್ದು. 101. Yes, Nagaraj Hegde.
Not one.
But petitioner is seeking, my lord, pay scale, my lord, of the petitioner to higher AGP. It is fixed on as per annexure E and G. Higher AGP was not paid, my lord, though it is included, my lord, that the service of the petitioner has been.
Respondent Suresh Bhatt. List the matter.
Well, Suresh Bhatt is formal party, my lord. The government
Suresh
is.
Bhatt is formal party.
He is appearing for the college. He is.
Government,
Government is.
Yes, madam. List the matter on
19th, my lord, same on
19th.
Preliminary English, my lord.
Preliminary.
Hello, obliged.
Not to Prashant Matpati.
100, Manoj, we forgot mentioning one aspect. Respondent number 9 is a minor. Advocate has also filed certificate.
Certificate I have filed.
ಅದು terms ಅಲ್ಲೂ ಇದೆ. Certificate is also annexed to the compromise.
Observation.
ಏನು? Yes. ಅದನ್ನ ಕೋಟೆ ಮಾಡಿದ್ದೀನಿ compromise.
That may be, yes.
Lord, challenging the Lok Adalat award.
ಯಾವ್ದು serial number?
102, my lord. Lord, it's a covered matter. All contested respondent has up, my lord.
All served. Chetna Biraj.
They are only, my lord's formal party, my lord.
Formal party.
Not sir, I produced the covered judgment also, my lord, page 75. Not my GP was misused and entered into
This the
compromise.
matter on Tuesday in preliminary hearing.
Please, interim order, my lord.
Intermodal continue. Mallikarjun Swami.
Not 3.
All these three matters relates to the temple merits at Ballari at the instance of the executive officer.
What's the challenge, sir?
So this is a case where a mandamus is sought to consider the representation. The facts are these, my lord. The present petitioner, my lord, sees a
Hold inquiry against respondent.
Yes,
demolished historical pillars.
Yes, my lord. Now he says this was done long back.
Who has demolished?
The executive officer.
Why did he demolish?
My lord, he has sold away this, my lord, sir. It's a old, my lord, pillar.
Executive officer sold away.
How though? We have produced everything before the deputy commissioner.
No action is taken.
No action is taken, and in a connected petition, my lord, wherein after I raise objection against him, he, my lord, suspends me, my lord, from being
Who
the
are
head
you?
priest. I am the head priest of the, my lord, temple. It's a hereditary trust. All our family members appoint, my lord, us.
ಯಾರು ಇದು executive officer?
Lord, his name is Hanmantappa, my lord. He is shown as, my lord, in his individual capacity. Respond number 4.
Is not represented?
He is represented by, my lord, by M.V.
Remat.
Out.
List the matter on Wednesday in fresh matters list.
Please. In the connected matters, there is subsisting interim order.
Interim order.
It's a connected matter, sir.
Interim orders in any of these cases shall continue to the next date of hearing.
Please.
104, Shivraj is Ballali.
What? He is an officer, is it?
Executive officer is appointed by the government.
KS.
Illa, KS.
ಅಂತ ಯಾರು? Anyway, ಬರ್ಲಿ ಬಿಡಿ.
Ranking government ಗೊತ್ತಿಲ್ಲ. And he is there from past 8 years.
We'll see. Yes. Next.
104, Shivraj is Ballali.
Writ of mandamus, my lords.
Who has to consider?
My land has been acquired, my lords.
Land has been acquired according to them 30 years back.
ಆಯ್ತು, ಕನ್ಸಿಡರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇದೆಯಾ?
Representation ಇದೆ.
Compensation ಕೊಟ್ಟಿಲ್ವಾ?
No, my lords. Neither the acquisition proceedings were taken place. Neither I was informed
initiation
in
of
regard to
acquisition
that.
proceedings.
Utilize.
30 years back ಅಂತ ಅವರೇ
Covered. 100 years ಆದ್ರೂ if you utilize private land, you have to give compensation. How can you utilize without acquisition? The petitioner is before this court seeking the following prayer. The petitioners are said to be the owners of land in block number 272/P measuring 7 acres and 30 guntas. The said land about 30 years ago is said to have been unauthorizedly utilized by the state to construct a primary health care center. The defense of the state is that it was acquired, the utilization has taken place 30 years ago and the petitioners have kept quiet throughout. The petitioners then demand compensation for having utilized the said land on coming to know their rights under the Land Acquisition Act of 2013, and therefore submit a representation to the respondents to consider their case and pass necessary orders in accordance with law. It is trite law that this state, if it has utilized the property of a private citizen, it ought to initiate process of acquisition or pay compensation for such utilization. In the light of the said circumstance, the respondent state shall consider the representation of the petitioners so submitted on 15/11/2021 and pass necessary orders in accordance with law within an outer limit of 12 weeks from the date of receipt of the copy of the order ordered accordingly.
Yes, please.
Next.
Highly obliged.
105, C.S. Shekhar.
Lords,
20th November.
Lords, this is a writ of mandamus, my lords.
ಹೌದಾ, ನಿಮ್ದು ಅದ ಕೊಡಿ. Comment.
We have made several representations at annexure AC.
For what, sir?
For consideration of the orders of respondent number 2.
ನೋಡ್ಲಿ ಅವರು. List the matter on 19th. AJ, ನೋಡ್ಕೊಂಬಿಡಿ. Yes, next.
106, Sharad V. Magdu.
I am for petitioner, my lord.
ಆಮೇಲೆ after that.
Writ,
You are for the petitioner. After that what?
writ of certiorari, my lord. Petitioner seeking impugned order, quashing the impugned order dated 24/9/24 on IA number 2, my lord, in criminal miscellaneous number 368 of 2023 on the file of first additional principal judge family court Belgavi, wide annexure F, my lord. Annexure F, my lord, entry maintenance 6,000 ಮಾಡಿದ್ದಾರೆ, my lord. ಈಗ ಆಲ್ರೆಡಿ ನಾವು 4,000 ಕೊಡ್ತಿದೀವಿ, my lord. ಪಿಟಿಷನರ್ ಡ್ರೈವರ್ ಇದಾರೆ, my lord. ಯಾವಾಗ ಅವ್ರಿಗೆ ಅವೈಲಬಿಲಿಟಿ ಸಿಗ್ತೈತಿ, ಡ್ರೈವಿಂಗ್ ಅದು ಹೋಗ್ತಾರ. ಸೊ 4,000 ಮಾಡಿದ್ನಪ್ಪ ಅಂದ್ರೆ ವಿಲ್ ಪೇ, my lord.
4,000 ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಈಗ?
ಆಲ್ರೆಡಿ ಕೊಡ್ತಿದೀವಿ, my lord, 4,000.
List the matter. List the matter after 4 weeks. Entry order subsisting will continue to the next date. Illicit counsel of the petitioner submits that in terms of the interim order, 4,000 is being paid to the respondent. The same shall continue to be paid, failing which the interim order would stand automatically vacated.
Much obliged.
Note 7, Madan Gowda and Patil.
Without conducting departmental inquiry, my lord, the petitioner was dismissed from the service, your lordship.
Which department, sir?
This is
Petitioner dismissed.
Please. Petitioner was dismissed from service, your lordship.
Without inquiry?
Without inquiry.
What contract employee?
Unauthorized absence.
Your contract employee, regular employees?
Regular employee.
Unauthorized absence, how many years?
Only for 119 days.
What?
19 days. And on another occasion,
Total 400,
total 400 days.
400 days.
Please.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
I'm working as Dalit, your lordship.
ಏನ್, what were you, physically disabled?
Disabled? No, no, my lord.
Accident?
No, no, my lord. He was suffering from some disease, my lord. For that reason, my lord.
Some disease?
Please, my lord.
Doctor,
due to that, my lord, you have produced certain documents with respect to that, your lordship.
Yes, madam. Legislative
Only
Assembly.
documents, your lordship, he has submitted saying that not proper documents he has submitted and not.
Page number
ಯಾವ ತರ
34, your
seal
lordship.
ಹೇಳಿ, ಯಾವ ಡಾಕ್ಟರ್ ಇಂದ ತಗೊಂಬಂದು ಕೊಡ್ತಾರೆ?
Lordship, the reason.
18th.
Please, your lordship.
Madam, make a note of all the service matters, read everything. Yes.
Please.
Note 8, MS Sarvi.
In writ of mandamus, my lord. Petitioner, my lord, was
Writ of
appointed.
mandamus.
Mandamus, my lord. Appointed by the respondent sugar factory as a assistant, my lord, mechanical.
Sugar factory.
Sugar factory, my lord. Served and unrepresented.
20, withheld 20% increment.
Please. But as on the date of appointment, the factory has assured the, my lord,
Learned
petitioner.
notice ಆಗಿದೆ first time.
Notice ಆಗಿದೆ. Served, they are.
Serve ಆಗಿದೆ.
Annexure H may be considered pass appropriate orders.
List the matter on Monday in fresh matters list.
Please.
Next.
Note 9, MB Hiremat. MB Hiremat.
20th.
110, Lingraj Mardi.
Same.
113, Balgowda A. Patil.
Tender matter list on 6th in fresh matters list.
114, Umesh Salma.
Yeah, the offense. First parole, second parole.
Last year, 24 had been granted.
List on ನೋಡ್ಕೊಳ್ಳಿ. List on Monday, fresh matters. Next.
115, HR Kambiyava.
For the petition, my lord, matter is arrived out of GST, my lord.
107.
One, ಇದು 107 ಅಲ್ಲ, my lord. First two matters 7310 barred by limitation 3 years ಒಳಗೆ ಮಾಡಬೇಕಾಗಿತ್ತು. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ. ಸರ್ಕ್ಯುಲರ್ 56.
The matter after 4 weeks. Next.
ಅಲ್ಲ, ಫಸ್ಟ್ ನೆಕ್ಸ್ಟ್ RS ಪಾಟೀಲ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆಲ್ಲ, ಅದು
ಪಾಟೀಲ್ ಯಾರು? ಅಡ್ವೊಕೇಟಾ?
ಇಲ್ಲ my lord, 115 ಒಳಗೆ ಕನೆಕ್ಟೆಡ್ 115(1) and 2.
ಕ್ಲೈಂಟ್ RS ಪಾಟೀಲ್ ನನಗೇನು ಗೊತ್ತಾಗ್ತದೆ? Yes.
ಅಲ್ಲ, ಇಟ್ ಈಸ್ ಕವರ್ಡ್ ಬೈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂದ್ರೆ
ಅಲ್ಲ, ಫಸ್ಟ್ ಟೂ ಮ್ಯಾಟರ್ ಡಿಲಿಂಕ್ ಆಗ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ 3 ಮ್ಯಾಟರ್ಸ್ ಡಿಲಿಂಕ್ ಆಗ್ಬೇಕು.
ಡಿಲಿಂಕ್ 115 and 115.1.
ಅದು
ಇನ್ ಮಿಕ್ಕಿದ 3 ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ.
ಇಟ್ ಈಸ್ ಕವರ್ಡ್ ಬೈ ರಾಯಲ್ಟಿ, my lord. covered by Supreme Court judgment. They have filed SO also.
Age you want to appear 10 days time.
ಇದ್ರಲ್ಲಿ ಏನಿದೆ? ಎಸ್
Supreme Court judgment.
ಅವ್ರಿಗೆ ಯಾಕೆ ಹೇಳ್ತೀರಿ? ಲಿಸ್ಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ. ಎಸ್
Please.
ಅವ್ರು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೇಕು, ನಾನು ಆಚೆ ಕರ್ಕೊಂಡು ಹೋಗಿ.
Allah, Supreme Court judgment is applicable.
116 Girish V. Bhatt. Appear Shri Nilopan.
Appear for respondent one, respondent number 3.
20th. Yes.
Next.
117 A. Sandrimani.
Writ of mandamus.
Appear for respondent. Already process has been initiated to acquire the land. But what had happened is, initially petitioner's land was notified in while joint measurement. However, no award was passed. Canal has been laid. Recently, my lords, we have initiated acquisition proceedings and submitted the proposal to the
Take it
special.
to its logical conclusion.
Plus, my lords?
You'll take it to its logical conclusion.
Yes, my lords.
ಮುಗಿಸ್ತೀರಾ ಅಂತ
ಮುಗಿಸ್ತೀವಿ, but state has to, my lords, special DC.
ರಮೇಶ್,
I get
get instruction. The legal notice mandamus baralla.
Yes.
The petitioner is before this court seeking a direction to consider the representation submitted by the petitioner. The learned counsel Chetan Manolli, representing the Karnataka Neeravari Nigam Limited, submits that the utilization of the land of the petitioner has allegedly taken place by laying a canal, by constructing a canal, and the acquisition proceedings, the process of acquisition has now commenced, and the proposal has been submitted to the state. It is for the state to take a call and now pass and take action in accordance with law. In the light of the said circumstance, without entering into the merit of the claim of the petitioner, I deem it appropriate to dispose the petition with a direction to the state to take expeditious steps with regard to the proposal sent by the Karnataka Neeravari Nigam, which has now initiated acquisition proceedings, initiated the process of acquisition of the lands of the petitioner, which had stood utilized long ago. The action shall be taken within 12 weeks from the date of receipt of the copy of the order, if not earlier ordered accordingly.
Vidyavati Amkapur Shekhar.
Silimar?
My lords. Yeah, I'm sorry, my lords. My apologies. 12 weeks will be too short, my lords.
6 months.
6 months. Please.
My lord, short it, my lord.
ನಿಮ್ದು ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್. ಎಸ್.
Unauthorized absent, your lordship, for 6 days.
25. List on November 25th at the request of the council appearing for the petitioner.
Srinivas Nayak.
Same 25th.
On 4th, my lord. 4th, urgency, disqualification matter, my lord.
Well, 4th, yes. List on 4th.
Interim order may be expected. Interim.
List the matter on 18th. Interim order subsisting will continue to the next date of hearing.
120. Ravi Chandra Gowda.
List on 25th November.
122. Ramchandra Mani.
Mandamus, my lord, seeking change in the name of the SLC march card, my lords. Only initial of name of the father has been wrongly, my lords. As per the circular, I have benefit of decree, my lords.
Interim order there. In benefit.
Mandamus, my lords.
List on 6th.
Short point, my lords.
Sorry, hearing. Yes.
Please.
123. Vipin Kulkarni.
In a domestic inquiry, I had sought for appointment of advocate. That was rejected, therefore I was before this.
ಯಾವ department?
Karnataka University.
What do the rules say?
Please, page number 61, which also specifies the employee for representing his case may take the assistance of any other employee of the university, where the university has appointed the legal practitioner to present the case on his behalf. The employee shall not be denied the right to be represented by the legal practitioner.
Illan legal practitioner alla.
Idhar, page number 50.
Who is the presenting officer?
Presenting officer.
Who is he?
One Mr.
Legal practitioner alla.
Okay.
One Mr. Chabbi.
ಏನು advocate?
Order impugned order itself says that page number 50 may continue. In fact, covered by my lord's judgment.
Totally. Yes.
Even criminal case is also filed and that is also
That's okay.
that similar set of facts.
Yes, Patil sir. Presenting officer idmel agoit. Nothing doing.
Monday, my lord, I verify whether he is adequate or not.
Completely covered in a judgment
Yes,
which
yes,
runs against also. Present dice.
In the impugned order itself, it has been specified that he is a
Kumar
presenting.
Nadkarni.
Page
Yes.
50.
My judgment ಇರ್ಬೇಕಲ್ಲ.
First page number 1.
ಇಲ್ಲೇ ಬರ್ದಿರೋದ? ಧಾರವಾಡ. ಇದೆ ಟಂಗ್ ಟೈಡ್ ತಾನೆ ಇದೆ.
ಹೌದು. Considering all the earlier judgment, Board of Trustees and the JK Agarwal also.
ರಮೇಶ್ ಚಂದ್ರ ಲೇಟೆಸ್ಟ್. ಇದಾದ್ಮೇಲೆ ಇನ್ನೂ ಒಂದೆರಡು ಇದಾವೆ.
Sorry.
Exagenarian cannot be left tongue tied.
Monday or Tuesday, my lord.
Covered.
Yes, sir. ಅಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಹೇಳ್ತಾರ, ಹೌದಲ್ಲ ವೆರಿಫೈ
Impugned order
ಮಾಡ್ತೀನಿ
ಇದೆ,
ಅಷ್ಟೇ.
page number 50 ಅಲ್ಲಿ ಇದೆ. There is observation in the impugned order itself.
50.
Please.
ಏನಿದೆ? Having heard the facts, circumstances of the case, memo of appearance filed by advocate SSF deserve to be rejected. ಏನಿದು?
ಅಲ್ಲ, what it says is that apart, admittedly, though the presenting officer is a law graduate, but he is not a practicing advocate.
ಅಂತ observation ಮಾಡ್ತಾರೆ.
That is what is it.
Yes, sir. ಮುಗಿಸ್ಬೋಣ. We'll take it as disposed. Allowed cost. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಎನ್ಕ್ವೈರಿ?
Inquiry at the initial stage. Initial stage. I have appeared and requested for document.
If allowed cost, the writ petition stands allowed, the impugned endorsement stands quashed, the petitioner shall be entitled to be defended by an advocate in the light of the fact that the presenting officer is a legal practitioner.
Not legal
is a law graduate, though
lawman
is not a law graduate, though is not is said to be not practicing as an advocate. Yes, so
please.
The inquiry shall continue after the petitioner being allowed to be defended by an advocate. Yes.
Obliged.
Ordered according.
24, commutation Harvey.
Yes, can leave it on Monday, my lords. Monday, my lords.
Yeah, ಏನು?
Can leave it on Monday.
ಯಾವುದು?
124, my lords.
PDS.
Yes. Objections already filed. Objections have been filed.
List on 20th. Next.
125, PG Chignarvan, Ita case.
The sort for mandamus that is found to consider the representation of lordships as an next EU lordships.
What representation?
In fact, not the petitioner, not the submitted the representation, requesting him to furnish certain documents to lordships pertaining to the appointment made in the respondent bank to lordships. In spite of direction issued by this honorable court, may have issued the endorsement stating that the documents sought by the petitioner are not specific to lordships. In fact, not.
Who are you?
I am the director, not one of the member of the not the bank to lordships.
What do you want from the bank?
In the respondent bank, they have made not illegal appointments to lordships without not obtaining the prior permission from the not the department to lordships. Therefore, I sought for the documents to lordships.
You are the participant in the recruitment process.
Not my lord. I am the
Then why do you want them?
I am one of the director of the not the bank to lordships.
So what?
There are no so many not the.
ಏನ್ ಮಾಡ್ತೀರಾ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ರೆ ಹೇಳಿ?
In fact, not the.
ಏನ್ ಮಾಡ್ತೀರಾ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ರೆ?
In fact, there
are
no
you a participant in the recruitment process?
There are no.
You will challenge the recruitment. ಯಾರ್ದೋ ಮೇಲೆ to develop an axe to grind against someone, you want these documents.
No, lord, I am the director of the bank to lordships. In fact, there are no lord the requirements.
ಯಾಕ್ ಬೇಕು? ಕಾರಣ ಯಾಕ್ ಬೇಕು ಹೇಳಿ?
There are no requirements of the new appointments to lordships.
ಅಯ್ಯೋ, ಕಾರಣ ಯಾಕ್ ಬೇಕು ಹೇಳಿ?
ನಮ್ಮ ರಿಲೇಷನ್ ದಾಗ ಅವರು ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ.
ಬೇಕು. Why do you want?
In fact, my brother's son was also applied for the not the.
Now the cat is out of the bag. Yes. ನಿಮ್ ಬ್ರದರ್ ಸನ್ಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಇದೇನು ಬೇಕಾಗಿಲ್ಲ.
ಇಲ್ಲ, but there are no requirements at all, lordship, for the new appointments, lordships. For that reason, I applied for the not the application seeking to furnish certain documents, lordships. This is the second round of.
Your brother's son should apply. ನೀವ್ ಯಾಕೆ ಅಪ್ಲೈ ಮಾಡ್ತೀರಾ?
I'm the director of the bank, lordships.
So, he is a participant, sir, in selection process.
One of the director of the bank. Therefore, I made application to not the.
Direction ಸರಿ ಇಲ್ಲ. Yes. List on.
First matter list ಅಲ್ಲಿ.
Dismiss ಮಾಡಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. List on Tuesday in fresh matters.
Please.
128, HR Kambiava.
ಇದಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ರಾ?
ಹೌದು.
Yes.
This is the second round of litigation. The petitioner, my lord, is manufacturer of stone crushers. Now, these stone crushers were being transported from Pune to Ballari. Back in 2015, these were stopped by the Road Transport Authority and characterized as construction equipment vehicles. Without passing a formal order, without hearing me, an endorsement is issued, tax is collected, and vehicles were not released until I paid the tax. I challenged those endorsements before this honorable court. If my lords kindly see the order passed by this honorable court, this honorable court basically set aside those endorsements, says you have not followed the procedure, refund the entire matter back. After 10 years, I got the refund back. Now, the contention taken before this honorable court is...
Now, why are you back to the court?
So, because it was sent back to the authority to follow the procedure, he issued notice. I say that these stone crushers are not motor vehicles, because motor vehicles are something that are mechanically propelled and something that are adaptable for use on roads. These can be used only in an enclosed premises.
Allah, they are not motor vehicles. Who said it is motor vehicle?
They are saying it is motor vehicle. That is,
motor vehicles are only those mechanically propelled vehicles which travel between point A to point B.
These are used in enclosed premises. And these are used in enclosed premises.
Correct. Well, motor vehicle. Motor irodella vehicle. Yes. ಅದಕ್ಕೆ ಏನು ಮಾಡಿದ್ದಾರೆ ಈಗ?
ಈಗ construction equipment and tirga they say, although it was argued before this honorable
court. You ply it on the road, is it? You ply it on the road?
No. They are in the mines or wherever the stone crushers is. They are so huge that they can't be plied on road. They can only be transported from one place to another. They are not mechanically propelled. And the definition of construction equipment vehicle under Rule 2 CAB of the Central Motor Vehicle Rule is, it has to be necessarily self-propelled for it to be a construction equipment
vehicle. There is no doubt about it.
This cannot be moved without a truck. Even if it has to be moved from one point to another,
it has to be on the truck.
It has to be pulled by a truck.
Pulled by, correct.
It cannot be loaded on a truck also, because this construction equipment vehicle has wheels. If my lord see the catalog, page 94.
Now what have they done?
They have treated it as construction equipment vehicle again and levied tax at 6% of the value of the stone crusher.
Intermodal ilva?
Intermodal illa.
Ilva?
Illa. After 10 years, I got the refund. Again, if it is collected, my lord, it will...
Heard the learned senior counsel T.S. Suryanarayan, T.R., right? T.S.
T. Suryanarayan.
T. Suryanarayan.
Yes.
T. Suryanarayan appearing for the petitioner. Initial confusion. Yes. The learned senior counsel takes this court through the documents appended to the petition to demonstrate the repeated folly of the state. The petitioner, the vehicle of the petitioner was once described as a motor vehicle and tax was levied. That was challenged and before this court in 103212 of 2016. The coordinate bench, in terms of its order dated 10th November 2023, disposed the said petition, directing refund of the amount of tax so collected. Adil finding kotra? Rendering a finding that the procedure for collection of tax against the vehicle of the petitioner was not followed.